25-04. For ease of reference, I'm going to refer to this as the Rocky Mountain Power's general rate case application, instead of reading the longer name. Just will note, we had last evening a public witness hearing, had a number of folks participate. We appreciated receiving that input. I think we had representatives from Rocky Mountain Power and the state, from the division and the office here, so you were able to, I'm sure, get a report on the comments that were received. We'll begin today with a question if there are any preliminary matters we need to consider before we resume the cross-examination of Ms. Koblia. Anything, counsel? Okay, doesn't appear.
I have one. I was just deferring to Mr. Sabin if he had one first. As a housekeeping matter, yesterday afternoon you had asked that we provide the engrossed version of UTLCG.
I think you meant the enrolled version.
Enrolled version, I'm sorry. Pardon. Just getting warmed up here.
Yeah, I understand.
The enrolled version of UTLCG cross exhibit number 10. And we have those 7 copies here available to provide to you all.
We'll just substitute that
Exactly.
for the exhibit. Let's go ahead, and if you've got those, let's circulate those.
And Chair Fenn, if I may, while those are being circulated.
Sure, please.
The division just needs to double check that the additional exhibit containing the footnotes from the relevant SEC reports is in its correct form. We have that with us, and we intend to distribute it quite soon.
Okay. When you're ready to do so, just let me know, and we'll do that.
Thank you.
Okay. Okay, thank you, Ms. King. Appreciate that. Were there any other preliminary matters? Seeing none, let's ask Ms. Koblia to return to the witness stand. You're an experienced witness, so you already know this, but I'll just state for the record that you remain under oath. Thank you. And I think we're ready for Ms. King to commence her cross-examination.
Thank you, Mr. Chair. And good morning, Ms. Koblia.
Good morning.
Again, I'm Michelle King. I'm here on behalf of the Utah Large Customer Group. And before we get going, I'd like to make sure that you have handy your direct and rebuttal testimony.
Yes.
Mr. Garrett's direct testimony.
Yes.
The cross-examination exhibits we admitted yesterday.
I might need to find them in the stack. I believe they are here, so
Okay.
yeah.
And then, as we discussed, have handy a calculator just for some very basic math.
Yes, okay. I have that.
Wonderful. So let's get started in a discussion about capital structure. In this proceeding, you recommend use of an imputed or hypothetical capital structure to calculate Rocky Mountain Power's revenue requirement, correct?
Yes, that's true.
And for our discussion, I'll use imputed and hypothetical interchangeably, okay?
Sure, no problem.
So let's start at, please, page 10 of your direct testimony. And I'll refer your attention to the discussion beginning at line 184 regarding the precedent for use of a hypothetical capital structure.
Yes, I'm there.
You're there? Yep. You ask whether the commission has ever approved a hypothetical capital structure in a rate case. Do you see that?
Yes.
And in the answer following, you present a single citation hearkening back to docket number 9903510, correct?
Yes.
And the 99 referenced in the docket number means that that case was filed in 1999, does it not?
Correct.
So 25 years ago.
Yes.
And the report and order referenced in your footnote, at note 7 there, at the bottom of the page, shows that that decision was issued May 24 of 2000, right?
Correct.
And you state at lines 188 to 190 that the company proposed a hypothetical capital derived from the average capitalization of comparable electric utilities used to develop its return on equity recommendation. Did I read that correctly?
Yes.
And do you know why the company proposed using a hypothetical capital structure in the 1999 proceeding?
I'd have to reread the specifics, but it was surrounding the situation that the company was in at the time and that it deemed to be most relevant rather than using its actuals, that a hypothetical was reasonable.
Okay, so is it fair to say that you're not sure, but it depends on the circumstances?
I'm not sure. What do you mean? I'm not sure. I suppose, as I noted, it was just facts surrounding the company at that time.
Okay, I think we're in agreement there. Are you aware that just 6 months prior to the May 24, 2000 report and order that you rely on in your testimony, that on November 23rd, 1999, the commission approved the merger between Scottish Power and Pacific Corp in docket number 98-203504?
Yes.
And I'll refer your attention to UTLCG cross exhibit number 4. Do you have that handy?
I'm assuming that's the merger.
Yes.
Yes. Mm-hmm.
And I'll refer your attention to what is marked at the top of the page as page 8.
All right, I'm there.
And I'll direct your attention to the header that reads financial issues.
All right.
And there, under the second sentence, it reads, applicants also agree that a hypothetical capital structure based on A-rated electric utilities comparable to Pacific Corp should be used to determine the correct cost of capital for rate-making purposes. Condition 19. Did I read that correctly?
Yes.
And so the use of a hypothetical capital structure was an agreed-upon condition of the merger, approved just 6 months before the decision you reference in your testimony. Do you agree?
That's what it says.
And so would you expect that at the time of the merger, the just merged companies didn't have an actual capital structure to use?
No, the company would have had a capital structure, but what it looked like could be, I'm sure, was different than the world today.
And so the company may have had a capital structure, but upon merging with Scottish Power, wouldn't that be in flux at that time of the merger?
I'm sure there was some variability and fluctuation happening at the merger just by virtue of it, being in a merger scenario.
Okay, and that's why they opted for a hypothetical capital structure.
Objection. That lacks foundation.
Sure, we've been discussing, Ms. Koblia, the fact of the merger approved 6 months prior to the decision upon which you reference in your testimony, right?
Yes?
And in your testimony, you refer to the 99 cases using a hypothetical capital structure. And we've discussed that 98 case also used a hypothetical capital structure, right?
That the merger transaction proposed a hypothetical capital structure.
And so
Yes.
we've been discussing that the fact of the actual capital structure may have been in flux at that time as a basis for why they used a hypothetical capital structure.
Objection. That's not what the witness said. Mr. Chair, she asked right at the beginning, do you understand or know why specifically a hypothetical capital structure was used? And Ms. Koblia said, no, I'd have to go back and review the documentation. So to suggest that the witness has agreed with her that that was the reason, misstates her testimony and lacks foundation, because she doesn't know, as she sits here, what the reasons were.
I'm gonna, before I rule on that, I'll give you a chance to, you look like you wanna
Thank you.
add some more.
I appreciate the opportunity to respond to Mr. Saban's objection. I believe that Ms. Koblia actually said that it would depend on the circumstances at the time.
Correct. But then you followed with a question saying, so the reason that this hypothetical was used was because of the merger. She did not say that. She said, I didn't know, and I haven't reviewed the underlying information.
Respectfully, Mr. Chair, I didn't hear her say, I didn't know and would have to read the terms of the merger. But if Ms. Koblia knows whether they had an actual capital structure at that time, I think is a fair question for the witness to address.
That's fine.
I agree,
You
I
can
agree
ask
with that. Let's let you ask that question. Also sustain the objection on your objection that it mischaracterizes her actual testimony, but you can continue your examination along the same lines, and if you need to phrase some questions, do so.
Thank you. We'll just button up this issue and move on. Ms. Koblia, would you expect that at the time of the merger, the just merged companies didn't have a reliable actual capital structure to use?
I get, at the time of the merger, because we have financial statements and the company did have financial statements, there would be a capital structure, there would be debt, and there would be equity. What it looked like, I don't have that in front of me, whether it was reliable. Clearly, there were some challenges with it, but I can't say specifically what those challenges were at this time.
Thanks. So let's move on from here and fast forward to some more recent cases. Let's please refer to UTLCG Cross Exhibit number 5. And prior to this current proceeding, the 2020 rate case was the most recent rate case before the commission, right?
Correct.
And you were with the company during the 2020 rate case
Yes, I was.
in the capacity of Vice President, Chief Financial Officer, and Treasurer for Pacific Corp, right?
Correct.
And let's turn to page 18 as marked on the bottom of this exhibit. And I'll have you review to yourself the testimony provided at lines 392 to 407, and just let me know when you've done so.
Yes, I'm aware of this and have read it again.
Thank you. And so you would agree that your recommended proposal in that case was to use the company's actual capital structure at March 31, 2020, and forecasted capital activity, including known and measurable changes through December 31, 2021, based on the 5-quarter end capital structures measured beginning at December 31, 2020, concluding December 31, 2021. That was your recommended proposal in that case, right?
Yeah, at the time of that rate case, the company was in a very stable financial position. The results of the wildfire hadn't really presented themselves, and hence I was in a different scenario at that time versus today.
Okay, and my question was really quite simple. That was your recommendation at that time, yes?
I thought I started with yes and then explained the differences.
And so the rate case before the 2020 rate case was the 2014 rate case in docket number 13-035-184. And that's UTLCG cross exhibit number 6. Do you have that handy?
Yes.
And we discussed it briefly yesterday, but you are aware that Bruce Williams was the Vice President and Treasurer of Pacific Corp in 2014?
Yes.
And so if you'll please turn to page 11, as marked on the bottom of this exhibit, and I'll refer your attention and have you just briefly read to yourself the testimony between lines 237 and 248, and let me know when you've done so.
Yes, okay.
And so would you agree with me, like, that just like you did in the 2020 rate case, in 2014, through Mr. Williams's testimony, Pacific Corp proposed using its actual capital structure, correct?
Yes, and as I noted before, the company is in a significantly different situation than even now, 10 years ago, as was in this docket.
And the company also based that actual capital structure on the average of 5 quarter-end capital structures, right?
Yes.
Okay, so the prior rate case to the 2014 rate case was the 2011 rate case in docket number 11-035-200, and that's UTLCG Cross Exhibit 7. Do you have that handy?
Yes.
And Bruce Williams was the Vice President and Treasurer of Pacific Corp in 2011.
Yes, he was.
And if you'll please turn to page 13, as marked on the bottom of Mr. Williams's testimony, I'll refer your attention to lines 284 to 291. And I'll ask you to please take a moment to review that to yourself and let me know when you've done so.
Yes, I'm done.
And so would you agree that just like you did in the 2020 case and the company did in the 2014 case, here in 2011 through Mr. Williams's testimony, Pacific Corp similarly proposed using an actual capital structure?
Yes, back in 2013, it made sense to use an actual capital structure.
And just to be clear, I'm asking about the 2011 rate case.
Oh, yes, I was referencing to the 12 months ended test period that was in the docket.
Okay, but in the 2011 rate case, it used an actual capital structure, correct?
Yes, at that time, it made sense.
And again, based on the average of 5 quarter-end capital structures, correct?
Correct.
Let's turn to the 2010 rate case, please. And so prior to, the company filed a rate case in 2010, docket number 10-035-124. And you can refer to UTLCG Cross Exhibit 8, please.
Yes.
Bruce Williams was the VP and Treasurer of Pacific Corp in 2010, right?
Yes.
And if we can please turn to page 12 of his testimony as marked on the bottom of the page, and I'll refer your attention to lines 259 to 266. And if you'll take a moment to just briefly review that to yourself and let me know when you've done so.
Yes.
And would you agree that just like you did in 2020 and the company did in 2014 and 11, in 2010, Pacific Corp proposed using its actual capital structure?
Yes, that is correct. Back in that time period, it made sense.
And again, based on the average of 5 quarter-end capital structures?
Yes.
And then last one, let's turn please to the 2009 rate case. Prior to the 2010 case, the company filed a rate case in docket number 09-035-23, and that's UTLCG Cross Exhibit number 9. Do you have that handy?
Yes, I do.
And Bruce Williams was the VP and Treasurer of Pacific Corp in 2009?
Yes.
And if we can please turn to page 5 of his testimony as marked on the bottom of the page there. I'll refer your attention to line 95 on page 9 and ask that you briefly read to yourself the testimony through page 6, line 119, and let me know when you've done that.
Correct, yes, I am.
And would you agree that like you did in 2020 and the company did in 2014, 2011, and 2010, in 2009, Pacific Corp proposed using its actual capital structure?
Yes, at that time it was reasonable and it made sense.
And again, that was based on the average of 5 quarter-end capital structures.
Yes.
And at the bottom of page 5, lines 105 to 106, Mr. Williams testifies that this is consistent with the methodology that was used in the company's most recent general rate case in docket number 0803538. Do you see that?
Yes, I do.
And so for at least the past 15 years, if not longer, the company has proposed use of its actual capital structure based on the average of the 5 quarter-end capital structures, right?
Yes, that is correct, based on the company's financial situation at those times.
Over the last 15 years.
Correct.
And now you seek a different direction. And so if you'll please turn to your direct testimony, page 3. Table 2, line 58. And let me know when you're there.
Yes, I'm there.
Okay. There, we see that the company's actual capital structure, dating back to December 31, 2018, spanning each year through December 31, 2023, right?
Yes.
And if we look at the line in that table for common equity, we see that in each of the 6 years, the 6 most recent years provided, the company's actual capital structure exceeded 50%, correct?
Correct.
Now, turning the page to your direct testimony, page 4, table 3, at line 70, we see that coincident with the company's proposed move away from its longtime proposal to use actual capital structure, the company's equity ratio is forecast to be 43.93% in 2024, correct?
Correct.
And 44.42% in 2025, correct?
Correct.
And it's your position that it was not until recent events related to the 2020 wildfires that the equity ratio dropped below 50%. Is that right?
It's both that and the sizable capital expenditure plan that I noted in the testimony were the drivers of the thinning of the equity.
Okay, and I'll just refer your attention to line 62, where it's we can start at line 61, but you say through 2022, the company managed to a capital structure near the authorized level, and it was not until the recent events related to the 2020 wildfires that the equity ratio dropped below the authorized level of 50%. Did I read that correctly?
And if you keep reading, as a result of the incremental wildfire liability accruals through 2023 and the settlements that were reached in 2023, coupled with the company's sizable capital expenditure plan. So yes, both those facts I've noted in my testimony as the drivers.
Okay, so we have a yes and, is that right?
Yes, and.
Okay, so you state that the company's access to the capital markets is challenged as a result of the risk associated with the wildfires. Is that right?
Yes.
And therefore, the company is seeking regulatory support that will provide the necessary financial support for its current credit ratings. Is that right?
Yes.
And you're generally aware that earlier this year, the Utah legislature passed legislation that created a wildfire fund?
That created the opportunity for a wildfire fund, yes.
Okay. And so if we can please refer to UTLCG Cross Exhibit number 10, which is an enrolled copy of Senate Bill 224. And I'll refer your attention to page 17 as marked on the bottom of the page. And direct your attention to lines 559 to 566.
Let me
And so I'll
find
pause to
let me
let
find
you
the
get there.
enrolled copy in the stack of papers. Sure. I'm sure it landed here somewhere. All right, we'll go with this one.
Okay. So if you would please
17,
refer to
sorry.
page 17. Thank you, Commissioner Harvey.
Yes, thank you.
page 17, and specifically lines 559 to 566.
Yes, I'm there.
And if you would just take a moment to review those lines and let me know when you've done so.
Yes, I'm there. Done.
And so focusing on line 564, are you aware that the commission shall approve a request to create a Utah Fire Fund if demonstrated to the commission's satisfaction that the fund, among other things, supports the financial health of the large-scale electric utility?
Yes, I see that.
And does the company consider that to be regulatory support that will provide the financial support for the company's current credit ratings?
If that fund is created, I would deem that to be regulatory support.
And so you're seeking here still more regulatory support from the commission, correct?
Yes, in my testimony, I talk about the capital structure and the level that, as we've noted from our rating agencies, they're seeking as a demonstration of regulatory support, which is a balanced outcome.
And the regulatory support from a fire fund, if approved, that would be funded by ratepayers, would it not?
That's my understanding, yes.
And if the commission provides the still more regulatory support in the form of your imputed capital structure, do you agree that that too would be funded by ratepayers?
Yes, the capital structure, basically the return, would be funded through rates.
And so let's shift gears slightly and discuss the wildfire liability accruals through 2020 and settlements that were reached in December 2023, which you say contributed to the company's significantly increased financial risk. Okay?
All right, yes.
You'd admit that a jury found the company to be grossly negligent, reckless, and willful in causing the Oregon 2020 Labor Day fires, correct?
There has been one case that has gone to court, which is the James case associated with, I believe, 4 fires in the state of Oregon where there was a gross negligence determination, but there has been no other determination associated with other fires that actually occurred on that Labor Day holiday in both Oregon and California.
And so, Ms. Koblia, in your response, in addressing the commission, you said that there was a ruling that that the company was grossly negligent. Is that right?
Yes, I said in the James case, there's been a ruling associated with gross negligence.
And are you aware that that case also ruled that the company was reckless in its behavior?
That sounds reasonable. I don't recall the specific words off the top of my head.
And are you aware that the jury also found that the company was willful in causing the Oregon wildfires?
That also sounds reasonable, and it's important to know, of course, that the company is appealing that verdict, and it's one case associated with fires in the state of Oregon.
And so there's still more cases that are pending, and we'll get into those, but there's still more cases that are pending, correct?
There are several fires that are being discussed, and their process of where they are in a court case is different. It varies.
Okay, so the company has entered into numerous settlements in resolution of the pending lawsuits related to the Oregon wildfires, correct?
We have entered into a number of settlements because as you look at that James verdict, in essence, it seems to have created a strict liability. So regardless of what the company actions were in any fire that's happened in this state, it appears that an Oregon jury is going to hold us strictly liable, regardless, I think, of the facts. And that's true in California as well. If you understand anything about the inverse condemnation requirements in California, there could be no order of negligence. However, the utility, if their assets are implicated, is deemed to be liable and will end up paying out on those. So rather than risking additional $1 to $5 million per plaintiff orders, we are settling at amounts that are significantly below that. If you look at some of the 8Ks that we filed around the fires, you'll see the average per settlement that we've reached in various other cases.
Just so that we can keep our record clear, I want to go back to the question that I asked. Which was the company has entered into numerous settlements in resolution of the pending lawsuits in the Oregon fires. Is that right?
To which I said yes and explained the additional detail.
Well, I also, in your explanation, you opined about a determination of strict liability. Is that right?
I noted what's happening associated with strict liability.
Okay, I have a copy of the James jury verdict with me, and so with your approval, permission to approach. You bet. All right, I just need one. Can I have one? Just the witness have one. I just want to make sure you have a copy.
Yes.
Oh, okay, thank you. So, Ms. Koblia, Mr. Jensen has placed before you a copy of the final verdict in the James versus Pacific Corp suit, case number 20 CV 33885. Do you see that before you?
Yes, thank you.
And do you recognize this as the jury verdict in the case that we've just been discussing?
Yes.
And I'll refer your attention, and you have familiarity with this verdict,
Yes,
correct?
I do.
Mr. Chair, I would move the admission of UTLCG Cross Exhibit 11, please.
Any objections to that? No objections will be received.
Thank you. Ms. Koblia, I'll refer your attention to page 4 of the document. And are you there?
Yes.
And do you see there that that poses the question to the jury of whether the defendant, Pacific Corp, was grossly negligent in causing the wildfires?
Yes.
And the answers are yes among the jury, correct?
Correct.
Okay. And so I'll refer your attention next to page 6. Are you there?
Yes.
And do you see there at question 7, the question is posed to the jury, was the defendant's conduct reckless as to the plaintiffs and the entire class based on the fires listed below? Do you see that?
Yes.
And the jury voted unanimously, or the jury voted yes.
Correct.
And then turning your attention next to page 7, question 8 poses, was the defendant Pacific Corp's conduct willful in causing the fires listed below? And the jury's verdict was yes. Do you see that?
Yes.
Now, if you want to take a moment to peruse the document that's before you and let me know if you see anything in here about strict liability. And if you don't, please so confirm.
Yeah, I'm not going to read through and look for strict liability, and my position around strict liability is what this has created. Looking at the law, there actually is a law in Oregon, and it's specifically around non-economic damages, but it seems to be disregarded, and hence that's what we're appealing. So I'm not a lawyer. It's definitely from my finance perspective that I'm getting the information, and hence it's created definitely a financial challenge for the company.
Ms. Copley, she didn't ask for your viewpoint from a legal perspective. She asked you to look at the document and see essentially if the words strict liability appear in the document. And I think you could take a few minutes or however long it takes, or if you're familiar with it and can answer the question now, or if you need to look at the document to be able to respond to the question that was asked, I think that that's appropriate.
Thank you, Mr. Chair.
There's nothing in here on strict liability.
Okay,
Thank you for doing that, Ms. Coblea.
thank you. And so the opinion that you proffered on strict liability, that is your opinion made as a non-lawyer, correct?
Correct.
Okay. So going back to our discussion about the settlements, you've agreed that the company has entered into numerous settlements, correct?
Yes.
And do you know how many individual settlements the company has entered into related to the Oregon wildfires? Is it 10, 20, 200, 500?
Not off the top of my head. I would need to go back and look again. It's been a couple. And when I talk about a couple, it's in groups of plaintiffs. So it hasn't been like individuals. So I don't know if you're referencing individuals or groups of settlements.
How many individual settlements? An order of magnitude is fine.
Individual, I'd have to divide between Oregon and California. Off the top of my head, I can't remember the split between Oregon and California because there's also California settlements.
Do you want to give an order of magnitude? Can you give an order of magnitude?
1,100.
11.
I think, but again, that's me trying to recall how many there have been.
And do you know the aggregate total of all jury verdicts against the company thus far?
Yeah, the jury verdicts are around, I believe, $200 million.
And do you know how much in total the company has thus far paid in settlements related to the Oregon wildfires?
I am not Oregon specifically, but across all settlements, I believe it's about $1.1 billion, somewhere in there.
Okay, 1.1 billion. And so for each and every one of the 1,100 or so settlements the company has entered into, didn't you, as Senior Vice President, Chief Financial Officer, and Treasurer for Pacific Corp, get a say in whether the company's balance sheet can withstand the settlement related to the Oregon wildfires?
That's an interesting question. So a say, can you clarify what you mean a say as in?
Were you consulted about whether the balance sheet could withstand the settlements contemplated?
I have been in many conversations around the verdicts and the outcomes and the settlements and the dollar amount, and have consulted with the CEO and the legal team around what that could mean to the financial statements.
So in your leadership role, you at least helped make the call that led to the accrual of those dollars in debt on the company's balance sheet, right?
Are you talking now the accrual or the settlements?
Well, both, actually.
Yeah, so there's a little bit difference of a nuance there. I've been involved. The accruals more so, just because that's a financial role. Settlements, that's definitely more up to the CEO and the legal counsel. But I am aware, and I'm in several of those conversations to discuss what is happening.
And so just then to clarify, in your leadership role, you helped make the call that led to the accrual of those dollars in debt on the company's balance sheet.
Yes, that's definitely an accounting determination that we work through with the CEO and the legal team.
And there are still pending lawsuits related to the Oregon wildfires, correct?
Yes.
And do you know how many claimants or potential claimants there are who have not resolved their claims with the company?
Not specifically. I think if you look at the James class, none of those claimants have resolved any outcome with the company. We have not paid anything nor settled anything, as I noticed that those are on appeal. I believe there have been like 1,500 mass complaints filed associated with the James case. The Archie Creek fire, which was another fire in Oregon, all of those individual plaintiffs have been settled. So there aren't any other remaining plaintiffs associated with the Archie Creek fire. And those are the fires in Oregon. Then there's California, but that's a different set of folks.
And so, do you know how many claimants there are who have not resolved their claims with the company?
Well, like I said, I believe, as we are aware, based on how many short form mass complaints have been filed in the James case, it's around 1,500
Okay.
individuals.
And most, if not all of which, will seek some form of monetary damage from the company. Is that your expectation?
That's what I understand is what is going to happen with this as we work through it.
And do you know how much is still sought?
And the filing, I believe, for each of the individual 1,500 folks is $5 million for economic damages and $25 million for non-economic damages. So I believe they've each filed a $30 million number per participant, plus I think there's other interest components that make that number larger. So that multiplied by, is that what you want me to do some math? Sure.
Is that 45 billion?
Yeah, it's somewhere in there.
Okay.
Yep.
Okay. And the company will have to assess whether to enter into still more settlements regarding these fires in Oregon, right?
Perhaps which fires in particular are you talking about in Oregon?
The Oregon wildfires that we've just been discussing that contribute to the 45 billion in expected claims to be filed.
Yeah, so that's the James class, which I noted we are appealing, and there will be continued conversations. There are 9 jury trials scheduled for this next year, and I believe mandated mediation, so we will see how that progresses.
And so the company will have to assess whether to enter into still more settlements regarding those fires, right?
There is mandated mediation, so that will be the conversation.
So yes.
I won't be involved in those, but I would assume yes, as mandated mediation means they'll be talking.
Okay, and so for each and every one of the remaining potential settlements to come, won't you, as Senior Vice President, Chief Financial Officer, and Treasurer for Pacific Corp, get a say in whether the company's balance sheet can withstand the settlement or accrual to come for the wildfires?
Yeah, as we discussed, I'll be involved in all those conversations.
Are you familiar with the economic term moral hazard?
No.
Oxford, I'll present it to you just for context. Oxford defines this as a lack of incentive to guard against risk, where one is protected from the consequences. Do you take issue with that definition from Oxford? Do you have reason to?
No.
Okay. And so, irrespective of that term, I'd just like to step through some of the details. We've discussed how the company acted in a grossly negligent, reckless, that a jury ruled that the company acted in a grossly negligent, reckless, and willful manner in causing the wildfires in Oregon, correct?
That's what the jury said.
And we've discussed how the company, and you in particular, gets a say in whether and how to pay hundreds of millions, if not billions, in damages to Oregon residents, with potentially more to come, right?
Yes, I'm involved in those conversations.
And we've discussed that the company's decisions have had an impact on its balance sheet, right?
Yes, the settlements have had an impact on the financial statements.
And as a result, the company now claims that it faces significant financial risk, correct?
That, coupled with our sizable capital expenditure plan, has created financial risk for the company.
And we've discussed that in the name of regulatory support, the company wants the commission to order that ratepayers pay for the hypothetical capital structure, despite also paying for a Utah Fire Fund if approved, correct?
At this point, as we know, the fire fund is not subject of this proceeding, and yes, the company, is seeking regulatory support in the form of a hypothetical capital structure to help with the financial stability of the company, so that we can move forward with the, reliability, safety investments that we are obligated and going to do.
And so isn't the company essentially having ratepayers shield it from the consequences of its actions?
I don't agree with that.
And if the commission provides the added regulatory support that you seek here, what incentive will the company have to strive to access capital at reasonable terms that it doesn't already have today?
When I think of, the incentive is that, we as a company are seeking to keep our rates as low as possible for customers and have access to capital and debt that is cost-effective and reasonable. As I noted yesterday, we're not in the business or not interested in being a price taker by having the further downgrade. So we are incented, and that is our mission, is to keep our rates low as possible for customers and have access to those debt markets.
And Ms. Coplia, isn't that the same incentive that you have right now?
Oh, absolutely, and it's continuing, and this is one of the key provisions to help us move forward and be in that space where we have access at reasonable cost.
And if the company rejects if the commission, rejects the company's proposed imputed capital structure, you're not saying that you can't or that you won't strive to provide safe and reliable service at reasonable rates, but just that it will be made more challenging. Is that right?
I think it's going to be more challenging and more costly, and that's what we're seeking to mitigate at this point, is the excess costs and the limits on our access that could happen to us, and the need to borrow. And when we need to borrow, it's not that we can typically put it off for years at a time. It's typically months, and so we're not wanting to be the price taker.
Okay. And so when you refer to it being more costly, are you referring to potential increases in the cost of debt?
Correct, in our credit spreads.
Okay, so let's get into that. If you would please turn, and you might have it open, your direct testimony, page 4.
Yes.
I'll refer your attention to lines 71 and 72. And
Okay.
there the result of these circumstances, and you're referring to the wildfire liability accruals and settlements in Oregon we just discussed, is that the company faces significant risk of a further credit ratings downgrade at its forecast capitalization. Is that right?
As we noted, it was both the wildfire liabilities and the sizable capital expenditure program that's creating the added risk.
Okay, so yes and, right?
Yes.
Okay. And then if we can please turn to your rebuttal testimony, and I'll refer your attention to page 6. Are you there?
Yes.
And specifically at lines 109 to 111, you state, if the company is ordered a capital structure with 44.43% equity, it will be challenged to achieve its credit metrics and could see a ratings downgrade. Did I read that correctly?
Yes.
The risk of a downgrade is speculative, isn't it?
The risk of the downgrade is my position regarding what I'm seeing associated with the credit metrics and their forecast if we have a challenging capital structure.
It may be your best estimate, but it's still speculative, correct?
Like I said, it's my position of what could occur.
Of what could occur. Okay.
Yes, sorry.
Are the Standard & Poor's and Moody's materials provided in your work papers, are those the only evidence of a risk of a downgrade that are in the record that the company has provided?
I suppose other than my comments in my testimony, then yeah, we have both the Moody's and S&P reports.
Okay. And without revealing anything confidential in those materials, can you confirm that there's nothing in those materials that expressly says, absent further regulatory support from the Utah Commission, Pacific Corp will be downgraded, correct?
There is a paragraph that discusses the regulatory support and that it is one of the positions that Moody's and S&P expects that the company will be able to achieve a balanced outcome in its various states that could help shore up the financial situation. So we'd have to, there's specific paragraphs, we can talk about the downgrade risk and the paragraph around the regulatory support if we'd like to kind of see those.
I don't want, and I don't intend to tread into anything confidential here. My question to you is simply, it doesn't say that a downgrade is inevitable unless the commission does X, right?
The downgrade scenario talks about various components. I don't believe the specific downgrade words say the regulatory support. It's later in the report that it talks about, seeking regulatory support from its commissions to support its ratings.
We don't know yet if the fact of a wildfire mitigation plan, as is pending in phase 3, and the potential creation of a fire fund might be enough to satisfy the rating agency's desire for regulatory support, correct?
I don't know if that's going to be enough. All I know is that there are words in the Moody's report that talks about support for a capital structure.
And even if you received the requested additional support from the commission and Utah ratepayers, there's no guarantee that the company won't be downgraded for some other reason, such as continued wildfire payouts, right?
The wildfire payouts definitely were a challenge and something that no one anticipated. So yeah, I can't confirm that there won't be other qualitative factors that could result in a downgrade. I can only look at the metrics and seek to have our credit metrics meet the criteria of both the rating agencies, which in that it talks about regulatory support.
And if we can now please turn, Ms. Koblia, to your direct testimony, page 5, line 83, table 4.
I'm there.
And there we see the current Moody's and S&P credit ratings and outlooks, right?
That's correct.
Moody's senior secured debt is an A2, and its issuer rating is a Baa1, outlook stable, correct?
Yes.
And S&P's senior secured debt is an A. Issuer rating is a BBB+, outlook negative, correct?
Yes.
And these are still a couple of notches above investment grade, correct?
Yes.
If, say, the company is downgraded by 1 notch, do you know how many basis points your cost of debt will increase as a result?
I do not know how much our debt would increase because that has many factors that come into play, in particular what's happening in the market, what our investors are seeing associated with the company, whether that be wildfire risk or our mitigation plans. So it's not something I can put my finger on as to what it would specifically mean in a quantitative perspective until we get there.
In this proceeding, you are concerned about the commission's decision, if it opted not to approve the requested imputed capital structure. You're concerned, you said earlier in your testimony that you were concerned that would be more costly, and that concerned the cost of debt. Do you have an order of magnitude estimate of how many basis points your cost of debt would increase?
As I just noted, I don't have a precise estimate of what that would mean. There could be comparisons to other lower rated utilities. That would be, again, somewhat speculative at this point. All I know is that we did see an increase in our cost of debt when we saw our last downgrade. Our credit spreads widened.
And so you don't know if your cost of debt would rise 10 basis points or 100 basis points?
As I noted, no, I can't give a precise estimate of what that would mean because there's many factors that come into play.
And you've not prepared any analysis in this record that walks through some of those potential variables, have you?
Which potential variables, I'm sorry?
The increases, various increases to the cost of debt. You said in your testimony that it depended on a number of different variables. You've not presented any empirical evidence in this record about what a rise in the cost of debt would mean.
I suppose the only specific evidence that I talked to was some history around the Great Recession on the top of page 6, where in a situation where a lower rated utility was unable to access the debt markets and paid significantly higher than the company actually paid for debt at the same time. So just trying to give the fact that there's scenarios and situations where, lower rated utilities are going to pay more, but I can't tell you today what that would look like.
And so if the cost of debt were to increase, that would apply to new debt issuances, which would then be incorporated into the company's embedded cost of debt, right?
Correct.
Okay. And then I trust, given your answers to the prior conversation, you don't know, but please confirm, order of magnitude, how much the embedded cost of debt stands to rise, how many basis points?
That would definitely depend on how much the issuance is, so I can't tell you specifically what that would mean without knowing, am I talking about $1 billion issuance at, 7%, whatever it is, that would all play into the math of our $13 billion of outstanding debt.
And do you agree it would take a pretty major event for the embedded cost of debt to rise 100 basis points?
It would definitely take a significant amount of debt, but at the same time, the other factor is maturities. So as other debt rolls off, that could also factor into the calculation. So it's hard for me to say a, quote, significant event. It would take some sizable debt to move that percentage, but other things will move at the same time.
And Ms. Koblia, can we please turn to your exhibit NLK1?
Sure.
And is the list of the debt that's provided, that says, series due July 2025, I believe that's column A?
Counselor, are you referring to the Moody's document?
No, it's
No.
Which one are you referring to? I'm sorry.
NLK1, it is Pacific Corp Electric Operations pro forma cost of long-term debt.
Okay, thank you.
Thanks. And so, Ms. Koblia, when you talked about debt rolling off or maturing, are those dates that are provided in column A the maturing dates that you're talking about?
correct.
Okay. And then as far as the embedded cost of debt is concerned, that's at the bottom of column M?
Yes.
Okay. And so all of the numbers that are in column M are the respective costs of debt for the issuances in column A.
Correct, yes.
And so if we were to see a swing in the embedded cost of debt of, say, 100 basis points, that would take a pretty major event and a pretty significant roll-off of maturing debt, most of which is not due to roll off until dates that are several years in the future.
Yes, or a sizable issuance.
Okay. Thanks. So the reason I asked about whether you've prepared any analysis in the record showing the impacts of increases in the cost of debt would have is that if, as the UTLCG and others recommend, the commission orders the use of the company's actual capital structure and the cost of equity recommendations in the range provided by the parties other than the company, even if the company is downgraded, it may still be cheaper for ratepayers if the weighted average cost of capital is lower. Are you tracking me?
I think I'm tracking you.
Okay, so let's step through that then. Currently, the company's authorized weighted average cost of capital from the 2020 rate case is 7.34. Is that right?
I would need someone to confirm that for me. I don't have that handy.
Okay, if you you permit me just one moment, please.
I think we're going to take a break right now. We've had a request to do that. We'll take, we'll be back here at 15 after the hour, and you can look whatever you need to look for, and will be appreciated by some if we take a break now. Okay? We'll be in
Absolutely.
recess for 15 minutes.
Thank you, Mr. Chair.
the cross-examination of Ms. Coblia. Ms. King.
Thank you, Mr. Chair. Ms. Coblia, before the break, we discussed the company's authorized weighted average cost of capital from the 2020 rate case is currently 7.34%. Is that right?
Yes, that's correct.
And if we turn, please, to your rebuttal testimony, page 12. Table 1.
I'm there.
We see that the company is seeking an increase to its weighted average cost of capital to 7.43%, correct?
Correct.
Now, holding all variables constant, the higher the weighted average cost of capital, the higher the revenue requirement, right?
Yes.
And if we can next please open Mr. Garrett, UTLCG's cost of capital witness, his testimony, and specifically to his exhibit DJG 16, which is the last of his exhibits.
Yes, I see that.
Okay. And there we see that if the UTLCG's recommendations are adopted, the company's WACC would be 6.8 WACC, weighted average cost of capital, thank you. The company's WACC would be 6.81%. Do you see that?
Yes, I do.
Now, I acknowledge that Mr. Garrett, in this round of testimony, used the cost of debt from your direct testimony and also your 2024 forecasted capital structure. Is that right?
It looks pretty close to that.
And if we adjusted his calculation to include the 4 basis point change in the cost of debt from your direct to your rebuttal case, and the company's projected 2025 capital structure to match the test period in this case, would you expect that to have a material impact on the resulting WACC?
Not at these levels.
Okay, and I'll submit to you that I performed the calculation using 2025's projected debt ratio of 55.57% at a cost of 5.21%, holding all else constant, but for the resulting equity ratio. And I get the same resulting weighted average cost of capital of 6.81%. Would you like to perform the calculation using those inputs, or would you accept my calculation subject to check?
I'll accept your subject to check.
And if we rerun that calculation using those same inputs, but changing the cost of debt to 6.21%, meaning a 100 basis point increase in the cost of debt to account for the risk of a downgrade. And I get that you didn't provide an estimate, but if we use a 6.1% for our cost of debt, I get a weighted average cost of capital of 7.35%, which is just 1 basis point above the company's current weighted average cost of capital, and still less than the weighted average cost of capital that the company seeks in this case. Now, would you like to perform those calculations to check my math, or would you accept my calculations subject to check?
I'll accept your calculation subject to check.
Thank you, Ms. Coblia. I have no further questions.
I think we asked everybody else if they had cross-examination questions. Did anybody else who had cross? Okay, Mr. Saban, do you have any redirect?
I do, thank you. Ms. Coblia, I'd like to draw your attention to the issue of wildfire liability that you were asked about extensively by counsel a few moments ago. The first question I want to ask you is the company seeking in this rate case to recover any of the wildfire liability costs that it is either paid out or anticipating that it will pay out through the test period?
None of those costs are in this case.
Why aren't they?
They've been excluded at this stage.
So, are you expecting customers to fund any portion of the company's payments on, whether it be through settlement or through, in response to any verdicts?
No, we're not expecting customers to fund any of those.
Does Pacific Core believe that it was, quote, at fault for the James fire?
No.
You mentioned earlier that the company is appealing that verdict. And you mentioned earlier that in a discussion with counsel about strict liability, that you viewed that in that way. Could you explain why you view it that way?
Yeah, as we see the outcome of the James verdict, and as we noted, the company does not agree with what has occurred in that case. It has really provided, I'll say, evidence, for lack of a better term, that if the company's assets are in any way implicated or near the origin of a wildfire, that the company will be brought to court by plaintiffs and it seems held liable in all circumstances. So to me, that's sort of a quasi-strict liability regardless of fault. And hence, the company has been pursuing settlements for other situations that are different than the fires that are in the James case because of that risk around those very large orders that we've seen for, in particular, non-economic damages to plaintiffs.
Do you know what action or inaction it was by the company that was deemed to be the source of your liability in the James case?
That the company did not turn off the power.
Do you know whether there was any determination that the company had failed to maintain its lines?
I'm not aware of any determination that the company failed to maintain its lines.
Do you know whether there was any finding by the jury or conclusion by the court that the company had failed to fulfill its obligations in any other way other than turning off the lines?
I'm not aware of any other determination.
Has the company in its history, prior to James, ever been held liable, to your knowledge, for just the failure to turn off an electrical line?
No.
In that respect, did the determination in the James case, was that surprising, or did it catch the company off guard?
It was absolutely surprising based on what, the verdict, and I think just other information about fires that were already burning in the state was very, concerning for the company as to what happened.
Was the company determined to have intentionally, in other words, that it meant to start the fire on its own?
No.
Okay. Counsel asked you earlier about potential settlements or potential liability that could flow in the future. You've had some settlements you've entered into that she asked you about, and you've got the James issue on appeal. Do you know how those future settlements or how future liability will play out?
No, I don't. As I noted, there's a lot of road ahead of us associated with, in particular, the 1,500 plaintiffs that I noted in the James case, and how that'll progress with appeals that the company is seeking.
So from your seat as CFO of the company, the uncertainty that of the future settlements, how do you factor that into what you are proposing here from a capital structure standpoint?
Yeah, at this point, I haven't factored in that uncertainty. I'm just looking at what exists today and the risk that we have associated with our financial stability and seeking a balanced outcome and support from the commission in that 50-50 cap structure.
If, in your estimate, for what you're looking at, the company does not get adequate support, what are the potential consequences the company could face?
As I've noted in testimony, I think there's definitely a concern about our credit rating and what that could mean to our access to capital, and then ultimately the cost of that capital and the debt that we need to issue so that we can pursue the investments in whether it's greening our system, the significant capital expenditures for that, wildfire mitigation plan, the work that we're doing to provide the safety on our system so that hopefully no type of event that occurred in Labor Day 2020 will happen again. That I think is key for us to move forward, and financial stability is going to be important for us to get there.
Council asked you a question, and I didn't write down the exact quote, but the question was it was words to the effect that, aren't you really just asking customers to pay for your liability or your wrongdoing? Do you recall that question?
Yes.
Is that what the company is here asking by virtue of the capital structure it's proposing?
I think at first, I don't agree that the company has made any mistakes, and no, we're not asking for the commission to approve payment of any sort of liabilities, as we noted. We're just definitely seeking some regulatory support for that capital structure so that we can have that, hopefully, financial stability to move forward.
All right, and then council showed you UTLC Exhibit 10, Cross Exhibit 10. Can you find that in your stack?
Which one was 10? Was that
It was the enrolled copy of the legislation.
I borrowed that one.
Oh,
Thank you. Thank
thank you, Commissioner. Appreciate it.
It's somewhere.
Has the commission, as of this date, approved yet a fire fund from which the company could draw for satisfaction of wildfire liability claims?
No.
And do you know,
Excuse me for just a second,
Sure.
Mr. Saban. I think it's probably good to, just for foundation, to note that the commission has not been asked to approve a fire fund.
I was just about to
I'm
explain
sorry,
that.
okay,
okay.
I wasn't sure, I just thought you were moving on. Thank you.
Nope. Do you know when this legislation on wildfire liability funding was passed?
Maybe. I'm trying to remember the
You
date.
don't,
The
it's
spring?
okay.
Oh, there it is. Look. Well, it takes effect May 1st, 2024.
Okay, so this is a brand-new law, correct?
Yes, correct.
Okay. Does the company intend to petition the commission for approval to create such a fund?
I would imagine so, but I'm not aware of any specific timing at this point.
Okay. Because as of today, that the commission has not yet ruled on the creation of a fund, do you know what that fund will look like?
No, I do not.
Do you know whether, in fact, it will be approved?
No, I do not.
Do you know how it will impact the company's financials at this point?
Not at this point.
Have you been able to factor in that potential future fund in the calculations you have done to come up with the company's proposed capital structure?
No, there's nothing included in my proposal.
Do you know whether a fund, if it is approved, would be the sole source for satisfaction of potential fire claims?
At this point, I'm understanding that there is a reasonable expectation that the company would have some level of insurance. So insurance would come first. That might be in the form of commercial insurance to the extent that it's still affordable, or self-insurance. I think Ms. Stewart had talked a little bit about that concept. So I believe there's many layers to that, with the fund perhaps sitting on top of it at the end of the day to help cover any future claims.
Thank you. Now, I want to switch topics for a moment. You've had multiple attorneys ask you questions about historically how the company has set its capital structure. Specifically, you've been shown a number of commission orders from 1999 through 2020 that discuss how the company has sought a capital structure in the past and what the commission has ruled. Do you remember that?
Yes.
So the first thing I'd like to have you explain, if you can, is why might it be appropriate in some cases to use an actual structure, and why might it in other cases be appropriate to use a hypothetical structure?
As I look back at the time period where Mr. Williams was the witness and what was happening with the company was in a very financially stable position. Our capital expenditures from 2010 to 2018 were $10 billion, averaging $1.1 billion a year, some years under $1 billion. These last 5 years, or from 2019 through 2023, our average capital expenditure per year is $2.6 billion. So we've significantly grown, and the situation is vastly different. So I think looking at actuals when we're in a very financially stable situation and our capital expenditures are lower is absolutely relevant. I think with that, with wildfires on top of it, we're in a different world than we were as we look back in time. And the higher capital expenditures necessitates additional debt, which I keep talking about these credit metrics. It ends up putting pressure on those metrics, which put us at risk for that further downgrade. In that same time period from 2010 to 2019, the metric I keep talking about was at 20%, and in 2023, it's in the low teens. So there's just sort of a vastly different set of circumstances that existed. So for me at this time, because we're in a little bit of an unstable position with all these factors, I believe a hypothetical capital structure will show that commission support and that we're on the path to financial stability at the company, and would be a great message for our rating agencies as we move forward.
And can you just remind the commission what capital structure you're proposing?
I'm proposing a 50% equity component of the capital structure.
Is that breakdown of 50-50 above or below the average of your peers?
If we look at the peers, the proxy group that you see in Ms. Bulkley's testimony, we are below the average, which I quote in my testimony as well, of the 52.5% equity component.
Now, in your book, I'm hoping you have this. Do you have Mr. Woolridge, or Dr. Woolridge, excuse me, his surrebuttal testimony?
Oh, I have his direct. I don't know if I have his.
It should be in that, the binder that is, I think, underneath the one that you're looking at there.
I need help finding it. Woolridge direct surrebuttal. Okay, I'm there.
You've got it?
Yes.
Would you turn to page 38 of his surrebuttal testimony and refer to table 7, please?
I'm there.
Could you please tell me what you understand that table to represent?
It's the updated cost of capital recommendation from Dr. Woolridge.
And what does he show as his recommended equity portion of that capital structure?
47.5%.
Okay, so do you,
47.5%.
so is it correct, is it your understanding that Dr. Woolridge is not supporting the company's actual equity percentage as part of its capital structure?
Right, he's neither supporting the actual or the hypothetical that the company proposed. So
in that regard, do you view that as let me ask it this way. Given that he is not recommending the actual structure, what can you conclude, if anything, from the fact that he's recommending something higher than that?
That he also doesn't agree that the actual structure in this situation makes sense.
Thank you. I'd like to now switch topics again. You were shown some documents yesterday that had to do with some dividend declarations the company had made during 3 years after 2020. Do you recall that?
Yes.
And to lead into that, I guess the first thing I'd like to know is, how does the company go about determining when it is appropriate and when it is not appropriate to make a dividend?
Yeah, I have in my direct testimony and in prior testimony the commentary about how the company determines its dividend, and it is truly looking at the weighted average equity component of the capital structure and how that compares to what is authorized in our states. And so on table 2 of my direct testimony there, in the 2020, 21, and 2022 time periods, the weighted average is right in line, and in some cases in excess of what was approved even after we paid those dividends. So that's what we're really doing, is we're managing that capital structure so that the equity is right around what we're allowed to earn on.
So maybe you could explain, how does the company through the dividend manage that equity percentage?
Right, yeah, so when we pay a dividend reduces the equity percentage because the money has left the company and it's no longer in the company's capital structure.
Okay. In that process, counsel from the office or the division, I don't remember which, was talking about the assessment of potential exposure at the time you make dividends. Could you explain to the commission, how does the company, before making a dividend, assess how much to reserve for potential liability?
Yeah, at the time of those dividends, it was impossible for the company to know what would come out of the James verdict, for example. And so we're assessing, all the facts and information that we have available at the time. I kept referencing the financial statement footnotes, which talks about the liability and our compliance with GAAP and needing to book things that are probable. So there was no way for me to predict that we would have this huge outstanding challenge that came from that verdict. So those dividends were paid, looking at our policy and our capital structure and what was reasonable to get our equity to the level that was authorized. And as soon as that verdict came out, we actually had another dividend that we were intending to pay in 2023, and we canceled that dividend as soon as the verdict came out because of the risk that was now put forth in front of us.
You've referenced the probability standard a couple of times. Would you please just briefly explain what you mean by that?
Yeah, so on our financial statements, in accordance with GAAP, if you have a liability, once it's probable and you can estimate that liability, you're supposed to record it. And so if you look at our financials, that's what we've done. We have a significant footnote that talks about what we determined to be probable and the amounts, and that, yes, it's reasonably possible that there's other liabilities out there, but we're unable to estimate it. That's all disclosed. And the legal proceedings section that was provided to us, the legal proceedings sections of the SEC documents is if anybody files a lawsuit that's over 10% of your current assets, you have to disclose it regardless of, even if it's of a frivolous nature. So that's where you end up seeing that very long laundry list of legal proceedings that we have now disclosed in our 2023 financials and continue to disclose. But it's not necessarily a direct connection to our liability that we accrue.
So when the company made the dividend or the dividends or declared the dividends that were declared in those 3 years, the company record on its books, to your knowledge, what it thought was the probable liability before determining the amount of the dividend?
Yeah, we had already recorded what was probable at the time we made those dividends, and it was then actually a number of months later after the jury verdict where we ended up having a significant increase to that liability in 2023. And as I noted, the dividends then ceased at that point.
And finally, you were asked yesterday about the use of operating company data versus holding company data. Do you recall those questions?
Yes.
First of all, do you know whether Ms. Bulkley assessed in her review of your proposed capital structure, whether she reviewed the operating company data, the holding company data, or both?
She's done both, depending on which portion of our analysis it's being used for.
And where did you get the information you cite to in your testimony for the operating company data? Where did that come from?
Yeah, it's specifically coming from Ms. Bulkley's exhibit. I think it's number 14, I'd have to look, which is associated with the operating companies that are comparable to Pacific Corp.
Okay, thank you. No further questions.
Thank you, Mr. Sabin. Is there any recross? Mr. Moore.
Hello.
Hello.
Ms. Colby. Do you remember yesterday when we had a long discussion and went round and round about whether to use holding companies of the proxy groups for the comparison for capital structure, or whether to use operating companies for the comparison for capital structure?
Yes.
Let's not do that again.
Thank you, Mr. Moore.
Agreed. Are we done then? Anything else?
Just real briefly, could you turn to page 28 of Dr. Woolridge's direct testimony?
Okay, I'm there.
Could you look at line 604?
All right, I'm there.
Now, Dr. Woolridge, as we talked about yesterday, takes the position that the holding companies should be used for the proxy comparison. And line 604 and 605, he represents that the common equity percentage for the Electric and Buckley proxy group holding companies are 40.9% and 40.6%, significantly below both the company's actual capital structure and below Professor Woolridge's proposed hypothetical capital structure. Isn't that true?
That's what these numbers would say, and I would ask that you discuss with Ms. Bulkley the specifics on the various schedules there. I don't know what these numbers represent.
The average common equity ratios for the Electric and Buckley proxy group. I'm done. Why don't we just stop there? Thank you very much.
Thank you, Mr. Moore. Appreciate that. Any other recross? Okay. Are the footnotes that you referred to yesterday going to come in with somebody else? I mean, you did raise those yesterday. I just wondered, you're not going to address that in with this witness, is that correct?
Could we, to make thank you. To better the record with this witness, we would like to pass those out now, if we may.
Okay, let's do that. I'll ask her. So, Ms. Schmidt, while we're having those distributed, is your intention to substitute what you've just provided us for DPU Cross Exhibit 3 that you submitted yesterday, or are we going to mark these as new exhibits?
I would like to propose that we mark these as new exhibits.
Okay, that's fine. So that would be, I think that's a DPU Cross Exhibit 6 and 7. Is that correct?
That is, thank you.
Yeah, which is which?
The packet of the 10K information would be DPU Cross 6, and the packet containing the 10Q information would be DPU Cross 7.
Okay, thank you.
I would like to move for their admission.
Okay, thank you. Is there any objection to the admission of DPU Cross Exhibit 6, the 2020 10K footnotes, and DPU Cross Exhibit 7, the 2024 Quarter 3 10Q?
First, just maybe a comment or question. The 2024 Quarter 3 Q10 is not footnotes. That is the 10Q. And it does.
I'm sorry, could you please repeat that?
The 2020, it's your DPU Cross Exhibit 7. I don't believe that is footnotes. And then Ms. Cobley could clarify that if you want, but I believe that's the 10Q without footnotes. The DPU Cross Exhibit 6 has one, or I guess 2 pages of footnotes, and I can't tell whether they're complete because, but again, Ms. Cobley could tell us, but I just want to be clear. I thought yesterday what we were going to be receiving was during those years where she was asking about dividends, that we were going to get the footnotes for each of those years, because because Ms. Coblia was saying that in those years, there was a footnote that explained why the company made the dividend in the amount it did and what the liability was it was considering.
Well, perhaps you misspoke with respect to whether the 10Q is a footnote or not.
I did.
Okay, but this is the document, the portion of the document that you referenced yesterday that you wanted submitted in evidence.
Yes, and since it was, I believe it was submitted in evidence yesterday, and so I don't believe I need to submit it again today, but if counsel for the company and the chair could help me keep track of that, I would appreciate it.
Well, just take a second.
I can explain what we have in front of us,
Yeah,
if you'd like.
yep, or you will ask Ms. Cobley if she can explain what she has in front of her before we make a ruling on her. You comfortable with that,
I'm
Mr.
totally
Saban?
comfortable with that.
All right, let's do that.
So I believe what we deemed was Exhibit 7 says it's the 2020 10K footnotes. Is that right? I might have gotten them backwards.
Seven was the 10Q.
Okay,
which is
so
not
then
footnotes.
6. Don't say that yet. So the 10K, this is the footnote that I was referring to in the 10K around commitments and contingencies, and it discloses the amount that Pacific Corp has accrued on the backside. So that's what I was seeking, so we can understand what was in the financials that linked to that legal proceedings. And then 7, yes, this does look like the September footnote that I was thinking of as well. And there's a table that discusses how much the accrual was at various time periods. So it is what I was hoping to see as part of that exhibit.
And can we conclude that that's a footnote because of page 75, the number 11 there? Would that be footnote 11?
Correct, yes. Footnote
Okay.
11 is the reference.
Okay,
Yes.
so both of these, Mr. Saban, appear to be footnotes
Yeah,
the
footnotes to
different
the
documents.
financial statements.
from the financial statements.
Yes.
That's fine. Is there an objection to us just, I'm happy to have from our side to submit the entire document so we have it. But if you don't want it, I just don't know how much we have and how much we don't, but.
Well, I have no objection, but I'll see what Ms. Schmidt has to say, whether we have the whole document in the record or not.
We do not have the whole record for any of the SEC filings in the record. I would be happy to submit them.
Well, let's ask Mr. Saban to submit them
I'm happy to.
since he's offered them.
Thank you. And
But absent further objection, I'm going to rule that the cross exhibit 6 and 7 will be admitted, and you can
That's fine.
supplement the record with the entire 10K and 10Q.
That's totally fine. Yep, no objection.
While we are doing this, may I be so bold as to ask the chair if we could ask Mr. Saban to submit the entire 2021 10K, 2022 10K, and 2020, I think we asked him to put the 2023 10K.
Can you lay a foundation of why you think those are necessary?
Yes, during our discussion yesterday, we talked about certain 10K provisions. During our discussion of the DPU exhibit, which took information from SEC filings for various years and then moved over to the side and referencing OCS 6.4, listed the dividends that were paid in those years. I believe that the entire SEC filings would help understand that exhibit. 4.6, thank you.
I have a suggestion that may simplify this.
Go ahead.
These are publicly filed documents.
Yes, they are.
Can we just take judicial notice of them and that way and have them admitted in that fashion? I'm perfectly happy with that. If the parties don't have to file anything and we don't have to weigh you down with a bunch of paper.
You know, I actually looked recently at the last 10Q that was filed. They're voluminous,
Yeah.
so I think that's a reasonable suggestion, Ms. Schmidt. Are you okay with that?
I am.
Okay, so ruled, we will not submit them as exhibits. We will use the exhibits that have been filed today, excerpts from those voluminous filings, and we'll take judicial notice that the filings with the SEC are available to anybody who seeks them, and we may review them in the course of the deliberations in this docket. Okay. Okay, Ms. Schmidt, back to you.
Could I have just one moment?
Turn it on.
The
You can
division-
have, do you need like a 2 or 3 minute break, or are you
No,
okay?
the division has nothing further, I believe.
Okay, great, all right. Any recross from UTLCG?
None, thank you.
Anybody else have any? Okay, all right, let's turn to the commission and see if we have any questions from the commissioners. Mr. Harvey.
Excuse me. I'd like to explore the ownership and the capital structure and a bit of these cash flows that have been talked about. So to begin with, how many shareholders does Pacificor have?
The Pacificorp is wholly owned by Berkshire Hathaway Energy, indirectly wholly owned. We have companies in between. So ultimately, I would say, Mr. Buffett is the ultimate shareholder.
And within that Berkshire Hathaway organization, the chain that gets from Mr. Buffett to Pacificor is what?
So if you want to know sort of the companies that stack
Yeah.
up, so we have Pacificorp, which its parent is PPW Holdings, which again is the holding company that has the goodwill associated with the acquisition of the company. That is owned by Berkshire Hathaway Energy, and then Berkshire Hathaway Energy is owned by Berkshire Hathaway, Inc.
Okay, thanks. You had mentioned in answer to a question a little bit ago that when Pacificor pays a dividend, that it reduces the equity portion of the capital debt ratio. Is that correct?
Correct, yeah.
Okay. That would be true for that same process of when cash goes out, reducing the equity portion would be true for any major outlay of cash?
Any major outlay of cash from the company, do you mean?
Mhm.
And no, the components that would impact the equity would be earnings from, ultimately from the customer collections and the authorized return, and then any reductions would be associated with dividends. So those are the only two things that would flow through equity. The other piece that then moves that equity number is the debt on the balance sheet. So the extent we need to borrow more, then your relative share of equity could decline if your borrowings go up.
Okay. So turning to the cash flows that you've mentioned in terms of all these settlements, what accounts, in general broad terms, don't need the number, but just kind of a description, are those coming out of?
So we would have recorded a liability on the books and then cash. Ultimately, cash, if we didn't have the cash from our ongoing operations, so the company would have ongoing cash from operations, again, which would be collection from customers or things like taxes that we receive, since we're taxed with our parent company, so inflows for taxes, all those pieces would determine if I needed to borrow to fund the settlement. So if I had enough cash from operations, then the settlements would have come out from cash from operations. If we didn't, it would have meant we would need to borrow either long-term or short-term debt to fund those payments.
So the payments are not coming from any other organization within the Berkshire Hathaway, trying to think of the right word,
Family.
but just family, that's a good word.
No, it would be all within Pacificorp and our finance structure that we have at Pacificorp.
And in the long run, does Pacificor have sources of income other than rate revenue?
No.
All right. So when you testified that Pacificor was not asking customers to pay for any of these settlements, you were limiting that to mean there wasn't a line item in a rate case.
Right, there's nothing seeking to collect that money today to ultimately fund those liabilities that we've paid. It's from the history, I'll call it, from the retained earnings or debt that we're issuing is where the funding is coming from.
But your answer a moment ago was that all of that eventually came from ratepayers.
Yes, that would have been the only source of cash to begin with that is still sitting with the company's financials.
And on a going forward basis, thinking just hypothetical worst case, when we talk about a $45 billion, assuming, I say hypothetical, that Pacificor loses that appeal, how would that be funded?
Bankruptcy.
Okay. So there isn't any expectation that further up the family would provide any of that?
Yeah, I don't know if you heard any of or saw any of the comments from Mr. Buffett at the shareholder meeting where, he's an investor, he's an investor in Pacificorp, and, the challenge of throwing good money after bad is, I think, top of mind for him, just like, me as an individual investor in a mutual fund, not necessarily inclined to put funds in somewhere that I'm going to lose it. And I think at this point, it's just $45 billion or, any large number would be beyond his ability to fund, and it would be a bankruptcy proceeding that would ensue.
Well, it wouldn't be beyond the ability, it would be on the willingness.
Agreed, yes. Okay. I'll agree with that.
So my point in asking that and asking for a confirmation here, in asking for a hypothetical capital structure, you're asking ratepayers to step forward and say, do something to, in a sense, save the company that the actual owner of the company has said he's not willing to do.
I think what the owner of the company is doing at this point is the suspension of the dividends. So there is no further cash, as we saw the list of dividends that has gone in the future. There is no further funding that's going back to the owner. So at this point, yeah, the only source of cash would be the support from the customers and that regulatory support to help us with our financial stability. In addition to, like I said, the lack of dividend and us moving around our capital expenditure. That's the other lever that the company is pulling, is seeking not to spend as much capital as we otherwise had budgeted.
But it would be a very simple way to raise the capital portion of the the equity portion of the equity debt ratio was just for Berkshire Hathaway to dump a few billion in.
If they were willing to do that, that would be a very simple way of tackling it, yes.
Okay. All right. You mentioned that, switching topics slightly, that there was a downgrade in the past and there had been a change in the costs of acquiring debt. Do you remember that from the earlier cross?
Sure, yes.
Do you remember what the change was?
In terms of the impact to our debt for the downgrade?
Yeah, the percentage increase in the cost of debt.
Yeah, and that's also one of those difficult to pinpoint situations. What I can say is, so the credit spreads are the measure of the difference between your treasuries and what it would cost the company to issue debt. So right before the jury verdict, our spreads were 155 basis points. Right after the jury verdict, it went up to 240 basis points. So that, I think, is 85 basis point gap. Had we issued debt right at that point in time, it would have cost us 85 basis points more than it did prior to the jury verdicts, which then a downgrade followed right after that. But then since then, our credit spreads have gradually declined as investors have gotten comfortable with the company. Mm-hmm. So when we issued debt, we tried to time it at the best possible moment. So it's hard for me to say, what would it have cost us if we didn't have the downgrade, just because of how the market dynamics move and investor sentiment. But that's what we're seeking, is to pick the right time and not have something else happening in the market that's causing, like a presidential election, or, you know, things that are causing chaos in treasuries. So that's why it's really difficult for me to say how much it actually cost. I can just say here's what happened to our spreads, and they're wider than they were pre-verdict and pre-downgrade.
But the largest difference is that 85 basis points?
That's the largest we saw on our debt.
Okay, thanks. And we appreciate you trying to get the best deal.
Oh, sure, yeah, thanks.
All right, in terms of whether a company funds additional capital resources, say transmission, generation, something like that, through debt or equity, maybe you can just give me some of the things that you consider when you're considering which of those two types of funding.
So the company doesn't specifically project finance any particular investment. So if you look at the Gateway South project that's subject to this case and that significant spend, it would have just been part of the overall capital structure that we're trying to balance at that 50-50 at the end of the day. So whether we had cash from operations that paid for it or borrowings, it's all kind of in a big pool with us trying to keep that 50-50 allocation. So you could almost argue every project is funded 50-50 debt and equity.
But when you're substantially below 50%,
yeah, I'd say right now, as you look at the forecast we have for 2024, then it's 56-44.
but like, I guess I'm wondering is your previous answer that there is simply no consideration of a pure equity investment?
Not on a project-by-project basis. If there was an equity investment, it would have been a larger conversation with the shareholder to say, hey, we need funds and we would love to have an equity contribution from the shareholder, which hasn't happened since the 2010 time period.
Okay. So you have referenced in previous answers the 13 billion current debt holdings, is that, or whatever the term is, I'm sorry?
Yeah, outstanding borrowings that we have, yeah.
Outstanding. And you've referenced a desire for an additional $7 billion in capital projects in the recent past and near future.
Are you referring to the rate base or the projects that have gone in service in between cases? I think that was Joelle's $7 billion reference.
I would like some clarification on what the 7 is, how it relates to the 13.
So I believe the 7, and I would want clarity, was the reference to how much rate base or new projects have gone in service in the recent past.
Okay, so that,
which
right.
it doesn't necessarily connect to my current cash and debt situation.
so it's already part of the 13.
It should be, yes, that we've already, anything that's in service, arguably we've already financed and have had to pay our suppliers and vendors for it. So it would have been part of that $13 billion debt position we have.
Okay. Would you agree with me that in general, debt financing has tax advantages for the company and indirectly for the ratepayers as compared to equity financing?
Yes.
Okay. So I'd like to discuss the justification for the hypothetical capital structure. I've looked at I think it's your direct testimony. You talk about your qualifications and your professional experience. What I see from that is an extensive experience in what I would call applied actual practice of finance, but the education itself is accounting primarily. Is that correct, or am I reading it wrong?
Yeah, I have an accounting degree. Mm-hmm.
Okay. In terms of the sort of theoretical basis for much of the current field of finance, there's a sort of a seminal paper that was written by Modigli and Miller. Are you familiar with that?
No. Mm-mm.
All right, then I'll skip that line.
Okay, sorry.
All right. So in the past, there was some discussion earlier about for Pacific Corp specifically about their capital structure in various cases that we went through. Excuse me, in terms of the commission, in terms of dealing with other utilities, the only other time that I can remember, and I could be corrected on this, dealt with our telephone companies, our rural telephone companies. And we ended up using a hypothetical capital structure because they were just way over equity, because they had just simply retained earnings and paid off debt, and they were getting the UUSF, so they were basically able to retain earnings and have essentially all equity.
Right.
And because of those tax advantages that we talked about, we said, well, they need some debt. Well, they need to be evaluated as if they had debt. So the main example I could think of was that we did a hypothetical because the actual just simply wasn't relevant. They weren't acting in the best interest of the ratepayers or the citizens of Utah. But that's a very different situation because there we were reducing the cost by that.
Sure.
You're asking to increase the rate of return by increasing the equity portion. At, as we said earlier, a time when the owner is not willing to actually match that. So why should I guess I'm just asking for the justification, why should ratepayers pay more than reality? And why do potential bondholders care more about something that's not reality?
So, okay, we're gonna have to break that down a little bit.
Yes,
Couple of pieces. So maybe if we first start with, the equity holder, as I noted, the suspension of dividends is the lever that the equity holder is interested in pursuing at this point. So that's all I'll say about that. That's their, I'll say, contribution towards this endeavor for our financial stability. The debt holders care about it and your relationship to our ability to pay our bills and the rating that ultimately comes up with an earnings that they're going to have and their willingness to support the company. So they care about that financial stability, which is linked to the credit rating agencies and how they view the company and its risk. And as I noted, that absolutely a downgrade, access to the market is going to get challenged, and will be challenging, and we'll end up perhaps paying more. I can't tell you exactly how much more that would be for those downgrades, but it's definitely a concern that we're trying to manage through. So big picture, the regulatory support and, I guess the importance of the financial stability of the company is what we're seeking with that 50-50 capital structure through, yes, I'll say, customers paying that through the order of a hypothetical capital structure. And to me, it's the importance of that stability so we can move forward and continue with the investments that we believe are important for maintaining containing the risk around wildfires or the greening of our system or safety and reliability that we're trying to seek as we move forward.
Okay, thank you.
Mr. Clark, do you have any questions?
Thanks. I have just a few as well. I'm going to be focused on Exhibit 4.6, just because I want the record to be clear about what this means. The question that is recorded in the exhibit addresses cash dividend payments made to Berkshire Hathaway Energy Company by Pacific Corp DBA Rocky Mountain Power Company, and then cash equity infusions in the opposite direction. Mm-hmm. The second question isn't explicitly answered, but you've answered it, that there haven't been any infusions in the time frame covered by the question, right? 2022 to 2024.
Correct.
And just to be clear, these are dividends not paid somehow by Rocky Mountain Power, but by Pacific Corp as an entity of which one of the divisions is Rocky Mountain Power, and there are other operating entities within the Pacific Corp Group, is that right?
Yeah, the only legal entity that exists is Pacific Corp. Rocky Mountain Power and Pac Power, just divisions, of course, operate in the various states.
But the dividends are coming from the combined entity?
Yes, the consolidated.
Okay, thank you. And then just to, you've talked about some awfully large numbers. If we were looking at the current book value of long-term debt and the book value of common equity in relationship to each other, can you estimate for me how much additional equity would be required to achieve an actual capital structure of 50-50?
That's a good question. I would need to do some math.
And I don't,
Yeah.
within $100 million even. I mean, I don't need to be too precise about this, but we have this record of the, in another exhibit, I think it's, well, it's really both of them, but Exhibit 5 that sort of totals the dividends that have been paid in this relevant
Yeah.
period at $550 million. And so I'm trying to relate that number to the number required for a 50-50 actual capital structure.
Yeah, and so maybe if I did a calculation at one point for my own information on that 300 million dividend, that the weighted average equity that I show on my table 2 for the end of 2023 of 50.4%, if we wouldn't have paid that 300 million dividend, the equity would have been 51%. So it's not, getting us, but then now I've got this, so we can say, I hate to say that, 300 million worth 1%. I hate to say that. That puts us at like $1.5 billion if I multiply that by 5. I feel like the number should be a little bit larger than that, but I'll stick with that. It's going to be in I think the $1 billion range would be my rough math.
Yeah. Yeah. Thank you.
Sure, yeah.
Ms. Copley, just a couple of questions. When was Pacific Corp last downgraded by Moody's or Standard & Poor's?
So the last action was an upgrade from Moody's in 2014, which brought us to the grade that we were until the downgrade, and S&P had upgraded us in 2016. So in 14 and 16, they both upgraded us 1 notch, and then now we've subsequently come down that 1 notch here in this 2023 time period.
And when was that? Do you know a date when the downgrade happened for those
I have a
rating agencies?
schedule that was a subject to the data request. If you can give me a second to flip through my book
That would be appreciated.
real fast. If I can remember, where did I put that? All right, so on January 30th of 2014, Moody's had upgraded us from a Baa1 to an A3 rating. And that's the long-term issuer rating, so not our senior secured debt, but the issuer rating. And then S&P on February 19th of 2016 had upgraded us from A- to A. And S&P is a little bit different because it's a family rating, so it isn't necessarily just Pacific Corp that influences that rating.
Okay, thank you. And when were you downgraded? That's
Yep, so that we were downgraded on November 21st of 2023, Moody's downgraded us to the Baa1. And S&P on June 20th of 2023 downgraded us to the BBB+.
Okay. Now, as I understand it, Moody's has issued their last report on December 4th.
Yes,
Is that
hot off
correct?
the press, yes.
Hot off the press. And in 2024, your actual capital structure was 43.93%. Is that correct?
The forecasts for 2024, we're not quite done with the year yet,
Okay.
but yeah, it's going to look to be
But-
that 43 to 44,
Okay.
correct?
No downgrade was received by the company from either Moody's or Standard & Poor's in 2024, is that correct?
Correct. Moody's maintained their ratings that they had issued last year, and S&P hasn't issued anything recently that I recall. I'm trying to remember the last time that they've done a report on us. Typically, we get a report every year from both agencies.
So you've been able to maintain your current credit rating this year with forecasted capital structure of, by the end of the year, 43.93%.
Yeah, they typically look at the 12 months lagging. So at this point, they have probably reflected most of that, and they can see the risk, but they aren't yet downgrading us.
And you project the forecasted rate, actual rate in 2024 at 44.42%.
Yeah, it's somewhere in there.
Okay. And I guess what I'm trying to understand is if you've been able to maintain those credit ratings from Moody's and Standard & Poor's with an actual credit or actual capital structure below 50%, whether the risk of a downgrade is really tied more to wildfire risk than to your current capital structure.
I think it's going to be tied to the wildfire risk and then the credit metrics. If I look at the recent Moody's report, they do quote that they're waiting to see the outcome of all these rate cases that we have pending. And it does note, that the company is working with the commission for regulatory support and a capital structure that could potentially exclude the wildfire liabilities, is how they put it. So they're waiting to see what's going to happen in all these cases.
And it's your understanding that other factors weigh into ratings by Moody's and Standard & Poor's than just capital structure or ROE?
Yeah, there's qualitative and quantitative factors. The big qualitative that we saw happen was the wildfire liabilities, which actually ended up being a quantitative impact too on our metrics. But all those factors, several of them come into play.
So by your reference that it was hot off the press, I'm assuming that you've reviewed the Moody's report from December 4th.
Yep.
Did they take a positive view of the actions of the Utah legislature in passing SB 224?
I'm trying to recall if the reports specifically said it, but I've been in conversations with both Moody's and S&P, and they have viewed that legislation as favorable. And so now it's just a matter of how ultimately might it impact the financial statements and what other regulatory support we might see from all of our states.
Yeah, I want to be careful is the December 4th Moody's report a confidential document, or is that publicly available?
Yeah, so unless you have a subscription to Moody's or S&P, I don't believe you can
It's
generally
confidential.
access it. Yeah.
Okay.
So
Well,
it's
then-
a little tricky. Yeah.
All right, well, then I'm not going to ask the question about what's stated specifically in the document, but you've had conversations with Moody's with respect to the impact of the Utah legislative environment when it comes to being supportive of the company and having a positive impact. You believe Moody's views that as having a positive impact?
I think both of them, the potential for the fund has likened it to what they saw in California. It's a little bit different situation in how California was structured and set up and where the money came from. But having access to a fund for future potential wildfire liabilities is seen as a credit positive.
Okay. You also, in your direct testimony, talked about that your request for a hypothetical capital structure is a departure from historical practice. And then you gave examples of a FERC case. You talked about Washington, Alaska, and Louisiana. Are you aware of other state commissions that have used a hypothetical capital structure in a regulatory environment?
If I look at the state of Oregon, Oregon actually has the last case for us. We ended up with a 50-50 hypothetical capital structure. It wasn't based on our actuals. And then we have a pending case where that decision has not been made. So I'm talking about the prior case that we had in Oregon. We were already at that 50-50 level with the view that, there's years that you're above that and there's years that you're below that.
And when was the case in Oregon? What was your actual capital structure at the time we received a 50-50 allocation
So it
between
would-
capital and debt, common stock and debt?
So I'll need one of my friends to remind me of the actual Oregon last rate case
Just
timing.
approximately.
I think it's in the 52% range, that 2021, but then the data that's subject to the case right now is the same test period, 2025 test period. They're like,
I believe the order is December of 2022,
thank you.
Mr. Chair.
Okay, all right, thank you.
So we would have been in that 52 to 53% actual type position.
So you had actual capital structure that was higher than the 50-50 hypothetical that they gave you, is that correct?
Correct, yeah.
So they lowered your capital structure?
They did, and in this case, we're in the opposite situation where, just like you, they've seen this projected table that shows 24 and 25, and we're awaiting the order, but I know staff's position, for example, was still to do the 50-50 as we've had in the past in Oregon.
Okay, that's a pending matter, had
Exactly,
no
yeah.
decision?
Yeah,
Okay.
yeah, we should be any day now in Oregon. Yeah, in December.
Okay. But I'm just curious, at the time you filed your direct testimony, I see three references. Actually, Washington is a statement of philosophical basis on which a hypothetical capital structure. Are you aware of any actual case in Washington where they use the hypothetical capital structure?
Not off the top of my head. I think that's where all those examples were to show that there have been situations where this has occurred. None of them are exactly like the company scenario.
Sure, and,
Yeah.
and I think that was what I was trying to
Yeah.
understand, because Alaska, over time,
Yeah.
went from 4.5% to 40%.
Correct.
And Louisiana went from 35% to 40.4%.
Yep.
All of which are lower than your actual capital structure now. So
Right.
I'm just trying to find out if I assume you would have had cause to have someone in research as to whether there were other examples
Yeah,
of
and
hypothetical capital structures.
right, and these were the only ones that we ended up putting in there as the examples. Whether there are more, I don't recall right now off the top of my head. Yeah.
Okay, so you would agree that would be a rare occurrence historically where that's been.
Yeah, I'd say there are occurrences, but to the count, yeah, you could argue a handful out of several proceedings could be deemed to be rare.
Okay,
Mhm.
all right. And has Berkshire Hathaway ever made, I'm not sure I got this clear, have they ever made an infusion of capital into Pacific Corp?
Yeah, for the first, I believe it was 5 years after the merger, so from 2006 to 2010, we had equity infusions. I want to say the total was around $1 billion. I'd have to go back and look, but it was part of, I think, the initial merger commitments, and we were also in a big capital build cycle for new wind at that time. So there was a driver for it to help fund those investments that we were putting on the system.
And so they've made a concession, or they've agreed, Berkshire Hathaway, to not require dividends from Pacific Corp for several years in the
Correct.
future, which will have a positive impact upon your capital structure.
Correct.
All things,
Yeah.
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 Yeah, we got the wildfire issue, I understand.
Yes.
But just to make sure I'm clear that the delta between 44.42% capital structure, and what you're proposing at 50%. Do we know what dollar amount that would be, assuming that you get your entire revenue requirement and keep the same ROE, that nothing is eliminated from the case by the commission, that your request is positively received? What would be the impact? Do you know the delta between of what you would need?
So you're talking about the dollar impact and the
Dollar
revenue
impact
requirement.
of the revenue requirement.
I will point that to Shelley McCoy, who's the revenue requirement witness. I think she could help assist with more of those calcs.
Okay, we'll try
Yeah.
to remember to ask that to
Yeah,
Ms.
right.
McCoy. Okay. I have no further questions. Yes, yes, go ahead.
If I might follow with just
Sure.
one question, I appreciate it, Mr. Chair. Ms. Koblia, when Chair Fenn was questioning you regarding the states that you cite to for precedent of a use of a hypothetical capital structure, relative to your testimony, today you added Oregon to the list, is that right?
Just right now I did, yes.
And is it correct that in that Oregon rate case, that 50-50 hypothetical capital structure was the result of a negotiated stipulation entered into by the company that might have been considered among various other compromises in the stipulation?
Yes, it was.
Thank you very much.
Thank you. I appreciate that clarification. All right, there are no other questions, Ms. Koblia. We'll ask you to be excused. Thank you so
Thank you.
much for your patience and allowing us to go through this for nearly an entire day when you add it all up. So, thank you. Mr. Saban, do you want to proceed with the start of your next witness now, or would you like to do the lunch break now?
I think we should, I just am worried about time, how much it will push us into next week, so I would advise we go forward, but
No, I'm happy to do that. I'm
Yeah.
just trying to see what you prefer, and
that's fine.
it's your witness, and we won't obviously get finished before we break for lunch. All right, would you call your next witness, please?
Sure. The company calls Ann Bulkley to the stand.
Ms. Bulkley, thank you. Would you please raise your right arm to the square? Ms. Bulkley, do you swear that the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. You may be seated. Turn to Mr. Saban for direct.
Ms. Bulkley, could you please state your full name for the record?
Ann Bulkley.
You're welcome to pull that closer to you so you don't have to lean forward. There you go. Ms. Bulkley, could you please identify for the commission where you're employed and what your position is with that company?
Yes, I'm employed by the Brattle Group as a principal.
And what is it you do as a principal for the Brattle Group?
My work primarily involves around economic and financial matters related to regulated utility companies, includes the preparation of cost of capital as well as other valuation matters, particularly focused on the energy and regulated utility industry.
Ms. Bulkley, have you caused to be filed in this case direct, rebuttal, and surrebuttal testimony along with exhibits marked AEB-1 through AEB-13 and then AEB-1R through AEB-18R?
Yes.
Did you prepare that testimony yourself?
Yes, it's prepared by me and under my direction.
Okay. Are there any corrections to that testimony?
I have one correction in my rebuttal testimony.
Okay, why don't you share that with us?
This is at page 124 of my rebuttal testimony at line 2485. I should insert the word correctly after witnesses.
Okay, thank you. Any other corrections?
Not that I'm aware of.
Okay, if we were to ask you the same questions in your direct rebuttal and surrebuttal testimonies, would you provide the same answers if you were asked those today?
Yes, I would.
Mr. Chair, I move for the admission of Ms. Bulkley's direct rebuttal and surrebuttal testimonies together with exhibits AEB-1 through AEB-13 and AEB-1R through AEB-18R.
Okay, thank you. Are there any objections to the admission of any of the testimony or exhibits? Seeing none, they're admitted.
Thank you. Ms. Bulkley, your direct rebuttal and surrebuttal testimony is lengthy. Have you prepared a summary of that testimony for the commission and the other parties?
Yes, I have.
Would you proceed to share that with us?
Sure. Chairman Fenn, Commissioner Clark, and Commissioner Harvey, thank you for the opportunity to provide you with a summary of my direct rebuttal and surrebuttal testimonies in this proceeding. Throughout the summary, I will be referring to several charts that are included in my testimony. It might be helpful when listening to review those as I go along. My testimony addresses the appropriate return on equity and capital structure for Rocky Mountain Power. My direct and rebuttal testimonies consider many factors in the development of the current cost of equity range that was considered for Rocky Mountain Power's requested ROE. Those factors include changes in capital market conditions since the company's last rate proceeding, credit and equity analyst expectations and comments on the regulated utilities industry, the results of analytical models that were developed to estimate the cost of equity, recently authorized ROEs, and business risk factors that are unique to Rocky Mountain Power in this jurisdiction as compared with the proxy companies. Turning first to capital market conditions. As noted in my testimony, it's important to consider the changes in capital market conditions since the Commission authorized an ROE of 9.65% in the company's last rate proceeding in December 2020. As those changes demonstrate that financial pressures under which the company operates are less, not more favorable, justifying an increased ROE, even though the company is only asking for the Commission to maintain its current ROE of 9.65%. I will briefly review these market changes. As shown in Figure 2 of my rebuttal testimony on page 7, give everybody a second to get there. The yield on the 30-year Treasury bond increased approximately 273 basis points, and core inflation increased 170 basis points from the time I filed my testimony in my rebuttal evidence in the company's 2020 rate proceeding to the time that I filed my rebuttal testimony in this proceeding at the end of September 2024. Further, while Mr. Coleman suggests in his surrebuttal testimony incorrectly that market conditions have improved since the company's last case, and that this demonstrates that the cost of equity should be decreasing, his analysis does not demonstrate that the conditions he discusses are unique to Utah. Mr. Coleman doesn't explain that if market conditions improved as he claimed, why has there been an increase in the average authorized ROEs for vertically integrated electric utilities across state jurisdictions since the company's last case? While I recognize that the Federal Reserve reduced the federal funds rate in September by 50 basis points and in November by 25 basis points, I note that the yield on the 30-year Treasury bond remains significantly higher than in July 2020, which is the vintage of the data that was used in my analyses in the company's 2020 proceeding. This market data demonstrates that the cost of equity remains significantly higher than when the Commission authorized a 9.65% ROE in the company's last proceeding. Despite this market data, which demonstrates higher overall cost of equity and would support a higher ROE, the company is requesting no change in its authorized ROE in recognition of the extraordinary inflation that has affected customers over the period between these cases. Turning to credit metrics, I've considered the changes in how the rating agencies have viewed the industry overall and Pacificor in particular. as discussed in my direct testimony, the rating agencies have identified large capital investment plans related to decarbonization, the replacement of aging infrastructure, as placing significant strain on the credit metrics of utilities, resulting in a decline in the median credit metrics for the sector from A- to BBB+. Further, credit rating agencies have noted that without regulatory support, including thicker equity ratios, the increased debt financing of capital expenditures will place further strain on these credit metrics, making them cautious about the durability of the current metrics for the industry. The conclusion from this evaluation is that regulatory support is essential for utilities generally, and Pacificor specifically, at this time. It's important to understand what is meant when we talk about regulatory support. From a credit rating agency perspective, it's clear that regulatory supportiveness is evaluated based on the effects of regulatory policy on key credit metrics. Therefore, regulation that works to improve cash flow metrics through the recovery of costs and the recognition of risk is important to maintain financial integrity. Key examples of such policies include the maintenance of the cost recovery mechanisms like the EBA, recovery of insurance and wildfire mitigation costs, and the timely recovery of capital investments. In addition to capital market conditions and credit concerns, I provided the Commission with the results of many analytical models that estimate the range of the cost of equity. Those models include the discounted cash flow model, capital asset pricing model, and empirical capital asset pricing model, and the bond yield risk premium. Figure 1 on page 5 of my direct testimony summarizes the results of those analytical models that I relied on. As shown in that figure, the overlapping range of the results from all of the models was between 10.25% and 11.25%. Sorry.
Excuse me, Ms. Bulkley, I didn't get the page number.
Sure, page 5 of my direct
Okay.
testimony.
Okay,
Figure 1.
thank you. Go ahead.
The overlapping range of results from the models shown in Figure 1 are between 10.25% and 11.25%. However, despite that range, the company is requesting an ROE of 9.65%, which is at the very low end of the model results. I updated the results of these models in my rebuttal testimony. Looking at Figure 5 of my rebuttal, I'm looking at your book and hoping that the book you just put down isn't the one you need to pick back up again.
I should use it on my computer, I know, but I thought it would be faster to
Sorry.
do it this way, but
I think you might need the other book again. I apologize.
no problem. All right, thank you for indulging me. Okay,
So-
what page
So
in your
page
rebuttal?
20 of my rebuttal testimony, Figure 5, shows the results of my updated model results. Sorry for the curveball there.
No, not a problem.
Those results demonstrate that the median DCF result ranged from 9.7. Oh, I'm so sorry. The median DCF results ranged from 9.75% to 11.06%, with 9.75 being the lowest projected EPS growth rates used in the models and 11.06 being the high end of that range. Further, the CAPM and the eCAPM, as well as the risk premium model, all reflect results that are significantly higher than the company's request. There have been many viewpoints offered to the Commission in this proceeding, with various methodologies and assumptions that have been used to estimate these models. There have also been opinions offered in this proceeding that don't include any independent quantitative analyses that is specific to the company or the current. Okay. There have also been opinions offered in this proceeding that don't include any independent quantitative analysis that is specific to the company or the current market conditions. In addition to the cost of equity models just presented, I feel it's also reasonable to consider authorized returns in other jurisdictions over a recent historical period that were decided in similar market conditions. I'll keep you in the same book this time. Reviewing Figure 3 on page 8 of my rebuttal testimony, it's important to recognize that as interest rates have increased, the average authorized ROE for vertically integrated electric utilities has also increased. In 2024, as shown on that figure, the average authorized return for vertically integrated electric utilities was 9.82%, which is much higher than the company's request. While Mr. Coleman disagrees that authorized ROEs reflect the investor required return, at page 16 of his surrebuttal testimony, Dr. Woolridge states that rate cases for utilities tend to occur every couple of years, so authorized ROEs are frequently updated and reflect the market cost of equity. Further, he notes that with fairly frequent rate cases, authorized ROEs are updated and can approximate the expected ROE. Therefore, it's reasonable to conclude that the average authorized ROE of 9.82% for vertically integrated utilities in 2024 demonstrates the expected ROE and the market cost of equity for an average risk vertically integrated electric utility. There's been much disagreement about the relative regulatory risk of Rocky Mountain Power and the proxy group companies. However, the argument's been taken entirely out of the context of what a risk analysis is used for in the cost of capital study. The risk analysis, which necessarily is a comparison of the company's risk to the proxy group companies, is intended to demonstrate where within the range of returns estimated using market data for the proxy group companies, the subject company's ROE should be placed. A risk analysis that compares the company to itself over a period of time, such as Mr. Coleman discusses, is insufficient and incomplete as it provides no information about how the company's risk profile relates to the returns that have been estimated using data for the proxy group companies. Further, in the current circumstances, the company's request is at the low end of the model results just discussed, using the proxy group companies that are risk comparable to Rocky Mountain Power. While the company is requesting an ROE of 9.65%, the median results of the DCF models as filed in my rebuttal testimony were greater than 10%. As noted previously, the results of other models also demonstrated that 9.65% is lower than the average for the CAPM, ECAPM, and bond yield risk premium analysis. The company's request is below the mean and median of recently authorized ROEs for other vertically integrated electric utilities in 2024. By all of those measures, the company is not asking the Commission to authorize an ROE that includes a premium for business risk. On the contrary, what the company is requesting is, in my view, well below what is supported and therefore is reasonable. While I continue to believe that the company faces greater risks than the proxy group in several of the areas that have been evaluated in my analysis, the company's requested ROE is below the average and median of the recently authorized returns. Turning to the discussion of market to book ratios, which I think we started to get into yesterday, Mr. Coleman and Dr. Woolridge suggest that the market to book ratio is an important factor that the Commission should consider, which indicates that utility ROEs have been consistently higher than the cost of equity. Essentially, these witnesses suggest that a market to book ratio being greater than 1 demonstrates that regulatory commissions across the country have systematically authorized ROEs in excess of the investor required return on equity. There's much discussion in all of the testimony that's been filed about academic articles and textbooks that these witnesses suggest support their position on this issue. In particular, the article cited by both Mr. Coleman and Dr. Woolridge, authored by Werner and Jarvis, is an analysis of regulation and valuation in the United Kingdom that they attempt to apply to U.S. regulation. As noted in my rebuttal testimony, there are several reasons why this study cannot be relied upon, one of which is the fact that regulation differs between the U.S. and the United Kingdom. In his surrebuttal testimony, Dr. Woolridge revisits this article in an attempt to suggest that this study is relevant to U.S. regulation and that it demonstrates that authorized ROEs overstate the cost of equity. However, his own rebuttal testimony undermines this study. At page 15 of his surrebuttal, Dr. Woolridge agrees that regulation in the U.S. and U.K. are different. Further, while he attempts to disprove the rationale for why market-to-book ratios exceed 1, as discussed in other articles by Colby and Vilbert, he ultimately does not disprove their points and suggests that some of the conditions they describe may or may not be present in any given year, which effectively disregards his assumption. Mr. Coleman also offers sites which he suggests support the conclusion that the market-to-book ratio greater than 1 demonstrates that the ROE set is greater than the cost of equity. He references Bonbright and Morin to support his claims. However, when you review those studies, they don't support Mr. Coleman's claims. Reviewing the pages that Mr. Coleman references in Bonbright, it's clear that he disagrees. In fact, Bonbright's final conclusions, cited on the very page that Mr. Coleman references in his testimony, states that he disagrees with the theory entirely. The reference that Mr. Coleman offers to Chapter 12 of Dr. Morin's book, New Regulatory Finance, is an excerpt of Morin's text, where Mr. Coleman disregards the first portion of the page. As discussed in that text, Dr. Morin refers to the end of the chapter, chapter 12.5, where he provides his review of the market-to-book ratio analysis. In that section of the chapter, Dr. Morin identifies that he does not believe it is relevant for regulators to consider the market-to-book ratio in setting the ROEs. Finally, while Mr. Coleman has cited to Dr. Morin for support several times in his testimony, he fails to consider Dr. Morin's opinion on many of the key issues that he criticizes in the development of the analyses in my direct testimony, including the use of projected interest rates, the calculation of the market risk premium in the CAPM. Dr. Morin's text in the CAPM. Dr. Morin's text specifically endorses both of the assumptions that I've used in my analysis. In particular, Dr. Morin states that the calculation of the projected market return to estimate the market risk premium, which is the methodology that I relied upon and was criticized by Dr. Coleman, is one of the top 3 most widely used methodologies. Lastly, referring to capital structure, there's been a lot of discussion about capital structure this morning and the analyses that have been prepared to support the company's requested capital structure. I developed those analyses, and I've prepared 3, all of which demonstrate that the company's capital structure is reasonable. As shown in Exhibit AEB 14, I considered the equity ratios of the utility operating companies owned by the proxy group. That analysis is looking at the book value of the regulated utility operating companies and is consistent with the book value that the Commission is considering for rate-making purposes here. The average equity ratios of the utility operating companies was 52.5%, as Ms. Koblia noted earlier. In response to this analysis, Dr. Woolrich stated that it is necessary to rely on the proxy utilities, the parent holding companies whose common stock is used to estimate the ROE. In my rebuttal testimony, I updated my capital structure analysis to do just that. I relied on the market value capital structures of the proxy group companies, since, as Dr. Woolridge notes, we are using common stock valuations for those companies to estimate the ROE. As shown in Exhibit 18R of my rebuttal testimony, the market capitalization of the publicly traded proxy companies, which is consistent with the market data used to estimate the cost of equity models, was 55%. In his surrebuttal testimony, Dr. Woolridge now suggests we should be relying on the book equity of the companies because utility rates are set using book value capital structures.
I'm going to object. This is, she's referring to Dr. Woolridge's surrebuttal. That makes her testimony surrebuttal, which hasn't been called for in the scheduling order and is generally not allowed unless we have a agreement or an order beforehand to allow live surrebuttal.
Mr. Saban, do you want to respond to that before I rule on that objection?
Sure. We are repeatedly reminded in intervener testimony that the company bears the burden. Yet Wednesday night, just a couple of days before this hearing started, we received surrebuttal testimony. That was provided when it was because the schedule was altered to move the date between the hearing and the surrebuttal closer. I just will note, I don't think it's appropriate for other parties in their surrebuttal to raise issues that are new for the first time in surrebuttal, and then expect our witness not to be able to have the chance to respond to it, where we are the ones that are required to bear the burden of proving one way or the other whether we've satisfied to your satisfaction that what we're recommending is appropriate. This has happened in multiple proceedings, and each time the OCS particularly has objected, and the last proceeding this happened, we were allowed to do this because they included new material in their surrebuttal. That's precisely what she's addressing here, is material that was not raised in their direct, not raised in rebuttal, but raised for the first time in surrebuttal, and she has not had the opportunity to address it, nor was there time to petition the commission to do surrebuttal, and I don't think you would have appreciated that because she's just making a few points about things that were brand new in surrebuttal.
May I speak to that?
Sure, please.
I believe that Mr. Coleman was, excuse me, Dr. Woolridge was responding to not new material, but material placed in Ms. Buckley's rebuttal testimony, in his rebuttal, which is appropriate. So it's not a situation where they had to respond to new material that appeared in a rebuttal. It was a position where Ms. Buckley correctly and appropriately countered an argument made by Mr. Buckley, by Professor Woolridge, and then in her rebuttal, allowing him in rebuttal to address her criticism. The problem is it has to end somewhere, and historically it's ended at rebuttal.
Okay.
Just 2 points quickly. Dr. Woolridge and Mr. Coleman include new citations to new material that wasn't previously cited in their prior 2 rounds. So it's not correct to say that that's not new. They're citing new material she's never had the chance to respond to. Why they waited till surrebuttal, I don't know. And the second point I would just note is that they have their opportunity to cross-examine our witness on these very issues if they choose to do so, and they have the opportunity for Mr. or Dr. Woolridge or Mr. Coleman to address what she says at later points in this proceeding. So nobody is going to be disadvantaged, and you've been clear, Mr. Chair, that you're allowing people to put in and have the fair opportunity to address things. That's all we're asking for.
Okay.
I'm sorry. Certainly you can cut me off in your discretion, but I just want to challenge Mr. Saban's notion that maybe we did put new things in there, but what she was referring to was something that she had raised before in her rebuttal testimony.
Okay, I think I've heard enough from both of you. This time I'm going to rule on the objection. The objection is overruled, and let me tell you why. Because I don't think I'm going to need to reach at this point in time whether new issues were raised in rebuttal or not. That's not, I think, dispositive of my ruling on this objection. This is a summary that she is giving of testimony, and I believe that the state, I believe that Mr. Moore, you're able to ask her on cross-examination any questions that will try to address your concern and to address the scope of what is in the various rounds of testimony. So I'm going to allow her to continue to give her summary, and the objection is overruled. Please continue.
I'm not sure everybody remembers where you were. Would you just start over with the last point, wherever it was you were with the last point, so that we have the proper background?
Yeah, we'll ask the court reporter to read back the last question or answer, whatever will be enough to refresh where we were in the process. Go ahead.
In his rebuttal testimony, sorry, Dr. Woolridge now suggested we should be relying on the book equity of the companies because utility rates are set using book value capital structures.
Dr. Woolridge can't have this both ways. To the extent that it is appropriate to consider the book value capital structures, because this is how utility rates are set, then it would be most appropriate to use the book values of the companies that are most comparable to Rocky Mountain Power, which are the utility operating companies. If it's important to maintain consistency with the market value of the common stock that's used to estimate the ROE, then it would be more appropriate to use the market capitalization that's reflected in those valuations of the proxy companies. In either case, I've performed the analysis. And as discussed in my direct and rebuttal testimonies and referenced previously, the company's requested equity ratio is lower than the average for the proxy group companies. Further, Dr. Woolridge has indicated in this case that it's necessary to include short-term debt in the capital structure for Rocky Mountain Power. That recommendation is inconsistent with his capital structure recommendations offered in several other recent rate proceedings, where he's not recommended the use of short-term debt in the capital structure. Lastly, Mr. Garrett's rebuttal testimony corrects a statement made in my rebuttal testimony, which I corrected this morning as well, that none of the intervener witnesses has considered the interrelationship between capital structure and the return on equity. And he cites to his own testimony using the Hamada adjustment. While Mr. Garrett is correct, and I adjusted my testimony this morning to reflect that he attempts to consider the Hamada adjustment, it's important to recognize that the analysis that he performs suffers the same flaw just discussed previously in response to Dr. Woolridge. Mr. Garrett's Hamada adjustment relies on the book equity of the proxy companies rather than the market equity, and therefore his adjustment to the ROE is incorrect. That concludes my summary.
Okay, thank you very much, Ms. Bulkley. I think this would be.
I have just two, can I just ask her two questions that were thrown to her from?
Sure, so let's have you do whatever direct you'd like to do, and then whatever that takes, we'll break for lunch after that.
It will be very, very brief here.
Okay.
Ms. Bulkley, were you present when Ms. Koblia took the stand and testified?
Yes, I was.
Do you recall that she was asked questions about operating company data versus holding company data in determining capital structure?
Yes.
I want to make sure I understand your testimony today, and that you have an opportunity to address a question that she fielded or referred to you. You noted in your summary just a moment ago that you've conducted, for purposes of the capital structure, you've conducted an analysis using operating company data as well as holding company data, if I understood you correctly. Is that right?
That's correct.
And what was your determination using both market, or the data for operating company peers and holding company peers when it came to the company's capital structure?
The company's proposed capital structure that includes 50% equity is lower than the analysis, than the capital structures using either methodology that I relied on. So the utility operating company equity ratios, the average was about 52.5%, and using the proxy companies and their market capitalization, the equity ratios were 55%.
And then one more question. In one of the binders there is Dr. Woolridge's direct testimony. I think it would be in the one you're looking at right there in front of you. It's either in that binder or the one right above it, but. Would you go to page 28, please? Ms. Koblia was asked and didn't know the answer and referred this to you, but She was referred to line 604 and 605. Do you recall that?
I do.
That represents Dr. Woolridge's calculation of average common equity ratios, which is represented as being for his group as well as your group. Do you agree that those figures in line 605 represent your calculation of the average equity ratios for the group of peer companies you assessed?
No, this doesn't reflect my calculation. This is Dr. Woolridge's use of book equity ratios for the proxy group companies, for his proxy group and mine. And the reason that the book equity ratios are not helpful in this circumstance is that they consider the capitalization of other than utility assets, and it's not the metric that is consistent with the market data that we're using for the DCF. So there are two issues there. We're using the market prices that relate to the publicly traded entities. The proper comparison when using the market prices would be to look at the market capitalization. Dr. Woolridge's analysis, in his DCF, he uses market prices, but in his capitalization analysis, he's using the book equity.
Thank you. I have no further questions, Mr. Chair.
Thank you, Mr. Saban. I think this, before we begin any cross-examination, I think this would be a good time to take our lunch break. We'll plan on reconvening here at 5 minutes after 1. Try to be prompt. We're 3 minutes late. We'll try to start when we say we're going to start. We welcome Ms. Bulkley back to the stand, and I think are you finished with your direct?
Yes, she's
Okay.
available for cross-examination.
Okay. We typically go with the division and the office, so are you okay with continuing in that order? I could switch
Yes.
it up a little bit. I do.
Yes, we are good today, thank you.
Okay, all right. I'm just trying to be an accommodating guy. Okay.
Thank you, and I appreciated the accommodation yesterday, more than you will ever know.
Oh, not a problem. Okay. All right, Ms. Schmidt, we're ready for you to conduct your cross-examination of Ms. Bulkley.
Good afternoon.
Good afternoon.
Before I turn to my prepared cross questions, I'd like to address one thing from your summary. As a gross simplification in your summary, you said that Dr. Marin disagreed with Mr. Coleman's testimony. Do you recall that from your summary?
Well, depending on specifically what you were referring to in Mr. Coleman's testimony, of course.
I am not sure that you gave the reference to Mr. Coleman's testimony. If you did, I did not write it down, and I apologize. Could the court reporter perhaps please read that portion of her summary back?
Think you can find that and read that back? Unless Ms. Bulkley can ascertain what's being asked.
Yeah, there were a few places, that's why I asked for
I
clarification.
understand. Well, let's take a second and let you, well, we can go off the record, but you can.
Yes. That I can perhaps clarify, or are we still off the record? I believe it was when you addressed that Dr. Marin did not agree with Mr. Coleman's market to book analysis,
Yes.
if that helps.
Yep, that does help.
Okay, we're going to go back on the record. While we were off the record, we had a discussion to try to identify the statement from Ms. Bulkley's summary that was at issue. And so we'll now have Ms. Schmidt ask her question again.
Thank you very much, and thank you for the indulgence. In your summary, you, I believe, represented that Dr. Marin disagreed with Mr. Coleman's book-to-market comments about Dr. Marin's position. Could you please provide us a citation to the parts of Dr. Marin's textbook where you said he disagreed with the premises Mr. Coleman said Dr. Marin said? That was really ugly, but did you understand that?
Yeah, I believe I understood the question. So I believe what I said in the summary is that that Mr. Coleman referenced a page in Dr. Morin's book, and he disregarded the first section of the page in the book. So that page was 359
Okay.
of Dr. Morin's book, where Mr. Coleman cites to a reference to the market-to-book ratio in his analysis, citing Morin as support for that, the concept that the market-to-book ratio greater than 1 suggests the cost of equity the return on equity is higher than the cost of equity. What he did not address is the first paragraph of that page in Dr. Morin's book, where he says,
And pardon me, I just asked for the page reference, not an explanation, I believe.
well, I think you asked for the page where Dr. Morin disagrees. So
I just
I'm-
asked,
I'm-
sorry, just for the page number.
Yeah, so it's section 12.5, which I did reference in my summary. I don't
Okay.
have the page number
Thank you,
necessarily.
that will help us. I could not keep up. Did you also reference something at perhaps the end of that chapter in your summary?
That is 12.5. That's
Okay.
correct.
Okay, with that, I'll move on. 2 cross-examination exhibits have been handed out this morning to people in the hearing room, the commissioner, the court reporters, opposing counsel, and the witness. The cross-exhibits were emailed out this morning earlier to the parties in electronic form. The first one is a copy of the commission's redacted order in the 2020 Rocky Mountain Power general rate case. And the second one contains the commission's order and errata order in the Dominion Energy Utah semi-recent rate case, 22-05703. If you could please turn to the copy of the redacted order in the 2020 docket and label that as DPU Cross 8.
Done.
Thank you. I believe that this order has been mentioned many times, but I don't believe that it has been entered as an exhibit in this docket. I'm happy to lay some foundation, and I will proceed with that. I will represent that I pulled the order from the commission's docket sheet for the 20-03504 docket. Do you recall that the 2020 order has been referenced in this proceeding?
I believe the results from this decision have been referenced, yes.
And you were here when the 2020 order was discussed earlier this morning?
I was, though I can't proclaim to remember what the conversation was about this morning.
It's fine. Do you have any reason to believe that the order I have passed out and marked as DPU Cross 8 is not a true and correct copy of that order?
I have no reason to believe that it is or is not.
I'm happy.
Willing to accept it.
I am. Do you recall anything from that order that we could check? I believe that you were a witness in that docket on behalf of RMP. Is that correct?
Yes, that's correct.
Would you like to see if there are references to your testimony that you recall? Or else I can move on and perhaps try and introduce this through another witness.
Frankly, Ms. Schmidt, I think you've laid enough foundation. I'm going to see if there's an objection.
No objection.
Okay. We will receive DPU Cross Exhibit A, which is a redacted order of docket number 20-035-04.
Thank you. Now, if you will turn to the other cross exhibit that was passed out, and if you would please label that as DPU Cross Exhibit 9, I believe.
That's correct.
I can lay some foundation for that as well. Mills Bulkley, both you and other witnesses in this docket, particularly Mr. Coleman, cited this order in your testimonies. Do you recall that you addressed this order in your testimony?
Yes, I do.
Do you have any reason to believe, if you'd like to take a moment to review the order, do you have any reason to believe that the order which has been handed out to you as Cross Exhibit 9, the main order, not the errata, is not a true and correct copy of that order?
No.
With that, do you have any reason, are you familiar with the errata order in that docket?
Not specifically, no.
I will lay the foundation again that that also was pulled from the commission's website, and I will move for the admission of DPU exhibit, cross exhibit 9.
Is there any objection to that?
No objection.
Okay, we'll receive DPU Cross Exhibit 9, which is both the order in the Dominion general rate case and an errata order that's attached to it. Will be received.
Thank you. Could you please turn to pages 7 through 10 of the original order and take a look at that, please?
I just want to be clear, the one is for Rocky Mountain Power and the other one is for Dominion Energy, is that right?
That is
We're not
correct.
talking about an errata order to the 2020.
We are not talking about an errata order to the 2020. The errata order was in the Dominion rate case. Thank you for helping me clarify that.
So you're referring us, did you say to Exhibit 9, page 7?
Pages 7 through 10, please.
Okay, thanks.
And the last couple of pages of DPU Cross Exhibit 9 contain the errata order.
Yeah, I just wanted to make sure she wasn't saying that the 8 and 9 were somehow related.
Okay, all right, thank you.
And it's 7 through 9, correct?
7 through 10, please.
10, yes, I have those pages.
Could you please, do you remember what was said on those pages? Or would you like to refresh your memory by reading them now?
I'll take a moment.
Thank you.
Sure.
I'm sorry to interrupt again. I think there's some confusion. I don't think Ms. Bulkley was a witness in the, maybe she was in the,
No, I'm sorry, she was not a witness in the DEU docket, but okay, let me start again. Let me perhaps relay my foundation. Ms. Bulkley was not a witness in the DEU docket. She was in the RMP docket. With regard to the DEU docket, she addressed the DEU order in her testimony in this proceeding.
thank you.
Thank you for having me clarify that. I apologize.
No, I actually think you've stated it before, but the clarification is good. We're all straight on it now.
Yep, I've reviewed that.
Perfect. Do you agree that it is a fair characterization of those pages that the commission there considered its task to consider the totality of the evidence before it in arriving at just and reasonable rates?
The commission identifies the evidence that it did consider. I'm not sure I want to characterize it as the totality of the evidence, given that I wasn't part of the proceeding, so that I'm not truly aware of what that would include.
But you did reference the order, correct?
I did.
Okay. I can move on. In your testimony, you proposed that the recommended range for the ROE is higher than your recommendation. I believe that you started with a recommendation, or with a note that 10.25 to 11.25 was a reasonable range, and then the numbers evolved through your rounds of testimony. Is that a reasonable summarization, or would you like to elaborate?
Yeah, no, I'm not sure I understand how the numbers evolved throughout the proceeding. That's kind of confusing to me.
Okay, so what was the first reasonable range that you cited in your testimony, in your direct?
On page 6 of my direct testimony at line 116, I provided a range of 10.25 to 11.25%.
And in your rebuttal?
On page 21, lines 392 to 393, 10.25 to 11%, 11.25%, same range.
And in your SIR rebuttal.
Don't believe I provided a range in my SIR rebuttal. I don't believe there is one here in my SIR rebuttal testimony.
Thank you. I stand corrected, and I'll state that your range was 10.25 to 11.25 for the ROE as a reasonable range. Is that correct?
10.25 to 11.25 would represent a reasonable range of the cost of equity based on the models that were developed.
Are you saying that the company's proposed ROE of 9.65 is insufficient to attract capital?
No, I don't believe I said that. As a matter of fact, I believe I said that it was at the low end of the range of the model results. So my testimony describes the 10.25 to 11.25% as the overlapping range of results of the models. And the 9.65% requested by the company is, if you look at figure 1 of my direct testimony on page 5, is at the low end of those model results. I think that's how I described it this morning as well in my summary.
Thank you. Are you familiar with the debt issuance that Pacific Core issued in 2024?
Not the details of that issuance, no.
Are you familiar with the fact that that debt issuance was associated with a 9.65 ROE and with the equity position from the 2020 case?
You'd have to show me something. I'm not familiar with that specifically, no. If you could provide a document to me, I'd be happy to review that with you.
I will just leave that there. And I will ask for, I believe I asked for the admission of 8 and 9, and I believe that admission was granted.
That is correct.
Those are all my questions. Thank you.
Sure.
Okay, let's go to Mr. Moore.
Thank you. Thank you, Chairman. Hello, Ms. Buckley.
Hello.
I'm going to begin with some questions on Rocky Mountain Power's business risk. Your testimony analyzes 3 types of risks that can impact an ROE: wildfire risk, capital expenditure risk, and regulatory risk. Is that correct?
Yes, those are discussed in my direct testimony.
Considering wildfire risk first, could I direct you to page 48 of your direct testimony, line 946? Are you there?
Yes, I'm there.
You testified, B of A has stated that it sees the consistent existential risk posed by wildfires outflanking any other factor or exposure of a given utility's equity. Did I read that correctly?
Yes, you did.
Well, my second shot. Now starting on line 976 of page 49 of your direct testimony to page 51, line 1011, you discussed the fact that credit agencies consider wildfire risk when they set their credit ratings. Is that correct?
I have identified several quotes from the rating agencies that discuss wildfire risk.
Specifically, on page 50, line 1008, you stated, S&P also stated it could affirm ratings on Pacificurse and reverse its outlook to stable if the company were to achieve favorable outcomes that limited existing wildfire liabilities, and the company is not the cause of future material significant wildfires. Is Is that correct?
I'm sorry, that's 51, I think. Is that what you were referring to? On mine, it appears to be on 51.
Oh, I apologize. That's probably a typo on my part. Do you want me to read that again?
No, that's fine. I just wanted to make sure we were in the same place.
Okay.
So let's just be clear, what page and what line numbers are we talking about? Do you know, Ms. Bulkley?
I believe it's page 51, lines 1008 through 1011.
Okay. Does that sound right to you, Mr. Moore?
That sounds right. I'll double check.
Okay.
Yes, that's correct. In the question and answer on page 52 of your direct testimony, starting with line 1044, you give your conclusion as a Utah wildfire risk. Could you please read the first two sentences of your conclusion, starting in 1044 and going through to 1049?
Sure. Wildfire risk presents one of the most significant business, operational, and financial threats for utilities in states subject to such risks. Utah has significant greater wildfire risk as compared to the proxy group utilities, and it is clear that equity investors and credit rating agencies are reflecting incremental risk for companies that have been affected by wildfire exposure, and that the electric utility sector overall has increased risk related to this threat.
Thank you.
Sure.
Now I'd like you to turn to this second risk you identified, the risks associated with capital expenditures. On page 54 of your direct testimony, starting in line 1080, you state, from a credit perspective, the additional pressures on cash flows associated with high level of capital expenditures exerts corresponding pressures on the credit metric and therefore the credit ratings. Did I read that correctly?
I'm sorry, what line are you on? I apologize.
I'm sorry, I should wait before I start. 1080?
Yes, that's correct.
Now, you never did state explicitly whether Rocky Mountain Power capital expenditures risk is greater than the proxy groups. And when I talk about the proxy groups, I'm just referring to your proxy group. But on page 53, line 1068 of your direct testimony, you did note that the company's ratio of capital expenditures as a percentage of the net rate base is approximately 1.4 times the median for the proxy group of companies. Isn't that true?
That's correct, yes.
Finally, you discussed the risks imposed by regulatory environment that the utility operates in and
I'm sorry, I think you asked it whether or not I ever made a conclusion on this, and I did actually make a conclusion, so I think that would be helpful. If you went to page 56 on lines 1,128 through 1,131, there is a conclusion there which states, therefore, to the extent the company's rates do not continue to reasonably permit the recovery of its prudently incurred capital investments on a timely basis, the company would face increased recovery risk and thus pressure on its credit metrics. That was my conclusion of that section.
Thank you.
Sure.
Finally, you discussed the risk imposed by the regulatory environment the utility operates in as the last risk factor you address. Isn't that true?
As a general category, yes, that's true.
Can you please turn to page 63 of your direct testimony?
I'm there.
Beginning on line 1293, you state both Moody's and S&P have identified the supportiveness of the regulatory environment as an important consideration in developing the overall credit rating for regulated utilities. I read that correctly, didn't I?
Yes, you did.
Also on that page, line 1,298, you state, I conclude the company has greater than average regulatory risk when compared with the proxy group. Is that your conclusion?
Oh, I think you skipped the part before that. Company's regulatory risk and the ability to timely recover its prudently incurred cost is moderately higher relative to the operating utilities of the proxy group. Given the company's risk associated with fuel cost recovery and lack of revenue stabilization. I think I raised this issue in my summary this morning as well, noting that at the company's requested 9.65% ROE, they are at the low end of the range of the results of the models, and therefore, while we've had a lot of discussion about business risk, the recommendation is actually so far below the range that it's hasn't been taken into consideration in the 9.65% ROE.
But you did discuss the business risk extensively in your testimony.
Yes, I did, but as I said, they were not factored into the company's recommended or requested return of 9.65%, being at the very low end of the range of results. As I noted in the beginning of my testimony, considering the relative risk factors for the company, I would have certainly, my recommendation would have fallen within the range that I identified and we discussed a few minutes ago of 10.25 to 11.25, and would have been at the mean or above to reflect some of those risks. So
Okay,
the company's
thank you.
request is.
I'd like to get back, I'm sorry. I'd like to get back to my questions about risks now.
Sure.
Rocky Mountain Power's S&B and Moody's credit rating are BB+ and Baa1, respectively, where the proxy group's S&B and Moody's credit rating are BB+ and Baa2, respectively, which means Rocky Mountain's Moody's credit rating is one notch above the proxy group's Moody's credit rating. Do you dispute this?
I'd have to put those in front of me, the ratings for the proxy group. Do you have those available, please?
I'll hand out an exhibit. I wasn't planning to make this exhibit, but to help you out.
Thank you.
Now, take a while and look at this spreadsheet. You're familiar with spreadsheets, correct?
Yes, I'm familiar with spreadsheets.
I thought you could find out the proper way to look at it quickly.
So in looking at spreadsheets,
Hold on 1 second. Robert, is this an exhibit that you've previously circulated? I don't think we received this in the cross exhibits that were disclosed.
No, this is not a new cross exhibit. It was in Mr. Woolwood's testimony. Exhibit.
Okay.
Brennan Woolwood's testimony.
This is an
number 2.
attachment to what he did?
I believe so, yes. That's my understanding.
Okay, thank you.
Can you tell me what the average,
Hang on just a second, so let me make sure you've marked it as OCS Cross Exhibit 9.
Right.
Since it's already in the record, we can refer to the exhibit in his testimony, but just for convenience, unless anybody has an objection, I'd mark it here as well. Mark it and admit it as OCS Exhibit 9.
Yes, I would like to do that. Thank you very much, Mr.
Okay,
Chairman.
so you moved, no objection to that. Okay, seeing none, we'll admit OCS Cross Exhibit 9.
You look in panel B in your proxy group, and under the mean and medium in the S&P insured credit rating and the Moody's long-term credit rating, about in the middle of the bottom spreadsheet, they have the numbers BB plus and BAA2. Do you see that?
I do, but my familiarity with spreadsheets tells me that you can't average a BBB plus and an A minus in a spreadsheet. So that actually doesn't work in an Excel function. So I'm not exactly sure how those means are derived, but I can tell you that Excel cannot average BBB plus and A minus and come up with any value.
Well, we'll ask Professor Wooldridge in his summary later on this week. All right, I asked you, and I believe I finished my my last question with the statement, which means Rocky Mountain Power's Moody credit rating is one notch above the proxy group's Moody credit rating. And that's if we assume hypothetically, because there's a problem with the spreadsheet, that those are the credit ratings for the proxy group. Which,
I'm just trying to be clear on what your question is. You're asking me to assume, can you just
well,
sort of summarize what you're asking me to assume?
certainly. I might add, too, in his direct testimony, and see if you can remember Mr. Wooldridge's testimony. In his direct testimony and his sir rebuttal testimony, he makes arguments citing these numbers, and I don't believe you have contested that.
I don't necessarily recall those specifically, but I do typically state in my rebuttal testimony that the fact that I haven't responded to every single sentence does not necessarily mean I agree with it. So
Well,
I think that's a fair statement. There's a lot of text in these rebuttal testimonies, so you have to sort of identify the things that you feel you need to address, and you can't possibly address every sentence.
you have to address the important ones, don't you?
Well, you address them in order, so I can't necessarily say that this particular sentence stuck out in my mind. You're addressing these on a short timeline and very voluminous responses.
But you did spend, as we've gone through, when I read your testimony, you did spend a lot of time when you're speaking about the business risk by making references and support from credit rating agencies. Isn't that true?
In the preparation of my direct testimony?
In the
Yes.
substance of your direct testimony.
Yes, my direct testimony is prepared on a very different timeline than the rebuttal testimony schedule, and it is prepared in isolation without reviewing hundreds of pages of individual witness testimonies, so I can address the things that I think are relevant there.
All right.
Yeah.
So now that you have challenged the credit rating of your proxy group, I'm going to rework this question I have here as a hypothetical. And the hypothetical is here. Given the fact that your analysis of the business risks concludes that Rocky Mountain Power is riskier than the proxy group, and the credit agency's analysis of Rocky Mountain Power is that it is the same or lower than the proxy group, either your analysis or the credit agent analysis must be incorrect. Isn't that true?
Mr. Chair, here's the problem I'm having. We can all see what the credit rating numbers or credit rating designations are. Some are higher, some are lower. I don't think it's a fair statement to say that this witness has challenged the credit ratings in there, nor do I think it's a fair statement to say that the mean or the median that's calculated here came from her. I just want to be clear that
I didn't mean to suggest that it did come from her.
I think your clarification and your comments are appropriate on the record. He is asking a hypothetical question, and we'll let the witness answer the hypothetical if she can do that.
Can I have the question again?
All right.
We could have the court reporter read it if you want. It was a long question, or do you have it written down and want to read?
I want to try to state it better. I apparently have confused the witness a bit.
I think that's fine. Thank you. Go ahead.
Given that your analysis of the business risk that you have in your direct testimony concludes that Rocky Mountain Power is riskier than your proxy group, and given my hypothetical credit ratings, which provide that the credit agencies determine that the proxy group is riskier than Rocky Mountain Power, either your analysis or the credit agency's analysis must be in error.
No, I disagree with that.
Okay, I'm going to do something I'm not supposed to. I'm going to ask you an open question.
You do so at your peril, as you know.
I know. Why?
My analysis is an analysis of the cost of equity. The credit rating agencies are looking at the ability of the companies to repay debt. They're looking at two different things. They're not necessarily looking at the same proxy group. They're not necessarily looking at the same risk profile. So the two analyses can come up with a different result.
You made this argument in your rebuttal testimony on page 102, isn't that correct?
I don't know. I'll tell you in a second. Yes, apparently I'm consistent.
However, you simply state the assertion and not cited any authority or undertaken any analysis demonstrating the difference in debt risk and equity risk. Or identify any factors that is taken into account of the equity investors that is not taken into account or taken into account in a different way by debt investors. Isn't that true?
I'm sorry, that seems to be a two-part question. Can we go with the first part, which is that I didn't identify the risks of debt and equity? I think that was your first question.
No, if that was my first question, I misstated myself.
Okay, maybe we should try again.
Okay, let me see if I can break this down. You simply stated the assertion on page 102 that you've read, and you haven't cited to any authority or undertaken any analysis demonstrating the difference between debt risk and equity risk.
Well, I did state at that page on my testimony, which I think is just simply a matter of fact, that credit ratings assess the likelihood that a company could default on its debt. This is the credit rating agencies. They focus on debt. Whereas the topic of estimating the cost of equity is to determine the riskiness and the cost of the company's equity. So I don't necessarily know I have a cite for that, but it is sort of fundamental in finance that debt has a prepayment obligation, has a payment obligation in regular intervals, and it has priority payment over equity, so that there would be greater risk associated with equity than debt, and that the credit rating agencies are really looking at debt obligations, which is why they look at cash flow coverage ratios. They're looking at the ability of a company to pay its debt. And so that's their primary metric. So I think that kind of goes with an understanding of what the credit rating agencies are doing. I apologize that I didn't cite, but I think that's the gist of the sentence.
Let me see if I can paraphrase your testimony, then we can move on. Despite the fact that you relied on credit agency ratings in your discussion of business risk, and the fact that debt investors have a higher claim to the company's assets and earnings than equity investors, Your testimony is nonetheless that while your proxy group is riskier than Rocky Mountain Power for debt investors, the proxy group is somehow substantially less risky than Rocky Mountain Power for equity investors. Isn't that true?
No, I don't think that's true at all. I'm not sure that summary captures my testimony at all.
Well, if the credit agency's debt risk has the proxy companies with a lower credit rating, and your testimony that Rocky Mountain Power is substantially more risky than the proxy group, you must be stating that the debt that Rocky Mountain Power is at the same time riskier than the proxy group when it comes to equity and less risky in the property group when it comes to debt. Isn't that right?
I'm saying, first of all, that the credit rating agencies haven't considered, as I noted on the prior page on 102, that the credit rating agencies are not actually evaluating the companies based on a proxy group that is comparable to the proxy group that I'm considering here. They're evaluating their own individual coverage ratios within a range of metrics.
When you were developing your direct testimony, you spent about half the time of your discussion talking about equity risk by referencing credit agencies. Isn't that roughly true?
I'm not sure what you mean by half the time. Half of my pages of testimony, I would disagree with that. My direct testimony is, I just don't understand the question. My direct testimony is...
What confuses me, and I'm easily confused, I'm just a lawyer, I'm not a financier. What confuses me is why, when you wrote your direct testimony, when you stated you had much more time, you emphasized so much what credit agencies did with fire risk, with regulatory risk, with capital expenditure risk. Why spend all that time referring to credit agencies when your conclusion about the credit agencies is they're irrelevant because they deal with debt, not equity? It seems odd to me that you would have wasted that ink.
I don't think that's a fair characterization of the testimony, I'll say.
Let's move along. Mr. Chairman, I was going to discuss the Utah Fire Fund Code, Section 54-24301, the same statute that has been entered into evidence on the Utah Large Consumer Group Cross Exhibit Number 10 as an enrolled copy of Senate Bill 224. I apologize for my ignorance, but I don't know how to proceed. My copies are from the legislature's website, and they don't cite to Senate Bill 224, but
Yeah, they would cite to the section that it's now found in the code. But we do have the enrolled copy as an exhibit. Can you refer to that and ask your questions using the enrolled copy that's been provided?
I can. I think mine would be a little clearer, but if you feel that that is appropriate, we'll go down that way.
I'm going to let you choose to conduct your cross as you'd like, if Mr. Saban has an objection as we get into this. But I think that we ought to be able to compare and make sure that the sections match up. So go ahead, however you would like to do it.
Well, in order not to further burden the record, why don't we use the Utah Large Consumer Credit Cross Exhibit 10? Do you have a copy of that with you?
Bet there is one here. That's great, thank you. Oh. Thanks so much. Okay, yes, I have one.
All right, in my notes here, I have used the section numbers instead of the line numbers. So that's what I'll be referring to. And that may take just a little bit longer, but we're dealing with, no, section numbers
Yeah,
are there.
Yeah, the section numbers are in the enrolled copy of the legislation, because that will then just move over into the code. So if you just give her the section numbers, she can find them off the enrolled copy.
Thank you very much, Mr. Chairman. Ms. Buckley, let us go back and address the wildfire liability now on page 52 of your direct testimony, lines 1044 to 1046.
Yes, I'm there.
On those lines, did you state wildfire risk presents one of the most significant business, operational, and financial threats for utilities in the state subject to these risks? Did I quote that correctly?
Yes, you asked me to read that into the record a few minutes ago.
Well, now we both have. After that line, you stated Utah has significantly greater wildfire risk as compared to the proxy group utilities. Isn't that true?
Yes, I read that one too.
That's right. You based this conclusion on a FEMA National Risk Index that lists, on a FEMA, F-E-M-A, National Risk Index that lists general risk of annual losses caused by wildfire and other natural disasters. And I believe that's, your discussion of that is on your direct testimony, line 51, page 51, line 1012 and 1029.
Yes, it's the expected annual loss. I'm not sure that's what you said, so I just want to clarify that.
Thank you.
Sure.
Now, the FEMA National Risk Index just provides for general wildfire losses and losses caused by other national disasters, and does not delineate between utility-caused wildfires and non-utility-caused wildfires, nor does the index address liability for wildfires. Isn't that true?
That's correct. It identifies the states and the regions that have wildfire risk.
That's correct. And it actually does that for several type of natural disasters.
Well, I focused on the wildfire, so I don't want to speak to the others.
All right. On page 48 of your direct testimony, line 957 to 961, you cite a B of A Global Research article that provides, we perceive a risk that a new premium utility will be defined by its exposure to wildfire factors. The first screen is simply geographical and FEMA's assessment of wildfire risk.
I'm sorry, I'm completely lost. Where are you?
Oh, I'm sorry. On page 48 of your direct testimony,
Yes, what line did you start at?
957,
Okay.
and I go to 961.
Okay, that starts with should there be further events? I don't think that's what you started with. So,
Maybe. Let me double check this.
Just take your time on that, Mr. Moore. We want you to make sure you find the correct reference. We're okay on time.
Well, now I'm very confused, Ms. Buckley, because my notes appear to be correct. Maybe I have you wrong. No, direct Buckley, page 48,
Yes.
and you see at the very end of the page, there's an indented quote.
Yes. Yeah, the quote starts, "Should there be further events?"
Right.
Right, maybe you didn't start at the beginning of the quote, so
I see the problem. Could you read the quote where it goes down on page 48 and ends on 963 before it looks like an ellipsis, it's not, it's asterisk. So just that first two sentences, I believe it is.
you want me to just read them into the record?
Just read them into the record, please.
Sure. Should there be further events, we perceive a risk that a new premium utility would be defined by its exposure to wildfire factors. The first screen is simply geography and FEMA's assessment of wildfire risk, while the second consideration is the legal and regulatory construct under which the utility operates. We anticipate having explicit and refreshed refreshed plans will become a necessity for any utilities operating in geographies.
Thank you. Let's look at the legal and regulatory construct with wildfires and the legal liability in Utah. This brings us to Utah Code 5424-301, first proposed by Senate Bill 22-4. You addressed the Fire Legislation Fund in your direct testimony on page 52.
Yes, I see that.
However, you did not state anything more than the bill provides for the creation of a fund to compensate third-party liabilities for wildfire damages that exceed the company's insurance. Isn't that true?
Can you give me the question again?
In your discussion of the fire fund legislation, was limited and basically was just the assertion that the bill provides a fund to pay for wildfire liability that is in excess of the company's insurance.
Yes, and in the next sentence, it refers to the testimony of company witness Ms. Joelle Stewart for the details on their company's plans.
Right, and we'll get to the details right now.
Okay.
Before I go further with this, with the code, I'm going to direct your attention to the end of 52, the top of 53 of your direct testimony. Did you state, absent meaning regulatory support for the utilities in the state subject to substantial potential loss for wildfires? I'm going to read that again because that's the part that I'm interested in. Absent meaningful regulatory support for the utilities in the state subject to substantial potential losses for wildfires, the investor required return increases significantly due to higher risk of wildfire exposure. That's your opinion.
Yes, that's my testimony. That's correct.
Now, I would like to walk you through some provisions of the fire fund legislation to discuss whether it offers meaningful regulatory support. To that end, I'm going to direct your attention to what I believe has been provided to you, the enrolled copy of Senate Bill 224. Now, Section 54-24-3012, do you see that?
Yes, I do see that.
Provides a large-scale utility may create a Utah Fire Fund by filing notice to the commission, and section 54-24301-3A provides the fund shall consist of a reasonable and prudent fire surcharge that a large-scale utility may charge to the large-scale utilities customers. That's correct, isn't it?
Yes, it is.
Under section 54-24302, the surcharge will terminate either at the end of 10 years on the commission's own motion, or when the fund equals 50% of the large-scale utilities Utah revenue requirement, correct?
Under section
54.
54-24-3012, I don't see that
I'm
number.
sorry. I must have stumbled. 302,
302.
paren 3.
3023. Yep, I see that.
Rocky Mountain Power's revenue requirement in its last general rate case was approximately, and this is a very rough approximation, $2 billion. So 50 of that would be approximately $1 billion. Isn't that correct?
50%, yes, that's true.
Are you aware that Rocky Mountain witness Mr. Graves' written testimony refers to the Utah Fire Fund legislation as an unambiguously favorable for the financial health of Rocky Mountain Power? That's Graves Direct, page 361, line 74950.
Yes, I've reviewed Mr. Graves' testimony. I think Mr. Graves references, I don't think Mr. Graves and I are in disagreement. Mr. Graves' testimony references the asymmetric risk associated with wildfire and the
Excuse me, I'm going to
being able
interrupt you. I
recover it.
promised to get to this, but my question about Mr. Graves was simply that he viewed, and we'll discuss the ROE issue in a second.
Oh, I don't have his testimony to necessarily validate your quote then, so you're going to need to give me that.
All right.
I just have a recollection of the testimony as I was describing. So,
One moment, I'll get you an exhibit.
thank you.
While you're looking for that, I'm planning on us taking a break around 2:30. Everybody good with that? Don't need one any earlier, correct? All right, thank you.
I have this as an exhibit, but it is on the commission's website. I was wondering how many people would want an independent copy, paper copy of it now? You have to give one to the court reporter, of course, and one to the commissioners.
Well, we don't need to give one to Mr. Saban. We need to give one to Mr. Saban and the witness and that, the rest of us.
This has not been furnished to everybody.
But it's the pre-file testimony.
But it's pre-filed testimony.
Yeah, we're okay, and others can look at the pre-file testimony, but for ease of reference, let's go ahead and mark this as an exhibit. Did you give it to us as the commissioners? Yeah, please do that. And you got the court report, you got them? Okay.
All right, let's see how my notes are. Graves Direct, page 361. That seems very large.
Since this is pre-file testimony, but it is marked as a cross exhibit, can we just admit it now? And I don't think you need to lay any foundation unless Mr. Saban has an objection.
Yeah, I'm not going to object to my own witness's
I
testimony.
I wouldn't think so, but you never know in today's world, do you?
I
All right.
appreciate you asking. That's fine with us.
Okay, so we'll receive OCS Cross Exhibit 6, which is the direct testimony of Mr. Graves. It has been pre-filed, and so it's nothing new here.
All right, the page number is 36. And line 749. He was referring to some aspects of the firefighting legislation that we'll review, and he states, the above features of SB 224 are unambiguously favorable to the financial health of Rocky Mountain Power. Isn't that correct?
That one sentence is correct, yes.
Okay.
It does go on
And-
to discuss,
I know it goes on to discuss ROEs, and that's in a different section of my questions, and we'll get to it, and you'll be able to discuss it.
I was just saying, not the section, what I was referencing. The second sentence in that paragraph says the details of how to integrate such state-specific features are to be determined.
Right, because the state-specific features deal with the type of mechanisms Ms. Stewart talked about, the ICA and the another fund that PacifiCorp may propose that is for all their states, where the Utah fund is separate. So they don't know at this point in time. My understanding is Rocky Mountain Power doesn't know at this point in time how all those things are going to come together yet.
Well, I think neither did Mr. Graves. On the next page, he talks about the potential challenges of the fund. So,
Yes,
right.
but do you believe that that makes his further statement that it's an unambiguous
I do think you need to read Mr. Graves' testimony in totality, and one sentence in it in isolation probably isn't very meaningful. If you go to the next page, I think he discusses some of the concerns associated with the implementation of the fund that need to be taken into consideration. So I do think
and
one
I believe I
by
may be
itself probably is less meaningful.
I may be wrong, but I believe when he discusses them, that's how the fund is integrated into PacifiCorp's set of cost recovery mechanisms that, although they are discussed in this docket, aspects of it like self-insurance, a global fund for all PacifiCorp states, those things have not been implemented yet. And the question, Mr. Graves, if my memory of his testimony is, we have this statute here that's in effect now and provides significant benefits to Rocky Mountain Power. We just don't know how it fits with the rest of our mechanism for cost recovery for wildfire at this time. Do you dispute that?
You know, that's asking me to have read and internalized all of Mr. Graves' testimony here. I think he's going to appear later, and probably you should ask him more specifically about the entirety of his testimony. I can address things that relate to the ROE and how I think wildfire relates to the ROE, but I think characterizing all of Mr. Graves' testimony without being, the author of that testimony presents some risk that I get it wrong.
Well, the question, perhaps you can rephrase it to, if you refer to specific lines of the testimony.
Right.
And she can respond to the language there. We understand the witness has made, I think, a legitimate point that she's not reviewed, at least recently, the entire testimony of Mr. Graves, and she's basically stating that there needs to be a context given to the whole testimony. We understand that. That point is noted. Try to ask your question and see if you can get her to respond to specific lines in the testimony given the caveat she just gave.
With your caveat that this is just one line of his testimony, could you look at page 749, line 749, page 36 to 750? 749 to 750.
I'm there. I think we were just, this is
That's
one
right,
we were
and,
just talking
and
about, right?
I'm just gonna read this into the record, and you have your caveat, and then I'll move on. The above feature of Senate Bill 224 are unambiguously favorable to the financial health of Rocky Mountain Power. Unambiguously favorable to the financial health of Rocky Mountain Power. That's what it says, doesn't it?
That sentence does say that, yes.
Okay, thank you. Would you agree with me, Mr. Graves, that that the potential of a billion-dollar fund finance?
I think you said, Mr. Graves, I know you meant Ms. Bulkley, but let's.
No, I meant Mr. Graves. I think he believes, I think,
Oh,
I
I'm
think he
sorry, I
agrees with
cut
me.
you off before you had a chance to finish. I thought you were, I apologize, please continue.
Will you agree with me, Mr. Graves, that a potential billion-dollar fund financed by ratepayers to pay third-party damages caused by wildfires is meaningful regulatory support? Those are your words for Rocky Mountain Power.
Again, I'm not going to put words in Mr. Graves' mouth. I'm not exactly sure that that particular sentence referred specifically to what you're asking here. But my understanding is that the fund, that these funds would be helpful. They have not yet been determined. They haven't been filed for. There's been no decision with respect to how they're going to be implemented. And so that does remain to be seen, is my understanding.
And that's all, balls in Rocky Mountain Power's court. The legislature has done a great job for you, but the ball's down Rocky Mountain's court for the fire fund, isn't it? I mean, the reason why you don't have a fire fund is because you haven't applied for one.
So I don't work for Rocky Mountain Power, so your reference to you.
I apologize.
Is not relevant. But with respect to the fund, I do think that that there is legislation. The company may or may not, I'm assuming the company will make some kind of a filing, and then there will be discussion about that filing, and what ultimately comes out of that may or may not be in the company's court, right? The decisions get made. You make a filing, decisions get made, and they have to respond to those decisions, right? So that's a lot of
Right.
questions in the future.
The
And my
legislature-
testimony.
I'm sorry, are you?
Nope, not finished yet. My testimony simply says that there is risk associated with wildfire, and to the extent that there is not some kind of regulatory support, that there would be greater risk for the company. That's just a simple statement.
And I'm asking you if this is regulatory support, if you are able to make the determination as an expert witness that one of the things that's helpful in dealing with risk and dealing with the ROE is the regulatory environment. You must have some understanding of regulatory environments. Isn't that true?
Yes, I do. The fact that there is legislation is helpful, as I indicated. The need to file for and get a determination about how that fund is set up is also very important.
Do you
I have a
agree with
question.
me that there are limits to non-economic damages in those sections of the statute?
Yes, there are.
And there's $100,000 for pain and suffering if you lose your garage, which seems to me very generous, and $450,000 for if you get 50% of your body burned, which seems rather.
I'm not going to comment on whether those are valuable or not. I'm sorry.
Well, that's true.
that seems to go-
That is irrelevant.
I have to believe that goes beyond the scope of determining the ROE, so I'm not going to comment on that.
I have an article. Actually, I don't have an article. How familiar are you with the James case?
Not very.
I'll represent to you, and it has been discussed today, so this may be a reminder. The James case involved the June 14th, 2023 jury verdict in a class action finding that Pacificor acted with negligence, gross negligence, recklessness, and willfulness in starting the wildfires in Oregon and finding Rocky Mountain Power liable for substantial compensatory, non-economic damages and punitive damages.
Is there a question in there?
The question is, do you remember that from the this morning's discussion?
You know, there's a lot of discussion about James this morning. I think those discussions were that was well discussed with Ms. Coblia. I can't say that I have enough detailed knowledge of the case to go too far into that with you.
All right, I'll just make the what I'm going to do is I'm going to hand you OCS Cross Exhibit number 5, which is the June 13th, 2023 article Rocky Mountain Power has presented in filings in this case and in other cases, and in testimony, I believe, although I'm not certain, that concerns the liability imposed by the James verdict. And I will ask you to read the highlighted portions into the record, and you don't have that, I'll have to hand that to you.
Okay, excellent.
That's not it. Is that the article? Ms. Buckley, well, Mr. Vastok is handing that out. I'll represent that it is an article from an insurance publication a month after the James case that I have highlighted some sentences in, and I'm going to have you read the highlighted sentence into the record once we have it handed out. And there is some highlighting on the second page as well.
So can I, just for clarification, Mr. Moore, we have just received OCS Cross Exhibit 6, the testimony of Frank Graves. So you took him out of order. You're going to now mark this as number 5. We don't have a number 5 already in the record, correct?
We don't have a number 5 on the record. I took them out of order.
Okay, that's what I just was making sure.
Actually, there's some highlighting on the first 3 pages. Why don't you read that to yourself, and when you're comfortable, you can read the highlighted versions into the record.
Sorry, Robert, are you saying this is an attachment to Mr. Graves' testimony, is what you're saying?
No, this was filed with an application for a deferred accounting order in Docket 24-305-40, I believe. And I believe, although I would subject to check, it was also referenced by Ms. Stewart in her testimony in this case.
Was this disclosed as part of your cross exhibits?
It was not. I believe it was, it's been talked, I'll have to check Mr. Joel Stewart's testimony, but
If it's an attachment to somebody's testimony, I have no problem with it. I just want to know what we're dealing with.
Mr. Saban, I am almost completely certain that it was, but let's check it.
Okay, well, if it is an attachment, we have no issue. If it's not an attachment, even though it hasn't been disclosed, we'll admit it, give it whatever weight we choose to give it. If it hasn't been previously disclosed, there is not a attachment. It is a,
Well,
it's a news article. It's in the,
it's a
it's
news
widely
article.
available, and you can ask the questions on it. If there's an objection, for surprise or something like that, we'll deal with it.
No, that's not where I'm headed. The scheduling order required us 2 business days before this hearing to disclose all cross exhibits. That wasn't our idea, but it was put in the scheduling order. That's why I'm asking, because if that's gonna be the standard, then we'll hopefully get the same opportunity to put in our own cross exhibits. if
Well,
they
you
come
raise a
up.
good point.
Yeah.
You
So
raise
that-
a good point.
I'm okay, I don't wanna, I'm sure this has been used before, I'm sure he's right. I just don't, it wasn't a cross exhibit, so that was why I was asking the question.
All right, well, your representation is that it's been referred to by others in the testimony, pre-filed in the case, and we're going to receive OCS Cross Exhibit 5.
Thank you very much.
Well, if other issues come up with respect to exhibits, we'll consider them at the time based on the merits. I understand we have an agreement about no late filed exhibits. And
Oh,
we're going to go forward with this one.
I've
Based on the
just-
fact that it's already been referenced.
I just got a note from my colleagues at the Division of Public Utilities. Ms. Stewart cites it in this case on page 25 of her direct testimony.
Great, thank you for helping me out there so I don't get myself in a bind down the road. All right, thank you.
Have you familiarized yourself with the article?
Generally, this is the first time that I've seen this article.
Could you
But-
read the highlighted portions?
Sure. The first highlighted portion on page 1 says, "But a verdict last month ordering Warren Buffett's Pacificor to pay 17 owners of property destroyed by a series of 2020 Oregon fires, an average of $5 million each, setting up total liability for thousands of others in the billions." Second highlight. At trial, Portland-based Pacificor itself estimated its potential liability at $11 billion.
I'm sorry, what did you say?
I read the highlight.
Yeah, I thought I heard you say 11 million. Was that my
B,
problem?
Billion.
Thank
B.
you.
Next page, first highlight. Liability on the scale imposed by the Oregon jury presents an existential threat to an industry. Last highlight on this page. The jury found the company grossly negligent and voted to compensate 17 test plaintiffs well beyond their property losses, adding millions of dollars more for pain and suffering than their lawyers requested.
And the last line on the next page.
Collectively, they actually got 15 times as much for emotional distress as they were awarded in economic damages.
Thank you. Given the I would like at this point to move for the introduction of OCS Cross Exhibit number 5.
Sure, I think I already said we were going to receive it, so it's already received into evidence, Mr. Moore.
Thank you. Given the large amount of non-economic damage award in the James case, the Utah Fire Fund's legislation low cap on non-economic damages certainly is. I'll start over. Given the large amount of non-economic damages awarded in the James case, the Utah Fire Fund's legislation low cap on non-economic damages certainly is a meaningful regulatory support, those are your words, for Rocky Mountain Power. Isn't that true?
I believe I indicated in my rebuttal testimony that I am not in disagreement with that. My rebuttal testimony says at page 104, has the legislative mechanism put in place in Utah eliminated all risk associated with wildfires? No. While the Utah Fire Fund will allow the company to collect funds to cover the costs in excessive insurance coverage, the risk remains that wildfire costs in excessive insurance coverage could exceed what the Utah Fire Fund would cover. That is the risk I discuss in my testimony.
Can you identify any of your proxy groups of companies that operates in a jurisdiction when there are low caps and non-economic damages caused by wildfire claims?
I have not reviewed the legislation in every state across the country, if that's what you're asking.
Can you identify any member proxy group companies that operates in jurisdictions where there is $1 billion rate paper funded fund for the payment of wildfire damages?
Objection, Lex Foundation.
Well, he's asking her if she knows of any, if she's aware of any states that have that fund.
And I was just noting that there hasn't been one here either. Not yet. There's no fund that's been created.
Well, that's a different statement, but that we agree with. But the question is to her knowledge as to whether there are any states that she's aware of that have a fund, whether it's $1 billion or not. Let's ask the question again, if you would, Mr. Moore.
Well, thank you very much, Mr. Chairman. I would like to, however, narrow it a little bit to her proxy group of companies, because her assessment of risk is done by comparison the proxy group of companies with with Rocky Mountain Power. Now, for example, I'm aware of a California fund for the payment of wildfires, but that fund is not applicable for two reasons. One, that because it is shareholder and ratepayer financed, where the Utah fund is purely ratepayer financed. And two, there are no proxy companies in California.
I understand, and thank you for that explanation, but let's ask her what she's aware of and her knowledge. I think that's where you were headed originally, correct?
That's correct.
Okay, let's go back to that. And Ms. Bulkley, if you can respond to what your knowledge is as you have the question.
Sure. So my knowledge on this is that this is a topic that is being discussed at regulatory commissions, primarily west, a little less in the northeast where I'm from, but this is a topic that is being discussed by regulatory commissions and, to some extent, legislatures across the region. So I don't know how many have actually signed legislation, and I don't know the process for every company and how far along they are in developing some kind of a fund, but as I noted in my testimony, this is in fact one of the most important issues for companies in states that are facing wildfire risk, and it is being discussed. I have testified in 50 cases in the last year, and the topic of wildfire risk has come up in the vast majority of those cases that are in the West.
Again, focusing on your proxy group, which I believe is the appropriate focus, you can't say that any member of your proxy group has a legislation, you can't say yes or no, has legislation that reflects the Utah legislation in terms of $1 billion financed fund for wildfires paid for by ratepayers. You don't know of another fund like that in your proxy group. And you don't know of members in your proxy group that have operated in jurisdictions where the type of damages in James' case are simply not allowed.
I can't speak to the details of any of the legislation and regulatory support that's being provided to the companies in the proxy group. The companies in the proxy group, however, do span across many regulatory jurisdictions that I have testified in. As I noted previously, the conversations are happening in those states.
I don't want to become a witness. I have done some research on this to establish that my point is in good faith, and also to protect myself from a very skilled and intelligent witness who may know that.
Well, yes, so we don't want you to testify. Obviously, we want you to ask the questions, and I'm wondering, I'm not trying to curtail your costs. Do you think this would be a good time to take a break? Do you have some, I mean,
I think this would be. I have three other areas.
okay,
of
you've got
investigation.
significant additional costs. Let's take our 2:30 break now, 2:35, and I'm going to ask that we be back at 2:45. We'll try to have a shorter break here. Okay, we're going back on the record. And I think we have counsel who wasn't here yesterday, and we'll let you enter your appearance.
My name is Stephen Snar. I'm an assistant attorney general, and I assist the office. I'm a colleague of Robert Moore's. I'm happy to be here to join in the events.
Thank you, Mr. Snar. It's great to have you here. Okay, are we?
Can we raise just one quick issue?
Yes.
Ms. Bulkley currently has a flight at 5:45. Based on the estimates we received, we thought we had plenty of time. My understanding is Mr. Moore has about at least, he thinks another half hour. I've conferred with the other parties. They don't have cross, but I'm sure the commission has questions. I don't want to hurry anybody up, but
You would need to leave by, your flight leaves at what time?
5:45. So she'd need to leave here about 3:40 is my guess to make that flight. And I don't want to hurt anybody, but I also don't want to have her pay $400 extra to change a flight unless we need to. But we're happy to.
Yeah, if we have to do that, we have to do it. But Mr. Moore, I want you to be able to answer your questions, but to the extent you can drill in and we can get it done in another 55 minutes, that'd be great. But no cross from our.
Mr. Chair,
Oh,
I do have a few minutes of cross.
okay, all right. Okay, so if you've got about 30 minutes,
I got about 30 minutes.
let's go then.
Let's see how we can do this. Do you want to talk about Mr. Graves and the ROE?
I think you're asking the questions.
Well, all right, let me, I
The
promise.
answer would be no if you're asking if she wants to talk about it. We can establish that.
Well, I asked because I believe you started to talk about it beforehand, and I told you I'd get to it, so I thought I'd get to it now. Also, you said that although you could not digest Mr. Graves' testimony as you sit here today, you are familiar with his testimony when he discusses the ROE, and this is a question, and you're ready to discuss that. Is that true?
At a general level, I can't say that I have memorized Mr. Graves' testimony or that I can recall without you citing to specific sections for me, just to be clear. I didn't help him in the preparation of it, so I am not very familiar with it.
Well, let's just go to your comments on it in your testimony.
Sure.
On page 103 of your rebuttal testimony, you stated that Dr. Woodridge is mistaken when he states that Mr. Graves is suggesting that wildfire damages should have no influence on the authorized ROE of a utility. Is that your position?
Yes, the second sentence describes why. The following sentence, I should say, describes why.
Let me read my questions out quickly enough, and then after I'm finished, maybe you'll have a chance to explain. That may move us along quicker.
Sure, that's fine.
And if you feel like that is prejudicing you, just change your approach.
Sure.
On the same page, that would be 103. Lines 2053 to 2057, you state, Mr. Graves notes his preference for a variety of ex ante and ex post cost recovery mechanisms that provide the necessary regulatory relief for costs due to wildfires. And this is the sentence I'm going to focus in on this series of questions. However, absent the existence of necessary cost recovery mechanisms, it is clear that the ROE should be adjusted meaningfully to offset the risks associated with wildfires. Did I read that correctly?
Yes.
That last line, however, the absence of the existence of a necessary cost recovery mechanism, it is clear that the ROE should be adjusted meaningful to offset risks with wildfires. Those are your words, I'm Mr. Graves, isn't that true?
Yes, that's correct. They're not in quotes.
In fact, it is my reading of Mr. Graves' testimony is that he never testified that absent the type of mechanism he proposed, an ROE should be adjusted meaningfully. Did
Well,
he?
Mr. Graves testifies that the wildfires are an asymmetric risk for utilities, which means that the only possible outcome is for losses. So asymmetric risk is typically addressed in the ROE.
Asymmetric risk is typically addressed in the ROE.
Yes.
Oh, I see. Could you look to page 25, line 498 to 99 of Mr. Graves' testimony?
I'm sorry, the page number?
25.
25.
To my, line 498-99, I'm going to read the sentence. To my mind, this is as close as Mr. Graves gets to recommending an ROE as an alternative to the cost mechanisms that he discussed in the rest of his testimony. Specifically, he states, an allowed ROE could be augmented in principle by a premium to customary measure the cost of capital to reflect asymmetric risk. That's your position, isn't it?
That's correct. That's what I just said.
Right. That's why I wanted to direct it into the record. However, the next lines of Mr. Graves' testimony provides that there are multiple problems with this approach, including that the proposed ROE premium would be both too large to be acceptable to regulators and customers and too small to cover the black swan events used in case of a catastrophic fire. That's paraphrased, that's not quoted. Would you agree with my construction of Mr. Graves' testimony for the rest of his?
Well, his testimony says this isn't his preferred approach, but it is one approach that could be used. So,
With the caveat that it'll be too small and too big at the same time. I mean, that's not an endorsement of an alternative approach to the cost mechanisms that he and Ms. Stewart discussed.
that's correct. Please note that I haven't recommended an adjustment to the ROE for wildfire risk. I've simply said that it is something that has to be considered in the overall risk of the company. And in fact, the company isn't even asking for any kind of adjustment to its ROE for business risk. It's simply asking for the same return that it was authorized in 2020 prior to any of the risks we've been talking about for the last hour. So whether there is, so in 2020, the company didn't have any concerns about wildfire risk, and they were offered a return of 9.65%. They were authorized a return of 9.65% from this commission. Since that time, we have wildfire risk and we have some amount of mitigation that everyone has been talking about for 2 days now. And whether or not the mitigation actually solves the incremental risk associated with wildfire, the company is still asking for the exact same return that they were authorized prior. Yet, as I discussed in my cost of capital study, interest rates have increased some 200 to 300 basis points, indicating that the market expects a higher cost of equity. So
Yeah, I
this
understand.
risk
I understand.
is
but
not
you-
actually factored in to the
This
analysis.
is not factored in, but it is relevant, isn't it, that Rocky Mountain Power had hired 2 experts that have one aspect of their testimony that intersects wildfire risk and ROE, and one expert says it shouldn't apply, and the other expert says it must.
No, I don't think that's true. I think Mr. Graves says it's not the ideal approach. There are better ways to handle this. There are, but to the extent that they do not get handled in that way, investors will expect a higher return. That's my position.
But
So Mr. Graves' testimony talks about other approaches for addressing wildfire risk, and I think those are very important for this commission to read and consider Mr. Graves' testimony.
And it coincides with Mrs. Stewart's testimony, doesn't it?
I believe that's true, but, so I think those should be read, and I think they should be considered. I think Mr. Graves makes great points about how that risk can be mitigated, but to the extent that it is not mitigated, it is uncertain, it is very certain to me that investors will consider wildfire a risk and will consider it in their decisions to invest and expect return for it.
And Mr. Graves' position.
Whether or not we measure it correctly is another issue.
Well, Mr. Graves' position is you can't measure it. I mean, he's dealing with an impossibility.
Well,
He
the
says this
entire ROE
let
is
me
actually
finish.
not measurable.
He's dealing with the impossibility of coming up with an ROE that is both too small, too big. There's not a valid ROE, according to Mr. Graves, there's not an approach you can use with an ROE that doesn't have that problem that is too large, but it's too small, and to fix a part that is too small for the catastrophic black swan event, you have to make it larger. But you can't make it larger because it's already too large. I mean, he's talking about maybe not an impossibility, but he's not really talking about an alternative, is he?
Mr. Graves provides very good examples for how to deal with wildfire risk that, again, I believe should be reviewed by the commission and considered. To the extent that there were to be no mitigation, the fact that you have difficulty measuring the required return does not mean it does not exist. In fact, this entire exercise is that we do not have the understanding with any precision of what the investor required return is, and that is why we consult multiple models and make estimates. So I think we're talking about, yes, there would be some variability, and it would be a very challenging thing to try to measure, which is why Mr. Graves suggests in his testimony other approaches that should be considered.
Mr. Moore, are you ready to?
I'm ready to move
Move on, okay. Questions that you're asking could be asked of Mr. Graves, so yes, if you're ready to move on, that'd be great.
I would like to turn to a central disagreement between you and Dr. Woodridge, and that is whether the Wall Street analysts and Value Line projected 3 to 5 year growth rates reflect investors' expected long-term earnings per share growth rate. Is this the issue of contention between you and Dr. Woolridge?
Dr. Woolridge also relies on relies on analysts' projected EPS growth rates in his analysis. And we both use a constant growth DCF model, so those growth rates are actually used by us both. Whether or not Dr. Woolridge uses them as published, maybe not, but he does place significant emphasis on the EPS growth rates of Wall Street analysts.
He does say in the direct testimony, page 93, that Ms. Buckley's average long-term S&P 500 ESP growth rate of 10.83% is grossly overstated and has little, if any, basis in economic reality.
I don't believe that's actually related to the DCF model. Can you refer me to that in his testimony? And we can look at that
93.
together.
Direct testimony.
Again, as I noted, this isn't with respect to his DCF analysis at all. This is with respect to the market return calculations that have been relied on in my CAPM analysis in order to estimate the market risk premium.
So, yes, but isn't part of that mathematical analysis coming up with a growth rate of your S&P 500 companies, which you use through the Wall Street analysis and Value Line of a amount of 10.83%?
Yes, that's correct, but as I noted, Dr. Woolridge actually relies on analyst EPS growth rates in the calculation of his DCF model. I can try to find that for you in his testimony if you'd like.
That's fine. Maybe your lawyer can do that. I'll redirect. I'm trying to hurry. What I want to do here is just analyze Dr. Wildridge's argument on your growth rate of 10.83%. And my questions will be attempted to focus on that, and we can get you out of here if you help me out. Now,
Well, I'd still like my responses to be complete before, I'm not looking to have an incomplete testimony in order to get on a plane.
Fair enough. Let's go as expeditiously as possible. You may miss your plane. We'll just see.
Now, Dr. Woodridge repeatedly states throughout his testimony that it is well known that Wall Street analysts on Value Line's 3 to 5 year ESP and projections are overly optimistic and upwardly biased. Is that a fair representation of Dr. Woodridge's testimony?
That is Dr. Woolridge's testimony. I don't agree with it, but that's Dr. Woolridge's testimony.
Right, and that's the controversy I initially raised. That's what Mr. Woodridge's position is, and you reject that position.
I do reject that position.
Okay. Now, on page 91 to 92 of Dr. Woolridge's direct testimony,
I'm there.
He performed an analysis of S&P 500 EPS and GDP growth rates, earnings per share growth rates, and gross domestic profit growth rates. And he used the average of projected GDP growth rates from a 2024 survey of financial forecasters, which was published by the Federal Reserve Bank of Philadelphia. That's in the footnote. Energy Information Administration, the Congressional Budget Office, and the Social Security Administration, and he arrived at an average of 4.15% of GDP growth rate. Isn't that correct?
That's correct.
In his analysis, Dr. Woodridge determined that in 2022, the S&P aggregate profits constitutes 6.11% of nominal GDP. Nominal GDP. Then, using the 4.15% growth rate estimate by the government agencies, he calculated how much GDP would grow from 2022 to 2050. Next, using your S&P 500 earnings per share growth rate of 10.83, he calculated how much the S&P 500 EPS would grow again from 2022 to 2050. Dr. Woodridge then determined that by 2050, the S&P 500 aggregate profit would increase from 6.11% nominal GDP in 2022 to 38.84% of nominal GDP in 2050.
That is his testimony. Yep.
Unless I missed it, you did not address this analysis in your rebuttal testimony.
I addressed this in concept in my rebuttal testimony. Yes, I did. So in my rebuttal testimony, I identified multiple sources that have relied on the same methodology that I've used. Starting at page 48, 49, 50, figure 12 in my rebuttal testimony looks at the Federal Reserve Bank of New York and their estimates of what the market risk premium is, which is what this analysis is being used for. So you're taking the growth rate, calculating a market return, and then estimating what the market risk premium is. And the Federal Reserve Bank of New York indicated that that the returns, that the market risk premium was in the same range as the market risk premium that I've been relying on in my testimony, a range of 7.74 to 8.02%.
Yes, that's part of the controversy I was mentioning. Do you have any dispute about his 4.15 estimate GDP growth of the government agencies, Social Security Administration, et cetera?
I haven't actually,
You don't have an
Reviewed-
opinion one way or the other?
I haven't reviewed this table, I've reviewed the end result. So this, I've reviewed the end result. What are the reasonable market return estimates? This table is a bunch of assumptions that go into the return on the overall market. And so my response to Dr. Woolridge is with respect to what the reasonable return is on the overall market. I've provided in my direct testimony 50 to 75 years of historical returns to demonstrate that my market return estimates that are used in my CAPM are within the range of more than 50% of the returns from 1926 to the present. And I have provided the studies that I referenced just previously from the Federal Reserve Bank of New York indicating that those return estimates and the market risk premium are reasonable. I have also provided cites on the pages I just indicated, 49 and 50, to regulatory commissions who have relied on the same methodology.
Yes. Do you dispute Dr. Woodward's contention that over the long term, corporate profits cannot grow at a substantially faster pace than GDP growth?
Yeah, so this is again a misunderstanding that we continue to have, Dr. Woolridge and I. We're using the S&P 500 as a measure of the overall market. The growth rates that come in and out, so you have different companies that come in and out of the overall market. This is an estimate of the market return over time. And so those growth rates will change over time, but the market return, as I indicated, based on the sources I just described, my market return estimate is basically on track with history and the Federal Reserve Bank of New York's publication.
I'm a little confused with all your authority. Is your authority saying that that earnings per share can go faster than the overall economy, or is that what your authority says?
Again, what I'm telling you is that the returns that are used in that calculation, the ultimate end return, market return, which is used in the CAPM to establish the market risk premium. If you look at figure 9 of my direct testimony, there are 100 years roughly of data here that demonstrate that the return that is used in my analysis is generally consistent with more than half of the years there. So the return, the growth rate by itself.
So you're saying it can't grow faster than the U.S. economy?
No, that's not what I'm saying. I'm saying the return that's used in the model is actually reasonable based on history.
I didn't ask you if the return in the model, I asked you if a point in that model that had the S&P 500 growing at 10.8%, 10.83%, is going to result in the S&P growing faster than the GDP and over a sustained period of time. There could be changes, I agree, and I think Professor Woolridge puts this in his documentations. There are differences and there's a short-term benefit, but over the long term, corporate profits cannot substantially outgrow GDP.
That is a true statement. However, I would note that Dr. Woolridge's own DCF model assumes a higher growth rate than his 4.15% GDP growth rate. So I think, that is a limitation that we have all been considering.
Okay. Now, if you agree that corporate profits cannot sustainably outgrow the economy, then you're in agreement with the following quote from Warren Buffett. Someone once told me that New York has more lawyers than people. I think that's the same fellow who thinks profits can become larger than the GDP. When you begin to expect growth of a component factor to forever outpace the aggregate, you get into certain mathematical problems. In my opinion, you have to be wildly optimistic to believe that corporate profits as a percent of the GDP can, for any sustainable period, hold much above 6%. From what you just said, you can correct me, but you're in agreement with that.
I haven't read the context of that entire document that that you're quoting from Mr. Buffett, so I'm not sure I have a whole lot to say about that quote.
It's been quoted in his direct and sir rebuttal testimony.
In whose direct and sir rebuttal testimony?
Professor Woolridge.
You could maybe provide the context, but I haven't read the article, so
Okay.
that's not helpful to me, that Dr. Woolridge has quoted it.
Well,
Again, as I noted, in my prior response, Dr. Woolridge's growth rates are well above GDP.
and yours are 2 to 3 times ahead of GDP.
Again, that's, first of all, not my DCF analysis that I'm using to set the cost of equity. It is the market return overall. And as I mentioned, I've looked at 5 different sources that put the market return right where history has provided and where the Federal Reserve of New York has indicated is the most consistent outcome.
All right, this is my last question. Is 10.83 a larger number than 4.15?
Yes, it is.
Okay. And to get you out of here, I'm just going to talk about some comparative ROEs, and I'm going to hand you what has been marked OCS Cross Exhibit number 7. OCS Cross Exhibit number 7 is the first page of a much larger exhibit that I had provided to the parties in your council last Thursday. That is basically a compilation of the ROEs you recommended in your direct testimony in cases that you have testified in for the past 5 years, which we received from a DR from you. And the compilation of the actual amount that was authorized in that case. At this point, I know the chairman likes to move for introduction before we get deep into the docket. Now, I would like to move to omit cross-exhibit 7, but I understand that there may be some objections to that because the foundation for the document is in a packet about this big. So what I was going to do is ask the commission and your lawyer, Mr. Sabin, if they would object if I just introduce Exhibit 7, which is the summary of the data.
Mr. Sabin, what do you think?
So I want to make sure, Robert, I have your cross exhibits up, but I don't have a number 7 in the.
Oh, I'm sorry. That's just the first page of number 7. I didn't. I mean, you have it because it's the top of number 7. It's the number 8 is the heavy, large compilation of data, and on top of number 8, there's a compilation.
Can you show it to Mr. Sabin? I can't seem to find it either, but I want Mr. Sabin to know what you're referring to. Have we already admitted that?
No.
It's been provided, but it has not been admitted.
Okay, all right.
I wanted to see if there was an objection first because.
So can I think this might help cut through this. I have OCS Cross Exhibit 8 that you shared with us. Are you saying that what you're wanting to do is create a new exhibit that would just be the first page of that document?
Yes, not the first page, the second page with the compilations.
Why do we need to
Could I
create a
walk-
new exhibit? Why don't we just use the document, the entire OCS 8, and just refer to the page and admit the whole document? Can't we do that?
Yes, we can do that, that's fine. I didn't want to burden the record if it wasn't necessary.
I think it's, the reason he's asking, it's 178 pages. I'm sure that's why he's asking.
I see.
So why don't, what I would suggest maybe is, if it's okay with you, Mr. Chair, is have him pass around what he's wanting to use. Let me just look at what he's given and see if I can,
Let's do that,
Makes sense
and
of
we
that.
can maybe expedite this. Let's do
Yeah.
that. You haven't given this to the commission yet, right?
Yet to give it to the commission.
Yeah, okay. We've been up here looking for it.
Here you, oh, thank you. Sure. And Mr. Saban, I have copies of the full thing if that would be helpful to you.
Sure, and while you're doing that, Ms. Caviglia, do you have any cross-examination of this witness? Captain George, do you have any?
I do not.
Okay, so just Ms. Hayes. Okay. Do you have any idea approximately how long your cross would be?
It will really depend. It's, I have three points I'm trying to get at.
Okay, all right. Well, you've got to do what is appropriate for your client. I'm starting to think that Ms. Bulkley is going to miss her flight.
I just have two questions.
Well, then there's still hope. Hope springs eternal. Go ahead. What about, what's
so
your response on
it looks like it is not the same, unfortunately, because this document, the OCS Exhibit 7, contains a column of data that is not in her. I think this is supposed to be a summary of requested versus authorized, but I don't think this is a summary of the other documentation, exactly. So, yeah, that's fine.
So this OCS Cross Exhibit 7 is part of that,
It's part of this is the compilation.
the 100 and some odd page thing that we were hoping to avoid.
That they've had for, since Thursday.
Are you saying, Mr. Saban, this is, Cross Exhibit 7 is different than the larger document?
No, I'm saying that what he's representing this to be is different than what is contained, or is not, maybe I'll let him ask Ms. Bulkley about this, because I think she can identify what's,
Is this page, the single page, within this larger
yes,
document?
it's
Okay.
within it, yes.
Okay,
yes.
all right, okay. Go ahead with your,
In the hope of getting you out, I will ask you questions while I'm handing this out.
can we move for,
It's okay, Robert, it's okay. I don't know that we're gonna make it, so don't worry about that.
yeah,
Maybe we'll ask the chair if we could take a break at some point to have her change her flight. That's all we'll need.
why don't we do that right now? If you're gonna change the flight, I don't think you're gonna.
No, and I don't wanna
And
make.
you may have questions from the commissioners. I don't have any questions.
And I don't
Mr.
want to short
Harvey may
you
have.
opportunities to talk to her, so,
Yeah.
yeah,
Let's take
if
a
we can just-
5-minute break. You can make whatever, I hope you can get another flight later today. No? Oh, I'm so sorry, but. Rocky Mountain Power, Ms. Bulkley, for rearranging their schedules. I know that's very inconvenient and often difficult to do, but thank you for doing that. Okay, we'll go back to Mr. Moore for continued cross-examination.
Ms. Buckley, I have been working on the assumption that you have seen this document before. Is that correct? I think the document pretty much speaks for itself, so I'm just going to ask you two questions. The first question is just to direct you to the top of the second page of the document, where it lists that the average of the ROEs recommended in your 5 years of testimony was 10.20%, and the average of ROEs actually awarded was 9.60%. Do you see that?
I do, but I think I need to understand what the column requested return on equity means before we draw any conclusions from this.
All right, yes.
Okay, go ahead, Mr. Moore.
Yes, that's the ROE in your initial filing in the testimony.
So that would be what the company requested,
That
is
would
what
be
you're
what the
asking.
company requested.
So not a recommendation made by me, then. I want to make sure that we have a distinction between what's in this column.
Well, it comes from your testimony, yes.
Okay, but as in this case, the recommended ROE is the company's request, not my recommendation. So I want to be clear what's in this column.
The column is the combination of the pages of your testimony when you initially made a recommendation in the case of your proposed ROE.
So, for example, this column does not represent necessarily my recommended ROE. And I can demonstrate that by looking at, well, this isn't really numbered. So let's count the pages.
I understand that you may have updated your ROE.
No, this
No?
is not, some of these are not my recommendation, and I think that's an important distinction. We can't go forward with this column of data without understanding what it is. So, for example, the Central Hudson case, which I can count the pages in a moment, but it specifically says the company has requested an ROE of 9.10, and that is some number of pages that I'll give you in here.
And just to note, that's about halfway down on cross-exhibit 7.
Yeah, so this is 10 pages in, and it is at line 10 on that page, well, 9 and 10. And so that is referenced on this, yeah, about halfway down the page, as you mentioned. And so that's the company's number. And so in many cases, I have provided a range of results, and companies have established their return recommendations, or their return requests, similar to this case. And so this list, just by looking at that one, I knew that this list did not represent necessarily all recommendations by me. I have not gone through every single one of them, but in many circumstances, the companies request an ROE versus me recommending one.
Just for a point of clarification while they're talking, if you look at Exhibit 7, for example, you see Utah and Pacific Corp, and you see a requested return of 10.2 and an authorized return, which we've been talking about in this case of 9.65. Is the 10.2 the company's requested return on equity in that case, or is that your recommendation? in
So I
the case?
believe that was the company's request in that case as well. And I found another one, this isn't numbered, but, so this is, Montana Dakota Utilities. Unfortunately, the direct testimony doesn't always have the docket numbers, so it's PU 23. Beyond that, we're on our own. So, this is a few down from the Central Hudson case, the 10-5. That is also the company's request. So there will be a number of these like that in this column.
All right, but it's true, isn't it, that whether it's a company request, and this can take you a while to check, but I believe this is correct, whether it's a company request that got into your first 2 pages of the testimony, because we did get your testimony through a DR from Rocky Mountain Power, so we're relying on your documents. But in only one of these cases is the ROE I think in only one of these cases, the ROE of, yes, at 10%, and the requested ROE is 10%, and the authorized ROE is 10%, and everything else you're higher than. Or
Well-
the company is higher than.
Your column of data, I haven't looked at the entire column to determine the higher or lower, but the column of data doesn't represent my recommendations, number one. I will say that I did look at the second column, which I validated against the S&P reports, and that column does appear to be the authorized returns for the companies on this page. There are 50 returns noted on this page. 27 of them are greater than 9.65, but only 10 of them are at Dr. Woolridge's recommendation or lower. And seven of them are at Mr. Coleman's recommendation or lower, and only one at Mr. Garrett's. That one, I think, is an important distinction because it is United Illuminating. It is in the top 5 or 6, and the 8.63% that was recommended there was actually a penalty assessed. The original ROE as a base was higher than that. So that's the information I can give you about this schedule.
Thank you. Can you tell me offhand when you last had an ROE that was below, that you recommended that was at or below the ROE that was actually authorized?
I'm sorry, I haven't done that research to know the answer to that question. I've looked at your table and I've given you the statistics I can out of that table, but I haven't come here prepared with that information.
When was your last, general rate case, before this case?
I've testified in 50 cases this year, so I don't know, actually,
You don't know
necessarily.
what the last time you were on the stand was?
The last time I was on the stand was a few weeks ago, but there wouldn't be a determination made in that case, so I wasn't understanding your question to be the last time I testified, but rather the last return that was determined by the commission. There's usually a lag there, so I couldn't tell you when the last order was issued.
And you can't tell me when the last order came out from a case that you testified in?
No, I wouldn't be able to tell you that. I did look at this data to determine settled cases versus litigated as well in the cases that you provided, and the vast, 28 of them were settled versus litigated, so that is another factor that's probably important to think about.
Well, the point I was trying to make with this exhibit and is simply that you have a tendency to be higher than the authorized ROEs. And Mr. Woolridge, Professor Woolridge, has a tendency to be lower than the authorized ROEs.
Well, that is not, this column of data doesn't help me determine that because it's not all my information. That's all I can say. I did give you the ranges that I evaluated from this set, and as I indicated, 10 of them are at Dr. Woolridge's number or lower, and 27 of them are at the company's request or higher.
Now, Dr. Woolridge, in his testimony, Dr. Woolridge spends a great deal of time discussing the fact that although his ROEs are below the authorized ROEs, that he points to studies and analysis indicating that for the past 40 years, ROEs have not declined with capital costs, therefore ROEs are overstated. So he has an analytical aspect of why his ROEs are below average. And you have not made, you don't know if your ROEs are routinely above or below the authorized ROEs. Is that what I hear you saying?
I haven't done the analysis that you're requesting. Much like Dr. Woolridge, however, I have presented analysis in my testimony to talk about where the cost of equity should be. That was discussed in my summary in the figures that I presented that summarize market conditions. Even Dr. Woolridge agrees that as interest rates increase, so does the ROE, the investor required return. That's actually, I believe I cited to his live testimony in a Connecticut case where he made that statement. And so if you go to figure 2 of my rebuttal testimony, the issue, as I see it here, is that the company was authorized a 9.65% ROE in 2020 when interest rates were at 1.34%. And at the time of my rebuttal, they were at 4.07. They're a little bit higher than that right now. So based on that analysis, it would suggest the cost of equity has increased. Taking just that piece, Dr. Woolridge would suggest that interest rates have increased and the cost of equity has increased. That's what he testified in Connecticut. And so therefore, I would say that the 9.65% the company is asking for is very reasonable.
I find it interesting that you can refer to Dr. Woolridge's testimony in Connecticut, but you have no idea whether your ROEs are generally above or below authorized ROEs.
I developed that cross-examination in Connecticut, and I'm well aware of the answer. I said I developed that cross-examination question and was waiting for the answer.
All right, let's just summarize this. You do not know whether you have a tendency to come in high over authorized ROEs, whether her recommended ROEs have a tendency to be higher than the authorized ROEs. That is beyond your knowledge.
As I'm saying, I haven't done the
I'm not
analysis.
finished. And therefore, you have not done any analysis that shows that the authorized ROEs are actually below capital costs and that the appropriate ROEs should be higher than the average ROEs. You'd have no reason to do that because you simply do not know, although you know Dr. Woolridge's testimony in Connecticut, you do not know if you have a tendency to be above or below the authorized ROEs. Is that correct?
I'm not sure that that analysis holds. So whether or not my ROEs are above or below the average that has been authorized is not particularly meaningful from one case to the next. What is meaningful is whether the return in the current case reflects what the market would expect. So if you're looking at the prior case and you see that interest rates were 275 basis points lower, you would expect the return to increase in the current market conditions. I think Dr. Woolridge also agrees that there is an inverse relationship with interest rates and ROEs. It is not a one-to-one relationship, but it does exist, and I think we're both in agreement on that.
Going back to my question, which I didn't ask about interest rates, I don't think you asked it. And my answer is, sitting here today, you do not have any idea whether you have a tendency to come in higher than the authorized ROEs.
I have not done your analysis. It's entirely likely that my recommendations are higher than the authorized ROE. By how much? I'm not really certain I can tell you. But by the same token, I think there is a give and take. So one of your examples here, which I would have to look to see, there are several actually, that I would have to look to see in Wisconsin, 10% was the recommendation, 9.8 is the authorized. I don't think that's so terrible.
No, but.
So I think it really depends on what you're looking at.
Still haven't asked my question.
I haven't done the work that you've asked for. That's what I can tell you. I think I've answered that 5 or 6 times now.
All right. I have no further questions.
Okay, thank you, Mr. Moore. We'll go to Ms. Hayes for cross-examination.
Thank you, Mr. Chair. Hello, Ms. Boakley. My name is Sophie Hayes, and I represent Western Resource Advocates. As you can see, I'm sitting almost immediately behind you. So if you decide that you would rather just face the commission, please feel free not to have to swivel your chair or your head.
I'll do my best.
Okay, thank you. So I just have a few questions about your surrebuttal testimony to clarify the record on a couple of points.
Sure.
Would you go with me to page 8 of your surrebuttal testimony? All right, I am starting at line 150.
Yes.
Mr. Lynn suggests that the commission abandon the cost of equity estimation models presented by all of the witnesses in this proceeding and ignore the recommendations offered by these witnesses that are based on those model results. Did I read that correctly?
Yes, you did.
Okay. I realize that you have already changed your flight, but in the general interest of time, I'm going to tell you where I'd like to go with this, and we can see if we can do this quickly. Sure. Are you willing to concede that that quote is your own characterization of Mr. Lynn's testimony rather than a direct representation of anything he said?
Yes, it would be in quotes if it was a direct representation of what you
Okay,
said.
thank you.
Sure.
Oh, sorry. Then, we did it the quick way. Then if I could lead you to your surrebuttal, I think the same page. Yeah, lines 152 to 155, you say, Mr. Lynn suggests that the commission adopt a 4-year phased-in reduction to RMP's ROE until the ROE is set at what he suggests is the investor-required return based on the work of academic researchers and projections of the long-term market return by financial institutions. Did I read that correctly?
Yes, you did.
All right. Once again, would you acknowledge that your quote is your own characterization of Mr. Lynn's testimony rather than a direct representation of anything he said?
Yes, and I've cited to the lines in his testimony that I am paraphrasing there.
Will you go to his testimony? It's his rebuttal testimony at page 2. And, or it starts at page 2. Will you just read what he says at the lines you cite?
Sure. Doesn't appear to be the correct citation, does it?
No.
I can try to find it for you if you'd like.
Sure, well, I think you.
Unaware that that was an error, so I apologize. I would, if I had seen that error, I would have corrected it as I started my testimony
All right.
today.
Well, those, you do reference the area where he summarizes his rebuttal testimony, but he does not recommend a 3 to 4 year phased-in reduction.
In his rebuttal, maybe this is a reference to his direct.
No, well, I can help you out here. He, in those lines that you reference, he describes his testimony as showing a longstanding gap between expected returns on equity as estimated by financial institutions and academic researchers, and the returns on equity that are awarded to regulated utilities. And his rebuttal testimony talks about the commission gradually closing that gap. So at his rebuttal, in his rebuttal testimony, I think page 6, lines 75 to 76, he says, I think a 3 to 4 year time frame to close the gap makes sense. Is that right?
Yep, that's correct.
Okay,
So
is
I
that what you
apologize.
were referring to?
It is, yes, I apologize, and I didn't, in reviewing my testimony, I didn't notice that error.
Well, thank you very much. All right, last place I want to talk to you about is your surrebuttal at lines 171 to 175. I will try and find what page number that is on. I didn't make a note of that.
Page 9.
9.
Oh, thank you. You say, as discussed in my response to Mr. Coleman, the Werner and Jarvis study evaluated authorized returns for regulated natural gas and electric utilities in the UK, and none of the witnesses in this proceeding have provided evidence that the regulatory environment in the UK and the US are similar. Did I read that correctly?
Yes.
All right. At this time, I would love to approach the witness with an exhibit that is marked as WRA Cross 1.
Please.
Thank you.
I do think Dr. Woolridge agreed with this point in his surrebuttal testimony as well.
Ms. Bulkley, is this study the study you were referring to?
Actually, this is a revised version of the study. I think the citations that I referred to in my rebuttal testimony and that have been discussed were the 2023 version of this. So the working paper as of 2023, but they may be similar. I just don't know.
Do you have any reason to believe that the topic of this paper changed between the 2023 and 2024 version?
I don't know. I can't say that this is the version I reviewed, so I won't be able to tell you if, it says rate of return regulation revisited, which is the same title, but I don't necessarily know that the findings and the topic therein are the same.
Would you agree that the copyright on this study is 2022?
Let me see.
Sorry, first page.
Oh. It is 2022. Yep. So I don't, it says revised September 2024, so I'm not sure how it can have a copyright of 22 and be revised as of 2024. That's foreign to me.
Yeah, it's described as a working paper. My assumption was it had something to do with that. But have you read this study, even if if you've read the 2023 version.
So I have read a 2023 version. Again, I just don't, I'm assuming that they would be similar, but they may not. If you describe it as a working paper, the definition of that is that it is working and evolving.
Yeah.
Right, so I don't really know, but.
All right, well, Mr. Lin linked to this in his direct and rebuttal testimonies, and that's what you were responding to in your surrebuttal, starting at page 8, I believe. Is that correct?
Well, I responded indicating that I had addressed it in response to other witnesses who were using the earlier study, right? So to be honest, I would say that I didn't appreciate the distinction in the update
All right.
provided. But we can see what we can do.
All right, I really am not trying to get into the meat of this study.
Sure.
So much as to just clarify that it is about utilities in the United States. So, in your review of this study, do you see that the authors have outlined their data assumptions and analytical methods?
You gonna help me out by telling me where that is?
Yeah, I am.
All right.
So, the page 1 is the introduction.
Yes.
Page 2 provides a background on electric utility regulation. Page 10, section 3, talks about data.
Yes, I see that at the bottom of page 10. Yep.
And then, section 4 begins on page 16 and talks about their empirical findings. And then I think starting around, starting after page 42 is the supplemental appendix that goes into further detail.
Okay.
Let me, one citation that might be helpful to you is at page 16. In section 4.1.1, they talk about benchmarking to the capital asset pricing model.
I think I'm on a different page 16. Hold on.
Oh dear. Oh yeah,
I think
because they start renumbering in the appendix. I apologize.
No, that's fine. That's fine. I wondered why I didn't see any sections. So, okay, so I'm at that page.
Okay, I don't have a question here necessarily, except did the authors of this study use the capital asset pricing model?
Yes.
To estimate returns on equity, and that's a similar. You also have used that model in your analysis. Is that correct?
Yes.
All right. Will you turn with me to page 13 of the primary study, not the appendix?
Sure.
And on page 13, figure 1 shows return on equity and financial indicators and is a graph.
Yep, I see that.
Would you read the first sentence under notes, under the graph?
Yep, it says, these figures show the approved return on equity for investor-owned U.S. electric and natural gas utilities.
Thank you.
Sure.
And then back on page 10, in the section about data, would you just review the first paragraph or so? I don't think you need to read it out loud.
The second portion in the supplement, is that where we are?
Sorry, no.
I'm sorry.
Page 10 of the main study,
Okay,
section 3,
Yep.
data,
got it.
and it starts to answer our research questions.
Yep.
And do you see that they discuss data from the Energy Information Administration and the Federal Energy Regulatory Commission?
I do, yep.
And those are United States agencies, is that correct?
They are, yep.
All right. And then on page 21, and I think actually they talk about this earlier as well, but on page 21 is where they describe their benchmarking to UK utilities.
Yes.
Is this benchmarking to UK utilities what you were referring to when you said this study was about UK utilities?
This benchmarking here, and if you look at table 3 on page 17, this is sort of looking at the UK market as well and trying to draw conclusions between the US and the UK without really being able to identify the differences in regulation between the UK and the US.
Yeah, and you're referring, I think, to that far right column in that
Right.
table?
Correct. Yep.
Yeah, and they do, let me have you read a sentence. I think back on 21, where they sort of address the fact that they are acknowledging differences between the US and the United Kingdom.
I think they acknowledge they exist, but they don't actually do anything quantitative with them.
All right.
So I think they recognize, so the study uses both, but then says, yeah, we understand there are differences between the UK and the US, but it doesn't go any further. And that's kind of one of the issues that I've raised with it. I've identified other issues as well with the study that are discussed in my rebuttal testimony.
But would you acknowledge that this study is about utilities in the United States?
Well, it's a comparison using UK data, so.
They do a number of types of benchmarking, is that right? The UK data being one of those?
Yes, but the returns are the UK data that they're benchmarking, right? So the part that's.
They benchmark to UK data as well as to capital asset pricing model approach, benchmarking to debt yields.
Right, so again, that's one of the issues that I raised, right, is that they assume sort of a one-to-one relationship between treasuries and ROEs, right? So that's one of the other points that I raised. So there were 3 or 4 points that I raised with respect to this study. That one issue was identified in the SIR rebuttal in response to Mr. Lin. However, I think in my rebuttal testimony, I've provided the full detail on pages 25 and 26 about the issues related to the study. And I think even Dr. Woolridge recognized that the comparisons between the UK and the US aren't appropriate in his I guess it was SIR rebuttal testimony.
All right.
Yeah.
But would you agree that the graph on page 3 is representative of investor-owned U.S. electric and natural gas utilities?
Yeah, that starting data is, it's just how the rest of the analysis unfolds, right?
All right.
So, but that's true. Yeah, that graph is definitely U.S. data.
Okay. Those are all of my questions.
Sure.
Just very briefly, while we're there with Mr. Lin, can you just go back to your, I think it was your SIR rebuttal. Yes, your phase 1 SIR rebuttal. And Ms. Hayes had you on page 8 of that SIR rebuttal. Could you go back to there?
Sure.
So I want to focus your attention on lines 156 to 158 first. And maybe just ask you, what do you understand Mr. Lin to be recommending?
Yeah, so my understanding of Mr. Lin's recommendation is that the commission should apply gradualism to eventually get to an ROE of 6.55% for Rocky Mountain Power.
Is that 6.55% based upon any any analysis he's conducted of the relevant and current market data?
I don't believe so. So, Mr. Lynn's testimony references a case, and testimony filed in that case, in a Duke Energy Progress case in North Carolina, where a Mr. Ellis filed testimony. And it appears to me that Mr. Lynn sort of borrowed the analysis from Mr. Ellis in that case and drew the same conclusions as Mr. Ellis.
So what is your reaction to his recommendation that a ROE of, eventually, of 6.5% would be appropriate?
Well, I have a lot of reactions.
I just want to object there because at no place in Mr. Lynn's testimony does he recommend an ROE of 6.5%. He points to data that shows costs of equity at that level for regulated utilities, but at no point does he recommend that as a stopping point.
Okay, Mr. Saban, can you point to something where he did recommend that?
Well, let me just ask you, Ms. Bulkley, we just read the sentence, or had you look at the sentence where you state that he suggests that the commission employ gradualism over a 4-year period to get to an ROE of 6.55%.
That's correct.
Is that your understanding of what he has testified to here?
Yes.
And do you have some place that you're referring to for that?
Yes. So the gradualism we found together, shall we say?
Yeah, sure.
In my rebuttal testimony, I inadvertently referred to the wrong pages on gradualism, but they should be the rebuttal testimony of Mr. Lynn at, I believe, lines 78 to 80, as I was corrected previously. 80. But the figure 2, which is referenced, figure 2 of Mr. Lynn's direct testimony is the analysis that I believe was presented in this Duke Energy case in the Carolinas. This is on page 25 of Mr. Lynn's direct testimony. And then on page 26, he states at 29, 30, 31, the general utility industry cost of equity according to the New York University Stern analysis in the latest 2024 issue is 6.55%, or 47.4% lower than Pacificor's current and requested ROE. So that's where I'm getting that number from.
Okay.
And I think, so I did review Mr. Lynn's testimony after reviewing Ms. Bulkley's rebuttal. I do have a quote that I think could be helpful that includes the number 6.55, but clarifies what his recommendation is, if you would like me to read that.
Please, you can read it.
All right. This is Lynn's rebuttal, page 7, line 93 to 99. At a minimum, the commission should note the cost of equity average for the entire market is 8.48% according to the NYU Stern analysis, while the cost of equity for utilities is 6.55%. I believe any observer of business risk would conclude a regulated utility is exposed to less risk than the average company in the economy, so the commission should view 8.48 as a reasonable upper limit of what a regulated utility's cost of equity could be. Approving an ROE around 8.8 would allow progress to be made toward a proper ROE while also exercising a strong degree of gradualism.
All right.
Do you have a question you want to ask about there? Do you have an objection or?
No, I think she was just reading that.
Okay, you're just reading that. You're back to your
I just
redirect
wanted
then.
to point to a place in Mr. Lynn's testimony where he
Okay.
made a recommendation
Okay.
and
Fine.
referenced that number.
Thank you.
So-
Back to you, Mr. Saban.
Yeah, Ms. Bulkley, do you understand the text that she just read as a recommendation by him that the amount that the lower boundary or the amount that the commission should end with is 8.48%?
No, I don't, actually. If you go to page 5 and 6 of his rebuttal testimony, at the bottom, starting at line 69 of page 5 and on to 80 line 80 of page 6. Well, I guess it's at 73, he says, I reference in my direct testimony, which calculates the utility cost of equity to be 6.55% compared to a total market average of 8.48. To practice a level of gradualism and avoid any knee-jerk reactions to market conditions, I think a 3 to 4 year time period to close the gap makes sense. And so based on that, I concluded that his intentions were to start at 8.48 and to go over a 4 year time period to 6.55%.
Okay, that's certainly your understanding.
That was my understanding of that testimony.
Now, back to my original question, which was either of those numbers, or starting at an 8.48 and moving down to a 6.55, what is your reaction to that? And just if you could explain that to the commission.
Sure. So I think in my direct and probably rebuttal testimony, I've referenced some cases for utilities over the last several years where returns in the 8.7 and 8.8 range have created significant changes in the overall value of the stock of the companies, have made it difficult for companies to access capital. I've referenced the Avangrid cases where Avangrid operates in multiple jurisdictions. They operate in New York, they operate in Connecticut, and they operate in Maine. And the Connecticut jurisdiction has had particularly challenging regulatory outcomes with ROEs in the high 8s. Avangrid went to issue debt for all of their companies separately. So Central Maine Power, separate from the Rochester Gas and Electric, NYSEG in New York, and the Connecticut companies, Connecticut Natural Gas and Southern Connecticut Gas. In that bond issuance, they had very difficult time actually filling the debt that they were putting out for Southern Connecticut Gas and CNG, and needed to increase their costs in order to do so because the regulation in Connecticut was perceived to be very high risk. So I think when you're talking about returns in the high 8s, we're seeing significant risk for companies in that range. If you're talking about the 6s, I can't even contemplate. There has never been a return in 40 years in the 6s. And in fact, in the Duke case, where the data was borrowed from for Mr. Lynn's analysis, the commission in that case rejected Mr. Ellis's position in that proceeding, considering, forget the actual language, but I can point you to that in my surrebuttal testimony. Actually, so he came up with a 6.25, and the commission concluded that witness Ellis's outcome of 6.25 is an outlier and should be ignored. Apart from being more than 300 basis points below any rate of return on equity ever approved by this commission for DEP, it is scarcely 200 basis points above DEP's embedded cost of debt, a premium that is clearly insufficient to compensate investors for the added risk associated with equity ownership relative to a debt holder's claim on the same enterprise.
What page were you reading from?
I'm sorry, this is page 10, and it's lines 195 to 201.
Thank you.
Sure.
Lastly, I just want to, you were asked by Mr. Moore about credit rating discussion in your testimony. And I'd just like to have you explain, why is it that you assessed or looked at credit rating feedback or information as part of what you did in your analysis?
Sure. So I do think it's important to look at credit ratings. I think it is a signal to the market. It's something that investors also consider. It's a demonstration of the ability to, the metrics that the credit rating agencies use are a demonstration of the company's ability to actually repay its debt obligations. That obviously is of interest to equity investors, since all of that debt has, advanced payment over equity. So I think it is important to recognize the risks that the credit rating agencies see. I don't think it's the end of the story when you're talking about equity. I think you have to think more broadly about the risks associated with equity beyond what the credit rating agencies are considering in terms of the coverage for debt.
And then Mr. Moore also asked you about the business risk assessment that you did. Can you explain to us why you looked at the business risks as part of your analysis?
So I think business risks are an important factor in evaluating in a cost of capital study. I can guarantee you if I didn't include a business risk section, somebody would have put my testimony in front of me. Oh, sorry. If I didn't include a business risk section in this case because the company was requesting a number that was at the low end of the range and I suddenly didn't think it was important, somebody would have put my testimony in front of me and said, this is a abnormality in your testimony, and we would have talked about business risk from that perspective. It is a part of the cost of capital study. I think it's an important factor to think about what the risks are for a company and to consider those risks in establishing where in the range of results the ROE should be. In this particular case, I think because the company is, as I mentioned earlier, because the company is basically requesting the same ROE that they were authorized in 2020 before any of the risks that we talked about earlier this afternoon existed or might be mitigated. And the market conditions have also moved to a higher cost of equity. I think the business risks are probably less of an issue in this case than they would be in a case where we were focused on, with respect to the setting the ROE, I think they're less of an issue because the company is not actually factoring them into their request.
In that respect, are you saying, relative to the 2020, if you look at the relative risks the company is exposed to now versus 2020 when 9.65 was approved, what is your assessment of the difference between the two periods?
The company does have greater risk than they did in 2020. It just hasn't been factored into the analysis with respect to the requested return. So again, we started at 965 without any of the discussion of risk that we've had over the last 2 days between Ms. Kablia and myself. And those risks are real, and there is a need to address them. There's a need for regulatory support to address those risks. But with respect to the return on equity, the company is, whether or not those risks are fully mitigated by any of the legislation or not, the fact of the matter is the company is still asking for the same ROE they had prior to that risk taking place. And then the important other factor is that the market has moved since then considerably, 270 some odd basis points higher on capital costs. Authorized ROEs have increased since that time period. So the market overall is recognizing the higher cost of equity. The authorized returns for vertically integrated utilities, at the time I filed my rebuttal testimony, the average was 982. At the time of the company's last case, I think it was 9.6. So there's been movement in the authorized ROEs as well. So I think the market, the investor required return is higher, but the company isn't requesting it.
Thank you, Ms. Bulkley. I have no further questions, Mr. Chair.
Thank you, Mr. Saban. Is there any recross from anybody? Seeing none, thank you, Ms. Bulkley, for your testimony, and I keep forgetting. I keep thinking if I move along, he'll forget to ask any questions, so. All right, we'll turn to Commissioner Harvey for his questions.
Figure the plane has flown anyway. Or it's going to fly soon. All right. I've got a number of areas. I think the very first one, though, is going to be a pretty simple thing just to clarify some data that was discussed earlier. The OCS Cross Exhibit 9 that had the,
yes.
You've got that? In response to the question that you received about the last two lines in these two tables, you explained that they couldn't mean what they were labeled as. Could you explain a little bit why that is the case?
Well, it's not possible in Excel to average letter grades that are issued by the credit rating agencies. There's a need to, in Excel works only in numbers. You can conduct, measures of central tendency on numerical data. You can't really conduct measures of central tendency on letter variables in Excel,
Well, not just in Excel, but
in any spreadsheet that I know of.
in any process, whether it's a spreadsheet or not, right?
Correct.
Okay. So if we have data that is what the statisticians refer to as nominal data, meaning it just identifies a category, that's like our lowest level. And then we go to ordinal, and these would be ordinal data, right?
Correct.
And they're not, the intervals between them are not the same. So for a measure of central tendency, they could do a mode,
That's correct. You
but
could
they
do a
couldn't
mode.
do a mean or a median.
That's correct.
That's correct, okay. I just wanted to make sure that my understanding that was correct. All right, more substantive stuff. As I mentioned with the previous witness, Pacificor has one shareholder.
Yes.
So when we think about the CAPM and the DCF and the various models that get used, they are premised on the idea that there's a market functioning out there that would be determining a cost of equity or an expected return on equity.
Yes, we typically rely on the standalone rate-making principle in estimating the cost of equity, yes.
Okay.
Oh, I'm sorry.
Am I close enough on mine? Okay.
Is that better? Oh, certainly is.
Yeah. See, you could have been a lot easier the whole time.
Little did I know. It's tough
All
to
right.
find out after 3 hours.
Okay, indeed. So in Pacificor's case, there is no share price that you can look to for changes to see what the effects are or what they have been in the past.
Correct.
Correct. And that's why we use proxy groups. Right?
Yes, that's
Okay.
correct.
So then going back to my earlier question about the nominal and the ordinal data, if I have a proxy group and the credit ratings are ordinal data, how does one go about comparing whether or not that proxy group is more risky, approximately the same risk, or approximately less risk?
Well, if you're only looking at the credit ratings, is your question, how would you average credit ratings? Is that the question?
Well, no, I'm saying if I'm using the proxy group because there is no share price for the company I'm interested in. There is
Right.
no way to actually observe what's required. All we can
Right.
do is say, we find a group of companies we think are similar, and there's potentially an infinite number of variables that might influence investors' perceptions of those companies. But how do we then say this proxy group really is a good proxy for this variable that we can't observe?
So I think each of the witnesses in this case tries to come up with a proxy group that is reasonably comparable using some screening criteria, one of which is credit rating, in order to at least have companies that are investment grade. So I won't say credit rating doesn't fit into the screening criteria to establish the group. Certainly there are different risks if you're not investment grade. So I think probably everybody that has presented their proxy group in this case has used that as a screening criterion. And then there are a variety of other criterion that are considered to get to that reasonable group. The analysis that I use considers how much of the company is regulated, whether it owns generation, is it part of a merger? Because typically the company is involved in a merger that can affect the stock price, which would be difficult to address in the DCF. It might not produce a true result. So there are various screening criteria that have been used to establish that group. Once you get to that group and you start running the models, the additional analysis that I've done is this business risk analysis to try to use qualitative information to figure out, once you've run all the models, where in the range does the company fall? And some of that analysis is taking ordinal data and trying to use a numerical ranking to average it. So some of the analyses that I've used in my direct testimony looks at how many of the proxy group companies have a capital cost recovery mechanism? How many, in my rebuttal testimony, I looked at how many companies in the proxy group have something like the EBA and tried to use that as a measure of whether or not the companies were generally comparable to Pacificor Rocky Mountain Power, just this portion of Pacificor, the Rocky Mountain Power regulated here in Utah. Does that answer the question?
I think so. I
Okay.
think so. All right, in your summary, or introductory remarks, whatever you want to call them, I think you mentioned 3 different types of business risk. A wildfire risk, the risk associated with capital investment recovery and regulatory environment. Are those is that a correct summary? Of what you
Yes, that's true.
All right. With respect to the wildfire risk, and I am absolutely aware we have a phase 3, but since it seems like this is the phrase that's been brought up almost constantly today with respect to return on equity, I think I have to talk about it a little bit. How, from a financial markets perspective, how is that how can that be factored in, or how did you try to factor it in? And I know you've talked about it today, but specifically, we talk about these huge potential liabilities that are, as was amended on the stand, would simply bankrupt the company if they're actually realized in the way they're talked about. So how does a quote unquote mythical investor that doesn't exist in Pacificor, how would they decide whether it was a good bet to buy any, if it was possible to buy shares of Pacificor, to buy it?
Sure. Well, so I think one of the issues is whether or not there is some kind of support for from the regulatory agencies. And, this happened in California as well, where the wildfire risk affected PG&E and SDG&E at the same time, right? And one wound up in bankruptcy, and the other was they established a fund, and they did not wind up in bankruptcy. But at the time, there were many cost of capital estimates, experts actually trying to estimate what that cost would be. And this is why Mr. Graves has said it's a very challenging process to figure out exactly what that return would look like, because people have tried to do it in California, and it's a very it's a very difficult thing to put a number on. But certainly the risk, if you have a choice as an investor of investing in 2 companies that have a 9.65% return, one of them has the potential risk associated with not wildfire, that costs that may not be recovered, and one that doesn't have those risks, it is inconceivable to me that investor would pick the one with the open-ended risk as opposed to the one who didn't, without some measure of the return associated with that. The question just becomes, how do you measure it? And that's the subject of Mr. Graves' testimony to some extent, and how to get around having to include it in the ROE, but rather to do it from a policy perspective so that it doesn't become an ROE topic. So that's why I think Mr. Graves' testimony is so important.
Indeed. I appreciate that you have an economics degree.
I do.
All right, I do as well. So you have 4 of them.
You've got 2 more than me then, so let's hope I can answer your question.
But one of the principles that is pounded into us in those classes is that most of economics is looking at an incremental change. And certainly when we think about the type of models we usually use in these hearings, it's an incremental approach. Would you agree with me or not?
I would agree with that.
Okay. So in terms of going back to wildfire, if you have, as has been mentioned many times today, an existential threat, can it really be analyzed with an incremental analysis?
In terms of measuring the cost of equity, that's where you're going. Mm-hmm. Yeah, so it becomes very challenging, as I just said, and I don't think there has been an analysis that has quantified that risk in a way that anyone feels is even close to accurate, I guess I would say. But it exists, and we know it exists, right? very difficult to measure, but that doesn't mean that it doesn't exist. It just means that we are having, it's so difficult to put a number on that people have chosen not to do that, right? Or cannot do that, and are choosing the policy route instead. Let us make sure that we have sufficient support so that we don't have to try to guess. You know, it's much like the entire cost of capital study, as I mentioned earlier. There is no observable investor required return. We do our best to understand what that is. And then we see examples like I described to you earlier of cases where the decisions have been in the 8.7%, as I mentioned, and the stock prices crash. Like, well, that wasn't it. You can clearly say that probably wasn't the right number. But, you know, so I think it falls into that same category, I would say.
All right. And then this question is not Pacificor specific, but I'm asking you to draw on your many years of experience as a consultant to the electrical utility industry. And that is, I'm curious, just in very broad terms, sort of what percentage of the utilities, and excluding, you know, things like municipalities and the co-ops, things like that, but, you know, just sort of investor-owned, how many of those are just solely owned subsidiaries of a holding company versus an actually publicly traded company?
It's changed over time quite a bit. So there are very,
They get gobbled up.
yeah, so,
I'm sorry, they get gobbled up. Sorry.
so in 1995, there were 98 publicly traded utility companies that were covered by Value Line. Today, there are 30, Value Line, sorry. Today, there are 37, soon to be 36, that are traded, that are covered by Value Line, but they're mostly holding companies. I would say the two closest to purely investor-owned utility, and they're not even purely investor-owned utility, but primarily would have been Otter Tail Power and Elite. And Elite is in the process of a merger as well. So there are very few that are only utility,
So almost none.
single utilities. They have, you know, many of the holding companies have those 95 or whatever have been consolidated over time.
Okay. So in that case where they are a wholly owned subsidiary, the only option for the quote-unquote one shareholder, if they want to sell, is to sell the entire company. To another hold.
In the Elite example, is that where you're referring
Well,
to?
I'm just saying,
Yes.
For any wholly owned subsidiary utility.
Yes, you would sell the entity, yes.
Okay. I think that's all I have. Thank you.
Sure.
Commissioner Clark, do you have any questions?
I don't have any questions. Thank you, Ms. Bulkley.
Sure.
Ms. Bulkley, I don't have any questions either. You may be excused. Thank you so much for your testimony today.
Thank you.
Okay, we'll take a couple of minutes and just talk about our schedule for the rest of the week. Before we do that, does anybody have anything they'd like to talk about from a procedural standpoint?
I do, Mr. Chairman. I do.
Okay.
And
Ms. Captain.
it is kind of related to scheduling, but not necessarily. I wanted to just kind of make an oral motion to request that our witness, Mr. Gorman, potentially testify telephonically or virtually. I talked to the rest of the parties. There's no cross expected for him. So with the commission's permission, if he could testify telephonically.
Is that correct, that there's no cross expected? Go ahead, Mr.
No,
Moore.
there is going to be some slight, I wouldn't call it cross. What we have to do is clean up an exhibit.
But are you willing to have that done with him making an appearance telephonically?
Yes.
Melissa, will it be video streamed? He'll be on, so it's not just telephonically, it's live
Virtually
stream.
is fine.
Virtually.
Yeah, that's fine.
Does anyone have any objection to that? When is he scheduled to testify?
Thursday.
Good luck. Okay, we're going to talk about trying to get back on track in just a minute here, but without objection, that motion is granted, Captain George.
Thank you.
Okay. Anything else that we need to talk about before we talk about schedule?
Your Honor,
Yeah, Mr. Kumar.
yes, excuse me. We, Utah LCG and Rocky Mountain Power filed a stipulation, I believe, this afternoon. The stipulation deals with some of the issues that had been raised solely by Utah LCG witness Mr. Dauphiné, and they're sort of limited to those issues. We have the substantive terms of that stipulation were circulated to the parties, I believe, last week. And so the parties seem to indicate that there was no objection to the stipulation, but
Would that then obviate the need for him to testify?
I think it will significantly, the company would no longer have any cross-examination for Mr. Dauphiné.
Okay, but he's still going to testify, but cross-examination will be truncated, it sounds like.
Well,
Maybe?
Well, and I think both Mr. Jones and Mr. Dauphiné will be testifying in support of the stipulation in order to provide the
Context.
record
Okay.
support for it. And then my understanding is that Utah LCG may be waiving some of their cross of some of the other company witnesses as a result of the stipulation.
Okay, and that's filed, it's now available to us, is that correct? Okay, well, we don't need it, oh, you've got it. Do we need to talk about it this afternoon, or can we talk about that tomorrow?
We can talk about it tomorrow.
All right, yeah, I haven't reviewed it yet, and have you reviewed it? Okay, we'll review it in the evening, this evening, and we can talk about it first thing with respect to the impact of that. But, having said that,
That's our modest contribution to try and expedite this proceeding, so.
Mr. Chair,
yes, Ms. King.
as you're reviewing that leisure reading in your spare time, we appreciate that and would appreciate giving consideration whether you would like to have Mr. Dauphiné testify or not. He would be traveling here specifically to do so.
When would he be traveling here?
He is scheduled to appear on the 16th, Monday, and we'd be happy to have him available. Currently, there's no cross reserved for him, and so it would purely be to aid the commission in its assessment of the stipulation, should it desire.
Now, I assume the division and the office have not entered into the stipulation. Is that correct? I think a lot of it's going to depend on whether you want him here and whether you have any cross-examination of the witness. But have you seen the stipulation,
Yes, we have, and the division does not object to it.
the office?
I haven't seen the stipulation
Okay,
yet.
we'll talk about it in the morning, and that'll give you plenty of time to change his flight arrangements, I think. Okay. Well, that's always appreciated. If, we can move this along, that's great. Now, I want to just talk about trying to get us back on track, because we have not even finished the day one anticipated witnesses, and we've now finished 2 days of hearing. So I'm going to, unless this works a hardship on anybody, we're going to try to go till 5 o'clock the next few days. I've looked at witness Wilding, Mitchell, Owen, Link, Vale, is it Her Street? Did I pronounce that?
Hem Street.
Hem Street, I'm sorry, I can't read my own writing. Wagner and Barrett. That takes us through most of Wednesday, and we have some witnesses that have 0 minutes down. I assume that means you're just planning on having them give their summary, and the other parties have not indicated they'll have any cross for those witnesses. So I have, that's not correct?
With the schedule being so short between the filing of Sir Rebuttal and the Friday filing of witness order and estimates on cross, the division, unfortunately, is still reviewing testimony and looking to see if it will have some cross for some witnesses who have not appeared yet. I do not anticipate much, if any, but I requested that, I believe, to have, to be noted in the cross-examination estimate filing that was made on Friday. I do not know if that was made, and it's possible that, and I would like to caveat the division zeros with that. I am working as fast as I can.
We're not going to preclude anyone from engaging in cross because there's a 0 on my sheet, okay?
Thank
I have
you.
a 0 for Wilding, for Owen, and for Wagner. And but as I calculate now, we have 4.5 hours if we try to get through all of those witnesses tomorrow. We probably won't do it, but that is 4.5 hours of scheduled time that the company anticipates, plus cross. So we have, for example, Vail has 40 minutes of cross scheduled. And so together, 270 minutes of testimony, which is 4.5 hours. We will go for 6 hours tomorrow instead of 5.5, because we'll go for 6.5 hours tomorrow instead of 5.5. And my objective would be to try to get through all those witnesses, assuming they are all available, which they should be because they were scheduled is there any problem with any of those witnesses, Rocky Mountain Power's witnesses?
Many of them are in the room today.
I'm not aware of any problems on our side.
Okay, so let's try to do that. I'm an eternal optimist, but I understand if I was a betting man, I would bet that we aren't going to be able to do that, but we're going to try to do as much of it as we can. And if there is cross-examination, we're going to allow that, obviously. And then first thing tomorrow morning, we'll talk about your stipulation after having read it, and then see what that does with respect to truncating other portions of the trial and witnesses, okay? All right, is there anything else you'd like to bring up before we adjourn for the evening?
Mr. Chairman, to the extent.
Yes, go ahead.
To the extent you feel it's necessary and at your pleasure, we were also prepared to go past 5 to get through witnesses faster.
I worry a little bit about, that's a very long day for a court reporter in my experience, so we want to be considerate of her. I mean, I guess we could do that if we took one more break in the afternoon, but let's try tomorrow to see where we are. I mean, we were going to end at 4 o'clock today. We're now 4:40, so if we go a little over 5, I think you can probably accommodate that, can't you? So we'll shoot to try to get as many of those witnesses finished tomorrow. That will get us almost back on track. Almost. Okay. All right. Okay, we're adjourned. Thank you so much, everybody.
Thank you.